952792. 2792. 92. 952792. ಏನು ಆಗಿದೆ ಲೈವ್
Any mentionings from video?
Lordship, list number 1,
Yes.
serial number 14, Your Lordship.
Yes.
In this matter, already settled, Your Lordship, before the magistrate. So I'll file the memo accordingly, Your Lordship. Give me 2
Make
days.
the mention when the matter reaches. Yes. Any other mentioning?
One more matter there, Your Lordship.
Yes,
Serial
please.
number 16, Your Lordship.
16.
I want to file the retirement memo because the party is not contacting me, only my client. So I want to.
Serial number?
Serial number 16, Your Lordship. In orders.
No, that I will see when the matter reaches. There is an explanation submitted by Registrar General. I would like to go through that. Yes.
Much obliged.
Is any other mentioning?
Serial number 10 Swami.
Matter reached. Next. Yes, memos from the left side. Yes, please. ಸಂತೋಷ ಹೋಗಿ ಬರ್ಲಿ ನಿಮ್ಮ ಕಕ್ಷಿದಾರು ಒಳಗೆ ಏನ್ ಮ್ಯಾಟರ್ 138 ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ
year number 1 month bail sentence suspend on bail matter year number 1 month for bail matter.
What is the offense?
Offense is 138. 138.
Yes, please. Mentioning. Yes.
My lord, the last week, my lord, I moved application under section 451 and 457 in respect of NDPS matter was rejected, my lord, and I had referred a criminal division bench before this honorable court. And the matter was referred to division bench, my lord, whether the drug disposal committee or the court have to entertain application under section.
Court has the jurisdiction.
Yes, and it was ordered, my lord. Thereafter, I filed a memo.
Order has been passed.
Yes, my lord.
On the same line.
In the last week, my lord, I mentioned the same and I moved a memo. It was listed yesterday. Same was not listed. Last week, I had moved a memo.
Move the memo.
I made a submission. And the court directed that the matter to be listed on Tuesday. But the matter was not listed yesterday.
Matter was not listed yesterday. Verify ಮಾಡಿ ನೋಡಿ. Verify ಮಾಡಿ ನೋಡಿ ಅವರು ಹೇಳ್ತಾರೆ ಸಬ್ಮಿಷನ್ ಸರಿ ಇದೆ ಅಂತಾರೆ ಶುಕ್ರವಾರ.
Yes, my lord. It's under 138. The petitioner deposited participation of the fine amount in the year 2019. I made an application for executive funds. I'm doing the memo.
Made an application for
Release of the fine amount deposit.
ಬರ್ತದೆ ಅರ್ಜೆನ್ಸಿ
ದಿನ ಆಗಿದೆ.
ಅಪ್ಲಿಕೇಶನ್ ಯಾವಾಗ ಹಾಕಿದ್ರಿ?
In the year 2020 ಅಲ್ಲಿ ಆಗ್ತಾ ಆಮೇಲೆ pandemic ನಿಂದ ಮೂವ್ ಮಾಡಲಿಕ್ಕೆ ಆಗಿಲ್ಲ.
ನೀವು 2 ವರ್ಷ ಸಾಕಷ್ಟು ಇತ್ತು.
Urgency ಇದೆ. More than 10 lakhs.
Yes. Yes, please speak.
My submission. Revision petition, my lord, this honorable court granted the bail matter. In meantime, 2 weeks time ಕೊಟ್ಟಿದ್ರು. In meantime ಅಲ್ಲಿ ಕಮ್ಮಿ ನಮಗೆ ಕಾಪಿ ರಿಸೀವ್ ಆಗಲಿಲ್ಲ. ಎಕ್ಸ್ಟೆನ್ಷನ್ ಟೈಮ್.
ನೀವು ಯಾಕೆ ರಿಜಿಸ್ಟರ್ ಹೇಳಿಲ್ಲ? ವಕೀಲರ ಆಫೀಸಿಗೆ ಹೋಗಿ ಕಾಪಿ
ಅಲ್ಲ ಫೈಲ್ ಬೇಡ ಯಾಕಂದ್ರೆ ಕಂಟಿನ್ಯೂಸ್ ಆಗಿ
ಏನ್ ಹೇಳ್ತಿದ್ದೀರಿ ನೀವು?
ಅಲ್ಲ ಸ್ವಾಮಿ ಯಾಕಂದ್ರೆ
ಅದು ಯಾರ ಕೋರ್ಟಿನಲ್ಲಿ? ನನ್ನ ಕೋರ್ಟಿನಲ್ಲಿ provided same the
before the vacation my lord HP ಸಂದೇಶ್ my lord 2 weeks ಏನಂತ 2 weeks grant ಆಗಿತ್ತು ಬಟ್ ನಮಗೆ
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳಿದ್ದೀವಿ ಗುರುವಾರ ತಗೊಳ್ಳಿ. Yes, next
138 matter.
Yes, please.
They are seeking suspension of sentence. They are ready to deposit of 50% amount.
Yes,
Office subjection is already come.
138 minute criminal division petition, fresh matter minute. Both courts has convicted minute filed.
Yes, next.
138 they were granted. Deposit 50% amount. Time ಮಾಡಕ್ಕಾಗಿಲ್ಲ ಈಗ ಡಿಡಿನೂ ರೆಡಿ ಆಗಿದೆ.
Yes. Mention 52.
Case number 9.
Serial number 52. Yes. The request of the learned counsel for the petitioner. A week's time as spread is granted. Yes.
Number 35, my lord.
35.
For the petitioner, my lord.
Yes.
Respondent.
Yes.
38
Yes.
settlement of 2 weeks.
ಮೀಡಿಯೇಷನ್ ಅಲ್ಲಿ ಆಯ್ತಾ ಅದು?
ಇಲ್ಲ ಮೀಡಿಯೇಷನ್ ಏನಾಯ್ತು ಅಂದ್ರೆ ಯಾವ ಬಿಲ್ ಬರ್ಲಿಲ್ಲ, ಇಮಿಡಿಯೇಟ್ ವಾಪಸ್ ಮಾಡಿ.
The counsel from both sides reiterating their previous submission that settlement process is still going on. Press time once again. However, the matter, though referred for mediation once, could not be settled. Still, considering their submission as a final last chance, 10 days time is granted either to report settlement or to proceed further in the matter. Yes.
Serial 26, my lord.
Interim order extension matter reach other.
Serial number 26, my lord.
26. Yes.
I am for the petitioner.
Yes.
On 38 proceedings.
Yes.
50% deposit ಮಾಡಿದ್ದೇವೆ.
Yes.
Negotiation ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ದೇನೆ.
Yes.
ಒಂದು 2 ವಾರ ಟೈಮ್ ಕೊಡಿ. I have continue argue, otherwise I will argue.
Who appears for respondent? Mr. Tumbugi. And counsel for the petitioner submits that petitioner is trying to settle the matter with the respondent.
Your respondent advocate ಬಂದಿದ್ದಾರೆ.
ಏನಾದ್ರು ಪ್ರಪೋಸಲ್ ಬಂದಿದೆ ಏನ್ರಿ?
ನಾನು ಹೇಳ್ತೇನೆ, ಪ್ರಪೋಸಲ್ ಕೊಟ್ಟಿದ್ದೇನೆ, ಇವತ್ತು ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ದೇನೆ.
And counsel from both sides present and submit that the settlement process is going on between the parties. As is pray for 10 days time to report the settlement or to proceed further in the matter. Time as paid is granted. Yes.
Any date may be fixed, man. ಅದಕ್ಕೂ ರೆಡಿ ಇದೆ.
Is the matter on 16/6.
16 ವಾರ. Please.
Report the settlement or to proceed further in the matter. Yes. 30? 36. Yes, please. Yes. Scenery is out of the frame. Request of the learned counsel for the petitioner. A week's time as paid is granted. Yes.
Serial number 30, my lord.
30. Yes.
Appearing for petitioner.
Yes.
Yes, 1 week time.
Yes. Same order. Yes. Yes, please. Yes. Yes. What is the stage? What is the stage of the matter? Or which stage you want that matter to be posted? Order, submission, IA, hearing, being spoken to. Yes, please. No, you have to ascertain that. If it were to be for final hearing, the seniority would come after 15 days, 2016 matter. Now we are in up to 2013. Yes. After tomorrow. Yes. Next week. Yes. 51. Yes.
Short accommodation.
At the request of the learned counsel for the petitioner, as finally a week's time as spread is granted. Yes. Call the matters.
Order on completion of office subjections first time. Till one, V.V. Krishnappa. This matter, but I have filed NOC wakalat in this matter. It has to be shown, my lord. I pray for a week's time to comply with the office objections.
Where did you move the memo?
Matter after filing of wakalat, it is not posted before the honorable court at all, my lord. And I asked them for compliance. They directed me to move a memo before the honorable court. Since it was filed in
You are ready to comply the office objection, but the registry asked you to move the memo, na?
no, not like that, my lord.
Then
Since the compliance period was over, I moved the memo. But I have filed NOC wakalat in this case on February 19th, my lord. That was also not put up along with the file.
my question is that, do you mean to say that after 6 weeks, registry refuses to permit you to comply office objection?
Generally, my lord. Generally, that is the thing. After 42 days.
Who is the in charge? Call the registrar to my chamber at 1:30 p.m. 2:30.
Please.
File kalsi. Learned counsel for the revision petitioner physically presented submits that though he has filed no objection Wakala more than a year back and was ready. Who's the Vakil Nirmay Kusti B.V. Krishnappa?
B.V. Krishnappa. B.V. Krishnappa.
ಹೋದ್ರು ಅವ್ರು ಬಂದ್ರೆ ಮತ್ತೆ ಕರೆಸಿ ಓಪನ್ ಇಟ್ಟಿರಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್
Serial number 2, Basaraju TA.
None after 1 week time is granted to come to office.
Number 3, D.K. Chandrasekhar.
There's a week's time in this matter.
Same order 1 week.
Second time, conference. Number 4, Sundaraju.
Finally 1 week. Yes. 1 week.
Conference third time. Number 11, Shivaji. Aponi.
14, I appear for the petitioner, Your Lordship.
Number 11.
This matter already settled, Your Lordship. I'll file the memo, Your Lordship, to withdraw the petition, Lordship.
Don't make mention in some other matter. Ascertain which matter is called.
Serial number 14, Lordship.
Serial number 11.
The request of the learned counsel for the petitioner as a final opportunity, 1 week time is granted, making it clear that in case the office subjections are not completed in a week, the court may take the cause appropriate, including dismissal of petition. Yes.
Serial number 12, Firoz Nizam.
1 week time.
Same order.
Serial number 13, Prasanna Kumar.
Same order. 1 week finally.
Number 14, A. John Vasco. 14.
For petition, Lordship.
Yes.
Already the matter has been settled. Hence, I'll file the memo to dispose the matter, Your Lordship.
You can file it right now. I will pass over the matter.
It is not possible today, Your Lordship. By tomorrow, I'll file the memo, Your Lordship.
The counsel for the petition appearing through video conference submits that since the matter has been settled between the parties amicably, who would not press the revision petition as such, he is filing a memo to that effect, for which he prays for a day's accommodation.
Lordship.
Finish the matter on 3/6. Yes.
What matter? Serial number 15, M. Vinay Kirti, SCGP correspondent.
For respondent, my lord.
Connect.
Police? ಮೈಕ್ರೋಫೋನ್ಗಳು ನೀವು ಶೋಗೆ ಇಟ್ಟಿದ್ದೀರಾ ಯಾವ್ದಕ್ಕೆ ಇಟ್ಟಿದ್ದೀರಿ?
My lord, the concerned my lord, SHO is present, my lord. My lord, he has, my lord, he tried his level best, my lord, to my lord, trace to my lord, the accuser, my lord. He has, my lord, went to my lord, the house of the my lord, petitioner, my lord. Earlier, my lord, he is having, my lord, he is a heavy drunkard, and moreover, my lord, he is a AIDS patient, my lord.
Who? SHO or the accused?
Accused, my lord. He also, my lord, patient of, my lord.
No, he put his maximum effort. He went to his house earlier. He was ಅಂತಿದ್ದೀರಿ. ನನಗೆ ಅದು ಎಲ್ಲಿ ಎಲ್ಲಿ ಕಮ
ಶಾರ್ಟ್ ಆಗಿ ಹೇಳಿದ್ರೆ ಅದಕ್ಕೆ ಇಮಿಡಿಯೇಟ್
ಎರಡು ಸತ್ಯ ಆಗುವ ಸಾಧ್ಯತೆ ಇದೆ.
ಅವನು ಏನ್ ಮಾಡಿದಾನೆ, ವಿಪರೀತ ಕುಡಿತಾ ಇದ್ದ, ಆಮೇಲೆ ಅವನು ಏಡ್ಸ್ ಪೇಷಂಟ್ ಬೇರೆ ಸ್ವಾಮಿ, ಅವನು ಸಾಲ ಬೇರೆ ಮಾಡಿದ್ದ, ಸ್ವಂತ ಮನೆನ ಮಾಡಿ ಈಗ ಅವರ ಫ್ಯಾಮಿಲಿ ಅವರು ಬಾಡಿಗೆ ಮನೇಲಿದ್ದಾರೆ, ಅವ್ರ ಸ್ವಂತ ಮನೆ ಮಾರ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅವ್ರೀಗ ಲಾಸ್ಟ್ ಫ್ಯಾಮಿಲಿ ಅವ್ರ ಪ್ರಕಾರ 15/2/2021 ಮನೆ ಬಿಟ್ಟವನು, ಆಮೇಲೆ ಎಲ್ಲ ಬಂದಿಲ್ಲ. ಆಮೇಲೆ ಅವರು ಕನ್ಸರ್ನ್ ಹಾಸ್ಪಿಟಲ್
ಮಿಸ್ಸಿಂಗ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಫ್ಯಾಮಿಲಿ.
ಮಿಸ್ಸಿಂಗ್ ಅವ್ರು ಇನ್ನೂ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ 12/2 ಅಂದ್ರೆ HIV ಪೇಷಂಟ್ ಅಂತ ಅವರು ಬಿಟ್ಬಿಟ್ಟಿದಾರಂತೆ, ಫ್ಯಾಮಿಲಿ ಅವರೇ ಬಿಟ್ಬಿಟ್ಟಿದಾರಂತೆ. ಸೊ 15/2/21 ಅವನು ಮನೆ ಬಿಟ್ಟವನು ಇಷ್ಟವರೆಗೆ ನಾಪತ್ತೆ ಆಗಿದ್ದಾರೆ. ಆಮೇಲೆ ಹಾಸ್ಪಿಟ್ಲಿಗೆ ಕನ್ಸರ್ನ್ ಅವನು HIV ಪೇಷಂಟ್ ಹೌದಾ ಅಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಕನ್ಸರ್ನ್ ಹಾಸ್ಪಿಟ್ಲಿಗೆ ಹೋಗಿ ಕನ್ಸರ್ನ್ ಮಾಡಿ.
ಯಾವಾಗ ಮನೆ ಬಿಟ್ಟಿದ್ದ?
15/2/2021 ಮನೆ ಬಿಟ್ಟು ಹೋಗಿದ್ದಾನೆ. ಹೌದು,
ನಾಪತ್ತೆ.
ಹೌದು. ಆಮೇಲೆ 11/1/2021 ಅವನು ಲಾಸ್ಟ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಗವರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟಲ್ ವೈಟ್ ಫೀಲ್ಡ್ ಹೊಸಕೋಟೆಯಲ್ಲಿ ತಗೊಂಡಿದ್ದಾನೆ. ಅಲ್ಲಿ ಅವನು HIV ಪೇಷಂಟ್ ಅಂತ ಹೌದು ಅಂತ ಅವರು ಡಾಕ್ಟರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಮೇಲೆ ಅಲ್ಲಿಂದ ಮನೆ ಬಿಟ್ಟು ಹೋದವನು ಇಷ್ಟವರೆಗೆ ಅವನು ಎಲ್ಲೂ ಇವನ್ ಅವನ ಫಿಂಗರ್ ಪ್ರಿಂಟ್ ಸಮೇತ ಎಲ್ಲ ಕಡೆ ಎಲ್ಲರೂ ಬೇರೆ ಅಫೆನ್ಸ್ ಆಗಿದೆ ಅಂತ ಸರ್ಚ್ ಮಾಡಿದ್ದಾರೆ, ಅದು ಕೂಡ ಅವನು ಎಲ್ಲೂ ಮಾಡಿಲ್ಲ. ಆಮೇಲೆ ನಾವು ಅಫೆನ್ಸೇ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಇವನ್ ಮಿಲೋಡ್ ಅವರಿಗೆ ಆಕ್ಚುಲಿ ಇದು ಇನ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು ತುರುವೇಕೆರೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಲಿಮಿಟ್ಸ್ ಅಲ್ಲಿ, ಅಲ್ಲೂ ಕೂಡ ಅವರು ಫೋನ್ ಮಾಡಿ ಕೇಳಿದ್ದಾರೆ. ಅಲ್ಲೂ ಕೂಡ ಅವನು
Actually, that your client will be present on the next date of hearing.
Lordship, we are not unable to. ಅವ್ನು ಬಂದಲ್ಲ 4-5 ವರ್ಷ ಆಗಿದೆ ಆಫೀಸ್ ಸೀನಿಯರ್ ನ ಕೇಳಿದೆ 5 ವರ್ಷದಿಂದ ಬರ್ತಾ ಇಲ್ಲ ಆಫೀಸ್ ಕಡೆನು ಅಂತ ಹೇಳಿದ್ರು.
ಅವರು ತುಂಬಾ ನಿನ್ನೆ ರಾತ್ರಿ ಕೂಡ ಮತ್ತೆ ಹೋಗಿದಾರಂತ ಮನೆಗೆ, ಅವ್ರಿಗೆ ಗೊತ್ತಾಗದೆ ಅಲ್ಲೂ ಹೋಗಲು ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಕೂಡ ಗೊತ್ತಾಗದೆ ಮನೆಗೆ ಇನ್ನೊಂದ್ಸಲ ಅವರು ರೆಂಟೆಡ್ ಮನೆಗೆ ಹೋಗಿ ನೋಡಿದ್ದಾರೆ, ಅಲ್ಲೂ ಇಲ್ಲ. ಲಾಸ್ಟ್ ಒಂದಾದ್ರೂ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ ಹೇಳಿದ್ದೇನೆ. ಅದು
The counsel from both sides physically present. The SCGP submits that despite the maximum effort put by the police, the whereabouts of the present petitioner was not traced. Though his family members could be traced the address, but even according to the family members, since the year 2021, the accused has left the home, abandoning the family, and his whereabouts are not known. SCGP further submits that even according to the police, according to the respondent police, even the family members also have lost the hope of tracing the accused. Making the said submission, he prays for reissuance of non-bailable warrant to continue the effort in tracing the accused. Counsel for the petitioner also submits that they too don't have any details about the whereabouts of the petitioner. And since 5 years, the petitioner has not come in their contact despite their effort. They also pray for securing the petitioner by appropriate means, including coercive means. In the light of the above submission, reissue non-bailable warrant returnable by 26.
ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ರಿ ಅಕ್ಯೂಸ್
both side present ಆದ್ರ ಮೇಲೆ for ಹೆಸರು designation as identified by learned SCGP is physically present. Upon instruction, learned SCGP submits that. ಅಂತ ಬರ್ಲಿ ಮುಂದೆಂದು ಮನೆ ಬಿಟ್ಟು ಹೋಗಿದ್ದಾನೆ. ಆ ಹೆವಿ ಡ್ರಂಕರ್ ಅನ್ನ ಸೇರಿಸಿಲ್ಲ ನಾನು, ಅವಶ್ಯಕತೆ ಇಲ್ಲ ಅಲ್ಲ.
ಅಲ್ಲ ಕೊಟ್ಟು ಅವನು ಸ್ವಂತ ಮನೆನ ಮಾರಿದಾನಂತೆ, ಸಾಲ ಎಲ್ಲ ಮಾಡ್ಬೋದು.
26 ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲೂ ಸೇಮ್ ಅಕ್ಯೂಸ್ಡ್ ಏನ್ರಿ? ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲೂ ಸೇಮ್ ಪಿಟಿಷನ್ ಅದ. ಕೊಡ್ರಿ ಆ ಪಿಟಿಷನ್ ಕೊಡಿ, ಪಿಟಿಷನ್ ಕೊಡಿ ಒರಿಜಿನಲ್.
ಅದರಲ್ಲೆಲ್ಲ ಆಲ್ರೆಡಿ ಡಿಸ್ಪ್ಯೂಟ್
ಅದರಲ್ಲೂ
Serial number 16, A. John Bosco. Serial number 16, A. John Bosco.
Detailed circulation. Petitioner not present. And appear in the matter either physically or through video conference. Peruse the submission of the learned registrar general. The same is placed on in the file. The same is placed on record. Taken on record. Next line. The learned counsels from both sides to submit regarding the availability of the copies of the records with them. Sessions court records with them to enable to build up the sessions court record. TCR EDL library. TCR EDL. List the matter in the next week. Yes. Next week, but list the matter on. Matter on 3/6. Yes.
Cell number 17, M. Subramani.
Not clear. The delayed payment of PF, etc., be accepted by the registry. The delayed payment of PF made in this matter be accepted by the registry and proceeded further. Yes.
Cell number 18, MJ Alva.
Counsel for the petitioner submits it to the registry to verify process.
Hearing on epileptic application. Serial number 90.
For respondent here, I made two applications. One is for the limitation, another is for the restoration.
Who appears for the wife? Whether all alleged arrears, if any, have all been paid to you?
Yes, that's as per the order of this honorable court, 50% is paid.
Paid. Up to date.
50% to be.
No, up to December 22nd, ನಾನು ಪೇ ಮಾಡಿದ್ದೀನಿ sir. ಹೌದು 50% whatever is ordered by this court in advance.
Do you have any objection in allowing the application on costs? The counsel from both sides present. The counsel for the respondent makes his oral submission on IA 1 and 2 of 2022. Peruse both the IAs filed under so and so for so and so. Considering the reason shown in 2 or 22. Considering the reason shown in the affidavits accompanying both the IAs and also the nature of the litigation, I am of the view that making it mandatory petitioner to proceed with the main matter without taking any further adjournment, and also imposing cost for the inconvenience caused to the respondent, both the IAs be allowed in the best interest of justice. Accordingly, both IA 1 and 2 of 2022 are allowed at a cost of ₹5,000 payable by the petitioner to the respondent by depositing the same in the registry of this court within 10 days from today and filing a complaints memo along with the receipt in the registry within the set period, comma, the delay of 82 days in filing IA 1/22 is condoned, and the order dated 8/10/2021 dismissing the petition for non-prosecution is recalled and the revision petition is restored on the file. Is the matter on?
The trial court, I mean, records has been already sent to the trial court. That's recalled for your lordship.
Meantime, registry to from which court it is required to come?
Second traffic court, your lordship.
Local.
Yeah.
In the meantime, the registry to call for the trial court record on urgent basis by hand. Please this matter.
I may be permitted to pay 50% of the amount whatever ordered by your lordship.
That you are required to.
Your lordship?
That you are required to continue to pay.
Yes, if that is odd, because they are seeking entire amount in the trial court in the miscellaneous case, your lordship.
On 16th, we are going to hear the matter finally. In the meantime, up to May end, what are the due of 5 months you are required to pay?
ಅಲ್ಲ ಡಿಸೆಂಬರ್ ನಾನು ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ ಸಮಯ 22nd ಡಿಸೆಂಬರ್ ವರೆಗೂ ನಾನು ಪೇ ಮಾಡಿದ್ದೀನಿ. I have already paid.
22nd December.
December.
So you are sure of getting the matter urgent till?
ಇಲ್ಲ ಸಮಯ I am not seeking any adjournment. ಇಲ್ಲ ಸಮಯ.
I didn't know this calculation also works.
ಇಲ್ಲ ಸಮಯ I am not seeking any adjournment.
16/6 ಬರ್ತದೆ argument ಮಾಡಿ.
Macho.
Number 20, Suyog Herade, SCGP for R1, Latif B for proposed R2.
For the petitioners. My objection. I have filed my formal objection to the pleading application.
Who is for impleading applicant?
The complainant and the brother of he is
You are for impleading applicant.
yes, that is the prosecution and filed. Who is the brother of the deceased?
Impugned order is at which page?
Page 56.
56. Application. Were you the complainant in the case? Were you the complainant in the?
I am the complainant.
Both of you have got anything to add more than what you have stated in your application, the objection? Yes, take them. Learned counsels from both sides, including the learned counsel for the applicant, are physically present. Heard both sides on IA. One of 21. Filed by an including applicant under section 301. That is section 24(8) of the Code of Criminal Procedure 1973. Seeking is impeding as respondent number 2 in the matter. Next line. The present petition is filed by accused number 1, 2, and 7 to 12 in the sessions 4, against whom the charge sheet has been filed for the offences punishable under sections 449, 302, 504, 201, 120B, 109, 212, read with section 34 of IPC. Of IPC. The present petitioners apostrophe is yes apostrophe. The present petitioner's application under section 227 CRPC came to be rejected by the Second Judge's Court by the impugned order dated so and so. It is challenging the said order. Those accused have preferred this revision petition. During the pendency of this petition, the original complainant in the criminal case has filed the present application, wherein he has stated that he, being the brother of the deceased, is the victim, and as such he needs to assist in the matter. Therefore, his impleading is requested. The petitioners have filed their detailed statement of objection, contending that it is the state which is the guardian of all the cases, and it is for the state to guard the interest of the victim party also. As such, the proposed respondent number 2, as such, the application of the applicant need not be entertained. We need to support. In their support, the petitioners have also relied upon a judgment of Honorable Apex Court in Thakur Ram and others versus State of Bihar, reported in 1966 to SCR 740. Learned counsel from both sides reiterate. Learned counsel for the applicant and the petitioner reiterate the contents of their application and statement of objection in their argument also. But HCGP submits that he would leave the matter to the discretion of the court, since permitting the complainant to be imputed as respondent is exclusively to the discretion of the court. Next line. According to the applicant, this is said to be his own brother, who is said to have been, who is alleged to have been murdered in the alleged incident. The present petitioners saw few among the accused who have been charge sheeted by the investigating agency for the alleged offences mentioned above. Admittedly, the application of the present petitioners filed in the Session Judges Court under Section 227 CFPC has been rejected. Agreed by the same, the present petition has been filed by those accused. No doubt, the state is the guardian of the interest of the public, and it has to guard the interest of the general public. As such, truly, the aggrieved party would be the state. Aggrieved party would be the state, it being the custodian of the social interests of the parties. However, the alleged fact cannot be ignored that the supposed applicant proposed respondent claims himself to be the own brother of the deceased, which brother is alleged to have been murdered in the criminal act. Section 301 of CRPC reads as below, extract hack. Thus, a reading of this section go to show that the inclusion of a private party to assist the prosecution cannot be is not absolutely barred. However, in the appropriate cases where the court thinks that the impleading of a private party would be of some help to the prosecution to place its case more effectively, then the such party may be impleaded to assist the prosecution. In the instant case, since the applicant claims himself to be the own brother of the alleged deceased, and his impleading in this present petition as a respondent number 2 may help the prosecution in placing its case for the prosecution. I am of the view that no prejudice would be caused to the petitioners in any manner if the present application is allowed. Accordingly, IA 1/21 is allowed, and the applicant therein is permitted to come on record as respondent number 2 for assisting the public prosecutor as per subclass 2 of section 301 CRPC. The petitioner to carry out the necessary amendment in the memorandum of revision petition and file amended memorandum of revision petition and with the registry within a week from today, duly, however, duly serving copies thereof to both the respondents. List the matter on 10/6. Yes.
Request on 13th. Request on 13th. Somewhere. 13th.
Amendment part on the petition has the amendment copy hakri. ಆಮೇಲೆ ಬೇಕಾದ್ರೆ ಕೇಳಿ ಟೈಮ್ ಕೊಡುವ.
21, Pratima SK, C. Chandrasekhar for respondent.
Because I haven't filed my objections, I seek time to their application, not
Respondent, the wife, its application seeking permission to withdraw the.
ಹೌದ್ರಿ ಅವ್ರು ಅದಕ್ಕೆ ಇದನ್ನ ಹಾಕ್ಬೇಕಲ್ರಿ ಅಬ್ಜೆಕ್ಷನ್.
So to the direction of the honorable court, my lord, they have deposited 2 lakhs before the trade court.
I'll file my objections.
The counsel from both sides present, learned counsel for the petitioner prays for a short accommodation to file their objection to IA 2/2022. 10 days time is granted.
I pray for 2 weeks because he's traveling. That's the only reason.
On 1 week ಕೊಡೋನು 10 days ಕೊಡ್ಬೇಕು.
This matter still number 22, CS Kumar, Ramamani respondent, unrepresented. CS Kumar, still number 22.
None appear in this matter either physically or through video conference. No reasons are forthcoming for non-appearance of non-appearance of the parties, non-appearance of the learned counsel. The petitioner. The respondent, though has been shown as served, has remained unrepresented. Considering the nature of the petition, I am of the view that to present the matter of the respondent, amicus curiae be appointed. Accordingly, Srimati K. Archana, who is physically present in the court, is appointed as amicus curiae for respondent. The registry to furnish the amicus curiae takes notice. Registry to furnish petitioner to furnish activity. Registry to furnish the entire set within a week from today. Okay. Next line. A perusal of the order sheet would go to show that the criminal case is of the year 2007. As such, the matter is 15 years old. Still, the petitioner is not evincing. Prosecute the matter as his learned counsel has remained absent. The matter. As such, it is made clear that in case the learned counsel for the petitioner fails to appear in the matter on the next date of hearing, the court may proceed to appropriate order, including dismissal of the petition or appointing an amicus curiae. This matter on 8/6. Yes.
Cell number 23, Kantrajappa MG, SCGP for respondent.
The offense punishable under section 279, 337, 338, reduce section 134A and B, and section 187 of Motor Vehicle Act. The trial court is convicted the offense punishable under section. The impound order, page number 37, my lord. Accused shall undergo increase imprisonment of 6 months.
We'll hear the argument on main in the next week.
Please.
Learned counsel from both sides present and submit that since the trial court and session post records have arrived at, the main matter itself can be heard and disposed of. As such, list this matter on 9/6/2022 on the top of the list. Yes.
Cell number 24, NR.
to appear for? The settlement is concluded. Learned counsel for the petitioner neither present physically nor through video conference. Learned counsel for the respondent alone is physically present. Submits that no settlement has been arrived at between the parties. A perusal of the order sheet would go to show that on the guise of the alleged settlement, both sides have taken sufficient time in this matter. On one such occasion, on Date to 2022, the respondent had even submitted that settlement was not possible. Even thereafter, the matter went on for alleged settlement, and several hearing dates have been passed. Since the parties have not arrived at any settlement, the matter is required to be proceeded. Accordingly, list this matter on 9/6/2022 on the second top matter in the file, on which day both parties are directed to come prepared to address their final argument, since trial court and final argument on the main matter, since the trial court and sessions court records have already been received. Yes.
Serial number 25, KP Bhuvan, VS Ravindra Holla. Electric counter of correspondent.
I appear for respondent, please.
I have filed an application seeking for deposit, not permission to deposit the amount 50% ordered by this court.
Who appear for and in which matter?
The entire KV one has been last occasion for retirement, since he has given a no objection occurred to me. Ravindra Holla. I have filed it the entire appeal. In all the appeals I have filed no objection occurred.
To appear in criminal revision petition 466 of 2018, serial
For
number
respondent. For respondent.
I am for the petitioner, please.
Respondent I have 466, 468.
There are counsel from both sides. There are counsel Shri V.S. Ravindra suffice that since he has filed no objection wakalat given to him for the petitioners by Shri K.P. Bhuvan, the previous advocate, the name of Shri K.P. Bhuvan need not be shown. For the petitioner theory by previous counsel Shri K.P. Bhuvan, the name of said learned counsel, the name of the previous counsel Shri K.P. Bhuvan need not be shown in the cause list. The registry to verify the said submission and do needful in the matter. Yes. What is the submission?
I have filed an application seeking for permission to deposit the amount, whatever at the time of granting the suspension of sentence, this sum directed from I have filed earlier application. The earlier counsel has filed an application seeking for an extension of time. Since the appellant is not in a position to deposit the amount, then this sum court taking into consideration of the delayed date, the application extension, seeking extension of application has been rejected. And now I have filed an application now seeking permission to deposit. Since the trial court even though I have taken a DD, I have moved the matter. But since there is the dismissal of extension of the time, now the trial court is not accepting the DD or not permitting me to deposit the amount. That is why I filed an application before this court now seeking for deposit. Now the fine levy warrant has been issued.
From last, my lord, I
Seeking
have,
for deposit in which matter? There are 10 total matters.
my lord, I have filed it in criminal revision petition.
ಅದನ್ನ ಹೇಳ್ಬೇಕಲ್ವೇ, ನಾನು ಅದನ್ನ ಹುಡುಕೊಳ್ಬೇಕೆ. 12 ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಏನೋ ಸಾರಾ ಸಗಟಾಗಿ ಒಂದು ತಿಪ್ಪೆ ಸಾರಿಸಿದಾಗ ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಬಿಡ್ತೀರಿ. ಸ್ವಾಮಿ, ಸೀರಿಯಲ್ ನಂಬರ್ ಇಷ್ಟಿಷ್ಟರಲ್ಲಿ ನಾನು ಇಂಥ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೇನೆ. ಐ ಕ್ಯಾನ್ ಕ್ಯಾಚ್ ಇಟ್ ಕ್ಲಿಯರ್ಲಿ.
454 ನೊಳಗೆ it has been mentioned.
ನನಗೆ ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳಿ.
25.7, 25.
ಪ್ರತಿ ಕೇಸ್ಗೂ ಒಂದು ಸೀರಿಯಲ್ ನಂಬರ್ ಇದೆ ತಾನೆ.
25.7.
25.7 ಹೇಳಿ.
ಅದರೊಳಗೆ criminal revision petition 454 it has been mentioned.
Yes, ಅದು ಒಂದರಲ್ಲಿ ಹಾಕಿದ್ದೀರಿ.
I have filed the common application, my lord, since it is a common order has been passed and common case has been
ತೆಗಿರಿ ಅದು ಅಪ್ಲಿಕೇಶನ್.
in 4 cases where, my lord, the conviction has been ordered.
ಒಂದು ನಿಮಿಷ.
457, 454, 451.
My lord will see the order in 447 of 2018, my lords. Orders have been passed. 447 ನಲ್ಲಿ order dated 19/4/2022, my lords. 19/4/22, your lordships, this honorable court passed an order. Heard the learned counsel for the petitioner on IA number 1 of 22. This court wide order dated 5/8/2019 suspended the sentence subject to depositing 50% of the fine amount within 4 weeks too, and the same was not complied. And hence one more application was filed for extension of time to deposit the 50% fine amount on 2/3/2020. And this court again granted a week's time to do the same, but the same has also not been complied with. Now, almost after 2 years, the counsel for the petitioner has come up with the present application, again seeking extension of time to deposit 50% of the fine amount. And the reasons assigned in the present application is that petitioner was suffering from viral fever and sugar, and due to COVID-19, he could not able to deposit the amount within the time as directed by this court. And the petitioner is dragging the matter for a period of 2 years to deposit 50% of the amount as directed by this court. And hence, there is no ground to extend the time. Accordingly, IA number 1 of 22 is dismissed. The respondent is at liberty to enforce the judgment of conviction and sentence against the petitioner. This is the final order, please, next, dated 19/4/22.
ಯಾವತ್ತು ಫ್ಲಾಗ್ ಅನ್ನು ತೆಗಿಲಿಕ್ಕೆ ಮುಂಚೆ ಬರೀಬೇಕು. ಗಮನಿಸಿ. $454 in a year. Retirement. Counsel from both sides present first to retirement submission the name of the said previous counsel need not be shown on the. In addition to the same, the previous counsel has also filed retirement seeking his retirement. Seeking permission, seeking his retirement from appearing. The matters are shown in the memo. Amel in the light of the above, registry to so and so, so and so. In 447, have you filed an application seeking extension of time?
And since blood in it has filed, common application has been filed.
The counsel on the previous date of hearing, you made a specific submission that In criminal revision petition 447, you have filed an application. However, the registry has not
No,
placed the same.
I have not, Wakalat has not been put up. Sorry, my lord. Wakalat has not been put up. Only one case now it has been put up. Another case.
Proceeding. See that.
All other matters, 447, I have already. While filing the application, it has been mentioned 447, 454, and 451. I have no other intention.
464 previous date in 24/5/2022. Cause list. ಯಾವ್ದ್ರಿಂದ ತೆಕ್ಕೊಟ್ರಿ ಈಗ ನೀವು ಯಾವ್ದ್ರಿಂದ ಕೊಡ್ಬೇಕು? Your request for extension of time has already been rejected. Then how can you file the same application?
I do admit, Malad, while Malad passing the order, Malad,
My question is, once your request has been rejected,
but seeking for extension of time, Malad, earlier it has been rejected. Seeking extension of time to deposit the amount. Because Malad, I have no intention from 2018 itself, Malad, the appellant is in Malad, taken treatment for the heart treatment and kidney. Malad, these documents are
E-party case 138 ಕೇಸ್ಗಳಲ್ಲಿ E-party ಕನ್ವಿಕ್ಷನ್ ಸಫರ್ ಆದ್ರೆ ಹಾರ್ಟ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಬರ್ತದೆ, ಆಮೇಲೆ ಗ್ರಾಜುಯಲಿ ಬೇರೆ ಟ್ರೀಟ್ಮೆಂಟ್ ಗಳು ಬರಬಹುದು.
But since Malad, what is up, Malad, all these checks, Malad, I can Malad prove before this court, Malad, whatever Malad, the complaint has been filed is a frivolous complaint because he is Malad, he is under as a lessee. He vacated the premises. Malad, for that Malad, the deposit amount has been given. Now he did not vacate the premises. From last 2014 itself, Malad, up to Malad, the eviction order has been passed by the trial court. He has not vacated the premises. He has not paid the rent or Malad.
Do you have any objection for extension of time by allowing IA?
Highlights.
1/22.
Millets, my client has paid the mortgage amount of 9 lakhs millets. Since 2015, the matter has been dragged on till today. Millets, his contention is that on 1/7/2015, he has given the checks. He contends that on 26/7, he has paid 5 lakhs cash. He is due only 3 lakhs. That is his contention. He has examined.
I am not on the merit.
Yes, Millets.
Extension of time. If you have got any objection, file your objection. If you have no objection for allowing the application on terms, make submission. You are at liberty either to
I will file my
objection or to make a submission of no objection on terms.
I will file my objections, Millets.
Once, yes, the lordship permits. Even Malad, I am ready to Malad, they go on with the matters on merit. 2 days or 3 days have been given. Malad, if lordship Malad,
one submission. If Lordship, my lord, I will not take any adjournment, my lord, except my lord 3 days or 4 days, because I have to go through the entire records, my lord. But on the very same time, my lord, I will make my submission with respect to, my lord, the on merits of the case. If Lordship by considering those, my lord, the submission, my lord, now if another 4 days has been adjourned without, my lord, granting me permission to deposit, I may be permitted to enable to take, my lord, deposit the amount, and, my lord, seek for, my lord, the issuance of FLW as to be. Otherwise, my lord,
Learned Counsel for Learned Counsel Sri V. Lakshmikant Rao. Appearing for respondents in some of the matters submits better. Prays for a short accommodation to file his objection to IA 1/22. The week's time is granted as agreed. Yes.
Number 26 adjourned. Number 27, P. Mahesha.
I appear for the petitioner, my lords. I pray for a week's time, my lords, to go through the paper since it has come up after 1.5 years. My lords. It was listed last 2000.
The counsel from both sides present. At the request of the learned counsel for the revision petition, a week's time as finally is granted.
Number 28. ಕೆಂಪೇಗೌಡ HK.
ಈ ಕೇಸನ್ನು ಕೇಳ್ತಾ ಇರ್ಬೇಕಾದ್ರೆ ಫೈಲ್ ನೋಡ್ತಿರ್ಬೇಕಾದ್ರೆ ನೀವು ಇದೆಲ್ಲ ಕಸರತ್ ಮಾಡಬಹುದಿತ್ತಲ್ವೇ? ಪ್ರತಿ ದಿವಸ ಹೇಳಿಸ್ಕೊಳ್ತೀರಿ, ಇಬ್ಬಿಬ್ರಿತೀರಿ. None appear for the petitioner either physically or through video conference. As per the police report, respondent is shown to have been served. Who is respondent now?
Manjunatha DG.
Called out. He has remained absent. The matter could not be proceeded today. Yes.
29, Prasanna P. Ravindra P. Deshpande. Respondent.
As against the order of the learned special judge CBI cases Bengaluru for allowing the discharge application filed by number 8 and 9, or CBI may not has filed this revision petition.
Counsel from both sides. For the submission on admission, there was the memorandum of petition. Considering the grounds raised in the memorandum of petition, which requires a detailed hearing, the petition stands submitted. Registry to call for the special court records on emergent basis 4 weeks from today and list the matter for final hearing immediately after receipt of the special court records, which shall not be beyond 5 weeks from today. Since the matter involved is with respect to alleged offences punishable under various offences of punishable under various sections of IPC, and also the offences punishable under section 713(1) and 13(2) of PC Act. As submitted, the early disposal of the petition is warranted.
30 absent, 31 Santosh Kumar MB, Vijay Kumar S for respondent.
I appear for the petition in this case, my lords.
I am for respondent, my lord.
Lords, the petitioner has filed his revision petition challenging the order of the appellate court, my lords, wherein the respondent has filed. Lords.
Yes.
Lords, the respondent has filed a complaint against the petitioner for the offence punishable under section 138 of the Act, my lords. The amount, check amount is rupees 10 lakh, my lords.
Yes.
The contention of the complaint is that an amount of rupees 10 lakh was been invested in the aviation business of the complaint, my lords. Respondent. Respondent has invested a sum of rupees 10 lakhs in the aviation business of the petitioner, my lords. But she had paid an amount of rupees 6,50,000 by way of check on 8/11/2016, my lords. And thereafter, an amount of rupees 3,50,000 was been transferred by way of cash, paid by way of cash within a week from 8/11/2016, my lords. That's here. That's and the contention of the complaint is that 5 checks were been issued by the petitioner for the repayment of the amount, my lords. 1 check for an amount of 10 lakh. The other 4 checks were.
After hearing their submission, I am of the view that after receipt of the trial court and session court records, the main matter itself can be heard and disposed of. Accordingly, call for TCR and ACR.
Number 32, Charan Kumar KB.
Petition 138. Check amount is 4 lakh. Fine amount is 5,05,000 rupees imposed. Fine.
For the submission of Learned Counsel for the revision petition, there is the memorandum of petition and IA 1/20. Next line. From perusal of the record, it is revealed that though the petition was filed in the year 2020, though the petition was filed in February 2020, but till few days back, that is till the end of May 2022, the petitioner has not complied with the office objection, making the petition ripen for its first hearing. Next line. Let notice go to the respondent. After hearing the submission, I am of the view that before proceeding to pass any further order, responding to be served with notice and heard accordingly, issue emergent notice to the respondent. The petitioner to pay emergent notice to the respondent both on the main petition and on IA 1/20. Petitioner to pay the necessary process and furnish copies in the registry, if not already done, during the course of the day.
Tomorrow.
Immediately after service of emergent notice. Yes.
Number 33, SP Narasimhamurthy, SCGP for respondent.
Respondent Millard. For the offense punishable under section 304. The trial by the learned magistrate. In the appeal Millard, it is modified Millard. So the appeal is dismissed, but it is modified. It's here has not come, Millard. It could kindly the HR Millard could be.
Both for the petitioner not present, Learned HCGP alone present. There is the memorandum of petition, heard the submission of Learned HCGP. For TCR ACR. Yes.
Number 34, Gopal Singh. Gopal Singh.
can appear for the revision petition either physically or through video conference. No reasons are forthcoming for non-appearance of 11th council for revision petition. Here is the memorandum of revision petition and IA 1/21. It can be seen from the case file that though the petition along with the IA has been filed in the month of March 2021, the petitioner has not shown any urgency. Consider IA 1/21 for nearly 1 year, 3 months now. Hence, it appears that the petitioner has no urgency in the matter. Next line. Issue notice to the respondents both on the main petition and IA 1/2021. Issue notice better. In the light of the above, I am of the view that before proceeding to pass any order on IA 1/21, the respondent be notified and heard accordingly. Issue notice to the respondent both on the main petition and on IA 1/21. Petitioner to pay the necessary process and furnish copies in the registry if not already done within a week from today.
Till number 35, 36 adjourned. Till number 37, Nagendra Naik or P. Prasanna Kumar for respondent. Connected.
For the petitioner, Your Lordship. Lordship, I may be permitted to withdraw this matter.
Memo.
Your Lordship, memo next hearing date alko. Ili pass all Your Lordship.
ಕೋರ್ಟ್ ಅಂದ್ರೆ ಮಕ್ಕಳಾಟ ಅಂತ ತಿಳ್ಕೊಂಡಿದ್ದೀರಿ.
ಇಲ್ಲ ಪಾರ್ಟಿ ಸಿಗ್ನೇಚರ್
ಯಾರು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋದನ್ನ ಹೇಳಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಪಾರ್ಟಿ ಸಿಗ್ನೇಚರ್ ತಗೋಬೇಕಿತ್ತು. ಸೊ ನೆಕ್ಸ್ಟ್
ಪಾರ್ಟಿ ಸಿಗ್ನೇಚರ್ ಬೇಕು ಅಂತ ಯಾರು ಹೇಳಿದ್ದಾರೆ ನಿಮಗೆ? ಏನೋ ಸುಳ್ಳನ್ನ ನೇಯಬೇಡಿ. ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಸ್ ಕರೆದಾಗ ಪ್ರೊಫೆಷನ್ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ಗಂಭೀರತೆ ಇಟ್ಕೊಳ್ಳಿ. You are making a submission before a judge in a court of law. ಹಾಳಾಗಿದೆ ರೀ ಈಗಿಂದೆಲ್ಲ ಲಾ ಎಜುಕೇಶನ್ ಹಾಳಾಗಿದೆ, ಇದು ಹಾಳಾಗಿದೆ. ನೋ ಸೀರಿಯಸ್ನೆಸ್. There are counsel from both sides present. There is counsel for the petitioner prays for passing over of the matter, stating that he will file a memo not pressing the present petition. Matter is passed over. Call at 2:30 p.m. today. Yes.
Number 38, Alima Amin.
Conviction for offence under section 138 of NI Act, my lord. Check amount is 1,50,000 and fine amount is 1,69,000, my lord. Petitioner was out on bail during trial period as well as appeal period, my lord. He has not misused the liberty granted to him. PA is there for suspension sentence, my lord. He granted bail.
Why don't I order for emergent notice before passing any act?
Warrant will go, my lord. He'll be in.
So you are sleeping hither for nearly 6 months. You yourself had no urgency.
Dear lady, she had financial difficulties to approach the.
Maybe let him suffer no. Let the other party come. For 6 months you kept quiet after filing the petition. Heard the submission of learned counsel for the petition, both on the main petition and on IA 1/21. After filing the present petition along with the IA, the petitioner appears to have taken inordinate time to complete office objection and get this matter listed. Thus, for nearly 6 months, the petitioner did not evince any interest. The matter for obtaining any interim order on IA. When the matter was called on 24/5/2022 also, the petitioner did not proceed with the matter. Hence, it is clear that there is no urgency for the petitioner for the consideration of IA 1/21. Therefore, issue emergent notice to the respondent, both on the main petition and on IA 1/21, returnable by 16/6.
Number 39, Nehru P.
Hearing for the petition, my lord. The petitioner has been convicted for 20th ACMM by order H25/2017. Aggrieved by the conviction, she had appeared before the appellate court, and the appellate court has confirmed the order of trial court. Aggrieved by the order, she is before this honorable court, praying this honorable court to set aside both the orders of lower courts, along with an application praying this honorable court to suspend the sentence. She was regular in appearing before the trial court. Third, she has been convicted and ordered to pay rupees 3,60,000. The check was for the amount of 2,60,000. In fact, the check in question was not
deposited in the trial court within 2 weeks from today. 50,000 rupees personal bond with 2 sureties for the election to the satisfaction of the trial court. All other conditions, emergent notice, TCR, SCR. Yes.
Number 40, Hiremat Mallaya Viraya, SPP for respondent.
under the NI Act, that the learned magistrate was pleased to grant 11,90,000 rupees compensation, against which the appellate court was pleased to modify the judgment by granting 10,05,000 rupees by order dated 24/11. Immediately thereafter, I filed the February 17th, I filed the present tuition with lordships. I had a benefit of suspension of sentence during the pendency. I have paid 2,39,000, 20% check amount of rupees 10 lakhs.
Copy, sir, to you.
No, this is offenses under section 138 of NI Act. My name is wrongly shown in the card list by registry. Therefore, my name may kindly be deleted, my lords. By oversight, my lords, the board branch has shown my name as SPP.
Sir, they have shown it. You are entitled to and have a right to make a submission that your name has been wrongly shown by the registry. Whether it is oversight, mistake, intentional, careless, you cannot say. That is for them to say, for me to decide.
Yes.
You just say that you are not a party here.
Yes,
but however, your name is shown as served. As such, your name be removed. That is all. There ends your right to make submission.
Yes, ma'am. Yes,
was it a oversight or was it a mistake is my prerogative to decide. And last time I have made it very clear, still in a routine tape recorder manner, you make these submissions. Last time ನಾನು ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾಗ ಗವರ್ನಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಇದ್ದ ಪ್ರೈವೇಟ್ ಅಡ್ವೊಕೇಟ್ ಹೇಳಿದ್ದೇನೆ. What is his permissible limit of submission in such an event? The counsel for the petition and Learned HCGP are physically present. Learned HCGP submits that though the state is not a party in this petition, however, the registry has shown his name for the respondent, as such the same request to be rectified. Next line, admittedly, the present petition is between two individuals where the state is not a party, hence the registry, if has shown the SVP as served by mistake, to remove the same. Next one. 38, though bail. Deposit 40% in the trial court within 2 weeks, 2 lakh rupee personal bond with 2 sureties Emergent notice, TCR, SCR.
Please.
41 Kumara KG.
Delegate my lords, concurrent findings. Check amount is 31 lakhs 50,000.
Same order. 40% to be deposited in trial court within 2 weeks.
4 weeks, my lords.
2 lakh rupee personal bond with 2 sureties.
My lords, 4 weeks.
Absolutely. Yes.
That's I request my lords.
Silver 42 Venkatram Reddy L.
Yes, please.
My lord, the facts of the case are thus. Petition petitioner herein and the respondent were married in the year 2001 according to Hindu rites and customs. In the year 2002, out of this wedlock, a son named Naveen was born. After sustaining prolonged abuse, mental as well as physical abuse at the hands of the respondent, that is the husband, in the year 2015, the revision petitioner herein approached the magistrate, that is the trial court, under section 12. She filed an application under section 12 of Protection of Women from Domestic Violence Act 2005. The learned trial court provided three reliefs to the revision petitioner herein. The first being that a police protection was granted against domestic violence. Second is the maintenance of rupees 20,000 per month payable to the revision petitioner and her son. And third being the compensation of 1 lakh. My lord, the respondent husband then filed an appeal under section 29 of Protection of Women from Domestic Violence Act and approached the Sessions Court. The Sessions Court, which is the first appellate court, modified the second relief, that is the maintenance. The quantum of maintenance was reduced from rupees 20,000 per month to 10,000 per month, Your Honor. My lordship, I apologize, my lordship. It is this order dated 27/12/2021 that is challenged in this revision on two primary grounds, that being that the wife does not have the sufficient means to maintain herself as well as her son, who is now studying BCom, my lord. And the trial court has also recorded a finding that there's no conclusive evidence to show that she is employed. She is in fact unemployed. And the second being that the husband, that is the respondent herein, has sufficient means. He's running a cable TV business which is successful and owns prime properties in locations in Bangalore, my lord. Hence this revision petition.
Further submission of learned counsel for the petitioner, both on the main petition and on the A1/22. Here is the memorandum of petition. And A1/22. Considering the fact that the present petitioner is the wife who has challenged the reduction of the maintenance payable to her by the respondent herein, in the impugned judgment passed by the first appellate court. I am of the view that before passing any further order, before passing any order on A1/22, the respondent be notified and heard. Accordingly, issue emergent notice to the respondent, both on the main petition and on A1/22. In the meantime, call for TCR, SCR. The petitioner to pay the necessary process and furnish copies in the registry, if not already done, during the course of the day. Yes.
Naik NR.
I beg to appear for petitioner, my lord. In this case, my lord, the petitioner has punished for the offence punishable under section 138. Check amount of rupees 1,50,000, my lord. And thereafter, my lord, he has appealed the matter before the appellate court. Appellate court dismissed the appeal only on the ground delay in filing of the appeal, man.
How long was the delay?
Delay 2 years, my lord.
ನಿಮ್ಮ ಪ್ರಕಾರ ಒಂದು ವರ್ಷಕ್ಕೆ ಎಷ್ಟು ದಿವಸ? ಒಂದು ವರ್ಷಕ್ಕೆ ಎಷ್ಟು ದಿವಸ? 480 ದಿವಸ ಅಲ್ವೇ? ಆ ಬುದ್ಧಿವಂತಿಕೆ ಯಾಕ್ರಿ ಮಾಡ್ತೀರಿ ವಕೀಲರು? 980 days ಡಿಲೇ. ಕೋರ್ಟ್ ಏನು ಓದಿರಲ್ಲ, ಏನೋ ನಾವು ಹೇಳಿಬಿಟ್ರೆ ಸಾಕು, ಅದ್ರ ಮೇಲೆ ಮಾಡ್ತಾರೆ ಅಲ್ವೇ ನಾಯಕ್ರೆ?
Swami, we have assigned the reasons, Swami. ಆದರೂ ಕೂಡ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ. ಅದ್ರ ಮೆರಿಟ್ ಮೇಲೆ ಮಾಡಿದ್ರೆ
ಡಿಲೇ ಎಷ್ಟು ಅಂತ ಹೇಳಿದ್ರೆ ನಿಯರ್ಲಿ 3 years ಇದೆ, 2 ವರ್ಷ ಸ್ವಾಮಿ ಅಂತೀರಿ. ಸ್ಮಾಲ್ ಚೆಕ್ ಅಮೌಂಟ್, ಅದಕ್ಕೆ ಅಷ್ಟು ದೊಡ್ಡ ಲಿಟಿಗೇಷನ್. Since 9 years you are fighting.
Yes. Because what happened, my lord? The 1,50,000 who has taken, my lord, is one of the manager of the company, my lord. He left the company, and whatever amount paid to him, my lord, he has not deposited to the bank. But the check which was Received by him, my lord, presented and got it honored. Got it honored, but same is not.
Ayakudi. % of the fine amount. 2 weeks trial court, 30,000 rupees. Personal bond, single surety, emergent notice, DCR, ACR. ಅದರಲ್ಲಿ ಸ್ಟೇನ ಫಾರ್ಮೆಟ್ ನಲ್ಲಿ ಒಂದು ಸಣ್ಣ ಚೇಂಜ್ ಮಾಡಬೇಕು. ಸ್ಟೇ ಆಫ್ ದಿ ಜಜ್ಮೆಂಟ್ ಆಫ್ ಕನ್ವಿಕ್ಷನ್ ಅಂಡ್ ಸೆಂಟೆನ್ಸ್ ಪಾಸ್ಡ್ ಬೈ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇನ್ CC number zones. Specifically. Yes.
Number 44, Ramesh K.
Please.
Ramesh KM.
None appear for petitioner either physically or through video conference. Hence, it appears that the petitioner has no urgency on IA 1/2022. It's a matter in the week after next. Any earlier posting would be only after bringing the today's observation to the notice of the court. Number 1 numbers. Registry refuse ಮಾಡಿದ್ದು. ಕೃಷ್ಣ ಫಾಸ್ಟ್ ಅವರನ್ನು ಮತ್ತೆ ಕರೀರಿ ಅಂತ ಯಾಕಂದ್ರೆ ಬಂದಿದ್ರೆ ಕಾಲ್ ಮಾಡಿ ಏನು ನೋಟಿಸ್ ಮಾಡಿ ನಾನು ಹೆಚ್ಚು ಕರೀರಿ. ರಿಜಿಸ್ಟರ್ ಜುಡಿಷಿಯಲ್ಗೆ ಫೋನ್ ಮಾಡಿ ಸಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೇವೆ ಅಂದ್ರೂ ಕೂಡ ನೀವು ಟೈಮ್ ಬಾರ್ ಆಗಿದೆ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದೇ ಇಲ್ಲ, ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಕೊಟ್ಟಿಲ್ಲ. ಫೈಲ್ ಮಾಡಿದ ಫಸ್ಟ್ ಅಲ್ಲಿ ನೀವು ಆಫೀಸಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ ಕೊಡಲ್ಲ, ಪರ್ಮಿಟ್ ಮಾಡಲಿಲ್ಲ ಅಂತೆ, ಟೈಮ್ ಬಾರ್ ಆಗಿದೆ, ಬಿಡಲ್ಲ ಅಂತ ಹೇಳಿ. ದೇರ್ ಇಸ್ ನೋ ಆರ್ಡರ್ ಬೈ ದಿ ಕೋರ್ಟ್ ಫಿಕ್ಸಿಂಗ್ ಇನ್ ಟೈಮ್. ಅದ್ರ 1:15 ಸಾಯಂಕಾಲ ಸಬ್ಮಿಟ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ ಕಳಿಸಿ ಚೇಂಬರ್. ಎಸ್ ನೆಕ್ಸ್ಟ್.
Further hearing matter. Seal number 45, CM Raju. Connected.
For 57 and 380 of IPC. Last occasion, my lord, your lordship asked me the fingerprint was lifted the place, my lord, was not recorded in the Raja. And also the person who lifted the fingerprint, my lord, he was not actually.
You get me an equivalent citation of any other journal. I don't accept the reported judgment under this website. I'm finding a lot of discrepancy mistakes there. When you can easily secure the judgment by High Court website itself, most easiest way you go by. Most easiest way. ಏನು ಹೇಳಿದ್ದಾರೆ ಅದರಲ್ಲಿ?
Attention taken in this case also that my lord, he considered that the prosecution has failed to prove the opinion of the fingerprint expert so as to
Repeat it, please.
My lord. He contends that the prosecution has failed to prove the opinion of the fingerprint expert so as to connect the said opinion to the accused. The investigation officer has failed to follow the procedure in collecting the specimen fingerprint of the accused. No Panchanama was prepared either at the time of lifting the alleged chance fingerprint or collecting the specimen fingerprints of the accused. In view of these defects, the evidence relating to the fingerprints opinion is rendered unreliable. This court, my lord, gave finding that, my lord, the next circumstances laid on by the prosecution is the fingerprint evidence. In proof of this circumstance, the prosecution has relied on the evidence of PW 21 and consideration of this evidence. We are of the view that this evidence falls short of the legal requirement of an expert witness. We find this evidence sketchy and unacceptable. According to this witness, on 9/1/2011, on receipt of a wireless message, he rushed to the spot between 5:45 and 6 p.m. and inspected the spot and found a knife, beer bottle, whiskey bottle, water bottle, and a soda bottle at the spot. According to him, he developed a fingerprint from a beer bottle on 10/1/2011. He
According
said,
to him, a microphone ಸ್ವಲ್ಪ ಕೆಳಗೆ ಮಾಡ್ಕೊಳ್ಳಿ ನಿಮ್ಮ ಮೌತ್ದಲ್ಲಿ.
according to his witness, on 9/1/2011, on receipt of a wireless message, he rushed to the spot between 5:45 and 6 p.m. and inspected the spot and found a knife, beer bottle, whiskey bottle, water bottle, and a soda bottle at the spot. According to him, he developed a fingerprint from a beer bottle on 10/1/2011.
According to him, he developed
on a beer bottle, soda bottle.
According to him, he developed a fingerprint on Beer bottle.
From a beer bottle. On 10/1/2011, he sent an email to Panambur police station and thereafter forwarded the said chance fingerprint to the Fingerprint Bureau, Bengaluru. He further deposited that subsequently the investigation officer forwarded the fingerprints of all the 10 fingers of the accused to his office. After receipt of these specimen fingerprints, he secured the developed fingerprints from Bengaluru and compared them with the specimen fingerprints and issued his report dated 18/5/2011 as per Exhibit P14. Though this evidence, the developed chance fingerprint is marked as Exhibit P15. We have perused Exhibit P14 and the annexure appended thereto, wherein a PW21 has furnished 10 grounds in justification of his opinion. On careful.
One second, please. ಕಾಪಿಯಲ್ಲಿ ಇದೆ ಇಲ್ವಾ? ರಿಪೋರ್ಟ್ ತರಿಸಲಿಕ್ಕೆ ಹೇಳಿದ್ರಿ, ಅವ್ರು ಕೋರ್ಟಿಗೆ ಕೊಟ್ಟಿದ್ದು ಅಲ್ಲೇ ನಿಮ್ಮ ಹತ್ರ ಇಟ್ಕೊಂಡಿದ್ದೀರಿ ಅಲ್ವಾ? ಅದನ್ನು ಕೊಡ್ಬೇಕಲ್ವೇ ನನಗೆ? ಅದು ಕೋರ್ಟ್ ಇಂದ ಬರಲಿವರೆಗೂ ಮತ್ತೆ ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ? ಇಲ್ಲೊಂದು ಕಾಪಿ ಇದೆ, ಅವ್ರು ಓದ್ತಿರೋದನ್ನ ನಾನೇನು ಫಾಲೋ ಮಾಡಬಹುದು. ನಿಮಗೆ ಈ ಜರ್ನಲ್ ಬೇಡ, ಬೇರೆ ರೆಪ್ಯೂಟೆಡ್ ಜರ್ನಲ್ ತರಿಸಿ ಬರಲಿವರೆಗೆ ಇದನ್ನು ಕೊಡ್ಬಹುದಲ್ವೇ? ಯಾಕೆ ಈ ಪಾರ್ಟಿ ನೆಗ್ಲಿಜೆನ್ಸ್ ತೋರಿಸ್ತೀರಿ? ಇಬ್ಬಿಬ್ರಿದ್ದೀರಿ. Which paragraph you are reading?
16, 16, page 5. We have perused Exhibit P14 and the annexure appended, wherein PW21 has furnished 10 grounds in justification of his opinion. On careful consideration of his evidence and the contents of Exhibit P14, we are not persuaded to accept the evidence for more than one reason. Firstly, his evidence is not specific with regard to the date and time when he lifted the alleged chance fingerprint. Secondly, the said chance fingerprint is not produced before the court from the evidence of PW21. It can be gathered that he had collected the chance fingerprint from the beer bottle. The beer bottle is also not seen. His evidence is silent as to the manner in which he lifted the chance fingerprint. He has merely stated that he collected a developed fingerprint and forwarded it to the Fingerprint Bureau. What has been produced along with Exhibit P14 is the developed fingerprint. Exhibit P15 and not the chance fingerprint. The non-production of this chance fingerprint, in our view, creates strong doubt about the very existence of chance fingerprint at the spot as contended by the prosecution. This doubt gets further reinforced from the fact that no contemporaneous document like the Mahajar or the photographs of the said chance fingerprints are produced before the court by way of corroboration. Even though PW21 asserted in his evidence.
PW21. Who was PW21? Was he an expert or was he a police officer?
Fingerprint expert.
Where is that?
It is for second paragraph. Second paragraph, page 4, page 2, para 4. PW22, the investigation officer, fingerprint expert on the alleged spot, fingerprint expert, PW21.
Yes.
Even though PW21 has asserted in his evidence that he had intimated to his higher superior about the lifting of Charles' fingerprint, but no document is presented in support of this assertion. His evidence is not clear as to when he received the specimen fingerprints from the investigation officer. He has merely stated that on receiving the specific fingerprints from the investigating officer, he secured the developed print from the bureau and thereafter compared the specimen with the Charles' fingerprints. When the prosecution has failed to produce bogus proof for having lifted the Charles' fingerprint and the Charles' fingerprint itself is not produced before the court, there was absolutely no occasion for PW51 to compare it with specimen fingerprints. Therefore, viewed from any angle, we do not find his evidence worthy of credence. His opinion gets further falsified from the fact that in the opinion given by him at Exhibit P14, except making a reference to the requisition date 9/1/2000, he has not referred to any overriding letter under which the specimen fingerprints are said to have been forwarded to him by the.
This observation is helpful to you in your
This
case.
case, my lord, the lifting of Charles' fingerprints is there is no evidence. Lifting of Charles' fingerprint from the spot, my
How
lord.
do you say that there is no evidence? Has he not explained the methodology and the procedure followed in lifting the fingerprint?
But the person who lifted the melody was not examined.
That is different. Person who lifted is not examined is different from how it was lifted has not stated. You said that how the fingerprint was lifted was not stated. Now, when I asked you the question, has he not stated, you are now changing the version and telling that the person who lifted the fingerprint is not examined. Does this judgment says that the person who has lifted the fingerprint must be necessarily examined?
No, man, there is no evidence, my lord, to the, they were collected the fingerprint from the
Okay, don't assume certain thing. Please.
Evidence,
Kindly don't assume certain thing on your own. And say, or as part in the fingerprint, some evidence. Read the evidence, please. What read? The evidence.
PW 5 and 6. Eight 898.
PW6.
Evidence of PW 5 minutes.
Yes.
Anandamurti.
Yes.
ದಿನಾಂಕ 4/6/2010 ಠಾಣಾ ಪ್ರಬಂಧದ ಕಾಲಕ್ಕೆ ಬೆಳಗ್ಗೆ 1 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಈ ಪ್ರಕರಣದ ಚಾಸವನ್ನು ಠಾಣೆಗೆ ಹಾಜರಾಗಿ ನೀಡಿದ ಲಿಖಿತ ದೂರನ್ನು ರಂತೆ ಕಲಂ 50 IPC ಪ್ರಕರಣದಲ್ಲಿ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಗೂ ಮೇಲಧಿಕಾರಿಗಳಿಗೆ ರವಾನಿಸಿರುತ್ತೇನೆ. ಅದೇ ದಿನ ಈ ಪ್ರಕರಣದ ತನಿಖೆ ಸಲುವಾಗಿ FTP ರವರಿಗೆ ನಿವೇದಿಸಿಕೊಂಡಿರುತ್ತೇನೆ. ಶ್ವಾನದಳ ಚಿತ್ರದುರ್ಗ ಇವರಿಗೆ ನಿವೇದಿಸಿಕೊಂಡಿರುತ್ತೇನೆ. ಸದರಿ FTP ರವರು ಹಾಗೂ ಶ್ವಾನದಳದವರು ಘಟನೆ ಸ್ಥಳಕ್ಕೆ ಬಂದಿದ್ದು ನಾನು ಸ್ಥಳಕ್ಕೆ ಹೋಗಿರುತ್ತೇನೆ. FTP ಕೆಲವು ಬೆರಳು ಮುದ್ರಣ ತೆಗೆದುಕೊಂಡಿರುತ್ತಾರೆ. ತಪಾಸ್
FTP ಪರ್ಸನಲ್
ತಗೊಂಡಿರ್ತಾರೆ. ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ. ಅವ್ರು ಹೇಳಿಲ್ಲ ನಾವು ತಗೊಂಡಿದೀವಿ ಅಂತ ಯಾರು ಬಂದು ಹೇಳಿಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ. FTP ಅವ್ರು ಯಾರು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ. ಅವ್ರು ಯಾರು ಕೋರ್ಟ್ ಮುಂದೆ ಹೇಳಿಲ್ಲ ಸರ್ ನಾವು ತಗೊಂಡೆ ಅಂತ ಹೇಳಿ ನಿವೇದಿ ಕೊಟ್ಟಿರ್ತಾರೆ.
ಈ ಸಾಕ್ಷ್ಯ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಎಲ್ಲಿಯಾದ್ರೂ ನೀವು
ಪೇಜ್ 50
FTP ಅವರು ಸ್ಥಳಕ್ಕೆ ಬಂದು ಬೆರಳು ಮುದ್ರೆ ತೆಗೆದುಕೊಂಡಿರುತ್ತಾರೆ ಎಂಬುದು ಸುಳ್ಳು ಅಂತ ನಿರ್ದಿಷ್ಟವಾದ ಅಲ್ಲಗೆಳೆಯುವಿಕೆ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ, ಅವರೇ ಹೇಳ್ತಾರೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. ಈ ಹಂತದಲ್ಲಿ ಆರೋಪಿತರು ಬೆರಳು ಹತ್ರ ಬಂದು ಯಾವ ಯಾವ ಸ್ಥಳದಿಂದ ತೆಗೆದಿರುತ್ತಾರೆ ಅಂತ ಕೇಳುತ್ತೇನೆ, ಇದನ್ನು ಹೇಳಲು ಬರುವುದಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಅವ್ರು ತಗೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳಿ ಇದು ಮಾಡಿದ್ದಾರೆ.
ಈಗಲೂ ಕೂಡ ನನ್ನ ಪ್ರಶ್ನೆಗೆ ಸರಿಯಾದ ಉತ್ತರ ಕೊಡ್ತಾ ಇಲ್ಲ. ಈ ಹಂತದಲ್ಲಿ ಆರೋಪಿತನ ಬೆರಳು ಮುದ್ರೆಗಳನ್ನು ಯಾವ ಯಾವ ಸ್ಥಳಗಳಿಂದ ತೆಗೆದಿರುತ್ತಾರೆ ಎಂದು ಕೇಳಿರುತ್ತಾರೆ, ಅದನ್ನು ಕೇಳಲು ಬರುವುದಿಲ್ಲ, ಇದನ್ನು ಕೇಳಲು ಬರುವುದಿಲ್ಲ. ಅದು ಜುಡಿಷಿಯಲ್ ಅಬ್ಸರ್ವೇಷನ್, ವಿಟ್ನೆಸ್ಸಿನ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲ. ನಾನು ನಿಮ್ಮನ್ನ ಕೇಳ್ತಾ ಇರೋದು, ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ ಹ್ಯಾಸ್ ಸ್ಟೇಟೆಡ್ ದಟ್ FTP people have collected some fingerprint impressions. Have you denied this statement of investigating officer that FTP people have obtained some fingerprint impressions?
ಘಟನೆ ನಡೆದ ದಿನವೇ ದೂರು ನೀಡುವುದಿಲ್ಲ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಘಟನೆ 3/6/2010 ನಡೆದಿರುತ್ತದೆ ಅಂದ್ರೆ ಹೌದು. ದೂರು ನೀಡಿರುವುದು 4/6/2010 ಬೆಳಗಿನ ಜಾವ 1 ಗಂಟೆ ಅಂದರೆ
ಇದನ್ನ ನೀವು ಓದ್ಕೊಂಡು ಬಂದಿಲ್ಲ, ಇಲ್ಲಿ ಕೂತಿ ತಯಾರು ಮಾಡ್ತಿದ್ದೀರಿ.
ಕೇಳಿದೆ ಸ್ವಾಮಿ. 5/6/2010 ಬೆರಳಚ್ಚು ಮುದ್ರೆ ತಜ್ಞರು ನಮಗೆ ಮಾಹಿತಿ ನೀಡುತ್ತಾರೆ ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇವೆ ಅಂದರೆ ಸರಿಯಿಲ್ಲ. ನಾವು FTP
ಬೇರೆ ಮಾಹಿತಿ ನೀಡಿರುತ್ತಾರೆ ಅನ್ನೋದನ್ನ ನೀವು ಡಿನೇ ಮಾಡಿದ್ದೀರಿ, ಬೆರಳಚ್ಚು ಇಂಪ್ರೆಷನ್ ಲಿಂದ ತೆಗೆದಿದ್ದಾರೆ ಅನ್ನೋದನ್ನ ಡಿನೇ ಮಾಡಿಲ್ಲ. ಅದು ಎರಡು ಬೇರೆ ಬೇರೆ ಆಕ್ಟ್ಗಳು
ಅಲ್ಲ. ನೀವು STP ರವರೊಂದಿಗೆ ಈ ಶರೀಕಾಗಿ ಸೃಷ್ಟಿ ಮಾಡಿರುತ್ತೀರಿ ಅಂತ ಸಜೆಷನ್ ಮಾಡಿದ್ರಿ.
Denial, specific denial and omnibus clause, are they not different things?
ಅಲ್ಲ, ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಇಸ್ ನಾಟ್ ಏಬಲ್ ಟು ಪ್ರೂವ್. ತಗೊಂಡಿದ್ದನ್ನೇ ಪ್ರೂವ್ ಮಾಡಿಲ್ಲ, ನಂದು ಕ್ವಶನ್ ಬರೋದೇ ಇಲ್ಲ, ಬೇಕಾಗಿಲ್ಲ ಸರ್. ದೇ ಫೇಲ್ ಟು ಪ್ರೂವ್. ತಗೊಂಡಿರೋದೇ ಪ್ರೂವ್ ಮಾಡ್ತಾ ಪ್ರೂವ್ನೇ ಮಾಡಿಲ್ಲ. ಯಾವಾಗ ತಗೊಂಡ್ರು, ಎಲ್ಲಿ ಸ್ಪಾಟ್ ಮಾಜಲ್ಲಿ ಇಲ್ಲ.
ಬಡ 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 ಹೇಳಬೇಡಿ, ನಿಧಾನವಾಗಿ ಹೇಳಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಸ್ಪಾಟ್
ತಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನಿಮ್ಮ ಪ್ರಕಾರ ಏನ್ ಮಾಡ್ಬೇಕು?
ಅವ್ರು ಸ್ಪಾಟ್ ಮಾಜರಲ್ಲಿ ತಗೊಂಡಿರೋದು ಬರ್ದಿರ್ಬೇಕು. ಇಂತ ಡೇಟ್ ವಿ ಹ್ಯಾವ್ ಟೇಕನ್ ಫ್ರಮ್ ದಿಸ್ ಪ್ಲೇಸ್ ಅಂತ ಹೇಳಿ ಅದು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ ಇಲ್ಲಿ.
ಸ್ಪಾಟ್ ಮರ್ಜರ್ ನಲ್ಲಿ ಬೆರಳು ಮುದ್ರೆ ಇದನ್ನ ಬರ್ದಿರ್ಬೇಕು.
ಅಲ್ಲ, ತಗೊಂಡಿದೀವಿ ಅನ್ನೋದನ್ನ ಎಲ್ಲೂ ಎಲ್ಲೂ ಇಲ್ಲ ಸ್ವಾಮಿ ರೆಕಾರ್ಡ್ಸ್ ನಲ್ಲಿ. ಯಾವ ದಿವಸ ಹೋಗಿ ಎಲ್ಲಿ ತಗೊಂಡ್ ಬಂದ್ವಿ ಅಂತ ಹೇಳೋದನ್ನ ತಗೊಂಡಿಲ್ಲ. ಅವ್ರು ತಗೊಂಡವ್ರನ್ನು ಕೂಡ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ ಕೋರ್ಟ್ ನಲ್ಲಿ. ಅವ್ರು ಯಾರು ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊ ಬರ್ತಾರೋ ಅವ್ರನ್ನು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ.
ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಬಂದಿರೋರ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಲಿಲ್ಲ. ನೀವು 2-3 ಒಟ್ಟಿಗೆ ಸೇರಿಸಿ ಹೇಳ್ತೀರಿ. ನಾನು ಒಂದೊಂದನ್ನೇ ಬಿಡಿಸ್ತಾ ಇದ್ರೆ ನೀವು ಉದ್ದೇಶ ಪೂರ್ವಕವಾಗಿ ಅದಕ್ಕೆ ಅವಕಾಶ ಕೊಡ್ತಾ ಇಲ್ಲ. ಯಾಕೆಂದ್ರೆ ನಿಮಗೆ ಪ್ರತ್ಯೇಕ ಘಟನೆಗಳಿಗೆ ಆನ್ಸರ್ ಇಲ್ಲ. ಒಟ್ಟಾರೆಯಾಗಿ ಹೇಳಿ ನಿಮಗೆ ಒಟ್ಟಿನಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮುಗಿಸ್ಬೇಕಾಗಿದೆ. ನಾನು ಅದಕ್ಕೆ ಬಿಡ್ತಾ ಇಲ್ಲ. ನಾನು ಅಂಶನ ಹಿಂಜಿ ನೋಡ್ತಿದ್ದೇನೆ. ಯಾಕೆಂದ್ರೆ ಇಟ್ ಇಸ್ ಅನ್ ಅಪೀಲ್ ಅಗೇನ್ಸ್ಟ್ ಕನ್ವಿಕ್ಷನ್. ನಿಮಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲದೆ ಇರಬಹುದು. I am interested that an innocent person should not be convicted unnecessarily. ನಿಮ್ಮ ಪ್ರಕಾರ ಫಿಂಗರ್ ಪ್ರಿಂಟ್ ಒಂದು ಜಾಗದಿಂದ ತೆಗಿಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ ಏನೇನು ಪ್ರೊಸೀಜರ್ ಫಾಲೋ ಮಾಡಬೇಕು, ಅದಕ್ಕೆ ಲೀಗಲ್ ಬ್ಯಾಕಿಂಗ್ ಏನಿದೆ?
Before
ಲಾಸ್ಟ್ ಟೈಮ್ ಇದು ಯಾವುದು ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿರಲಿಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ಇನ್ ಯುವರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಯು ಕನ್ಸಿಡರ್ಡ್ ದಟ್ fingerprint impression tallied, but your only single point argument was that merely based upon a fingerprint tallying opinion, a conviction cannot be pronounced. That was your single cent argument. Today you have come up with a different set of argument. I am not prohibiting you from taking that stand, but I am asking you to elaborate the point. ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಲಿ, ಇವನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಲಿ, ಅಲ್ಲಿಂದ ತಗೊಂಡಿದ ಸ್ವಾಮಿ ಅಂತೇನೋ ಹೇಳಲಿಕ್ಕೆ ಮುಂಚೆ ಇಂಥವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡುವುದು ಅವಶ್ಯಕ. ಫಿಂಗರ್ ಪ್ರಿಂಟ್ ನ ಇಂಪ್ರೆಷನ್ ಅನ್ನ ತಗೊಳ್ಬೇಕಾದ್ರೆ ಇಂತಿಂತ ಪ್ರೊಸೀಜರ್ ಫಾಲೋ ಮಾಡೋದು ಕಡ್ಡಾಯ ಅನ್ನೋದನ್ನ ಯಾವ ಆಧಾರದಲ್ಲಿ ಹೇಳ್ತಿದ್ದೀರಿ? ನಿಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ಲ ಫಿಂಗರ್ ಪ್ರಿಂಟ್ ನ ಯಾರು ತೆಗಿಬೇಕು, ಹೇಗೆ ತೆಗಿಬೇಕು, ಅದಕ್ಕೆ ಪ್ರೋಸೆಸ್ ಏನು ಮಾಡಬಹುದು, ನೀವು ನೋಡೇ ಇಲ್ಲ, ಗೊತ್ತೇ ಇಲ್ಲ. ಇಲ್ಲಿ ಸುಮ್ಮನೆ ಇಲ್ಲ ಅನ್ನೋದನ್ನಷ್ಟೇ ಹೇಳ್ತಾ ಇದ್ದೀರಿ ಹೊತ್ತು ಆ ಇಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಕಾನೂನಿನ ಬೆಂಬಲ ಏನು ಅನ್ನೋದನ್ನ ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ನಾನು ಪಾಯಿಂಟ್ ಮಾಡ್ತಿರೋದಲ್ಲಿ ನೀವು ಅದನ್ನ ಕೇಳಿ. ಕಾಯ್ತಿದ್ದೇನೆ ನಾನು.
For lifting fingerprint from the place, the prosecution has to prove that no other persons have entered that place before taking that chance fingerprint. That is not produced by the.
ಹೇಗೆ ಹೇಳ್ತೀರಿ ಅದನ್ನ ನೀವು? ಬೇರೆಯವ್ರು ಬಂದಿದ್ರು ಅಂತ ಹೇಗೆ ನೀವು ಡೌಟ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಿದ್ದೀರಿ? ಬೇರೆಯವ್ರು ಬಂದ್ರೆ ನಿಮ್ಮ ಕಕ್ಷಿದಾರನ ಫಿಂಗರ್ ಪ್ರಿಂಟ್ ಅಲ್ಲಿ ಹಾಕಿ ಹೋಗ್ಲಿಕ್ಕೆ ಆಗತ್ತೆಯೇ?
ಅಲ್ಲ, ಈಸ್ ಅನ್ habitual offender, my lord. Is MOB offender. His fingerprints is with the police.
ಗೊತ್ತಿಲ್ರಿ. ಈಗ ಬೇರೆಯವ್ರು ಬಂದಿದ್ದಾರೆ ಅಂದ್ರೆ ಇರೋ ಎವಿಡೆನ್ಸ್ ಡಿಸ್ಟ್ರಾಯ್ ಆಗಿದೆಯೇನು? ಹಾಗಾಗಿ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಎವಿಡೆನ್ಸ್, ಅವೈಲೇಬಲ್ ಎವಿಡೆನ್ಸ್ಗಳು ಡಿಸ್ಟ್ರಾಯ್ ಆಗಬಾರ್ದು, ಹಾಗಾಗಿ ಬೇರೆ ಯಾರು ಹೋಗ್ಬಾರ್ದು. ಎ ಪ್ರಿಕಾಷನರಿ ಗೈಡ್ಲೈನ್ಸ್.
ಅದು ಫಾಲ್ಸ್ ಇಂಪ್ಲಿಕೇಶನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನಮ್ಮ ಸಬ್ಮಿಷನ್.
ಫಾಲ್ಸ್ ಇಂಪ್ಲಿಕೇಶನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನೀವು ಬರೀ ಹೇಳಿದ್ರೆ ಸಾಲದು. ಯು ಶುಡ್ ಕ್ರಿಯೇಟ್ ಸಮ್ ಡೌಟ್. ಏನೋ ಸ್ಟೇಟ್ಮೆಂಟ್ ತಗೊಂಡ್ರೆ ಆಗಲ್ಲ, ಬಿಕಾಸ್ ದೇ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ ಸರ್ಟನ್ ಎವಿಡೆನ್ಸ್. ವೆನ್ ದೇ, ಈಗ ಅವ್ರು ಏನು ಎವಿಡೆನ್ಸ್ ಹಾಕ್ಲಿಲ್ಲ ಒಂದ್ ಲೆಕ್ಕ, ದೇ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಸಮ್ ಎವಿಡೆನ್ಸ್ ಇನ್ ಸಮ್ ಫಾರ್ಮ್.
That is not
created doubt in that evidence. A mere stating something which has got no basis at all is not sufficient. Your doubt must be a doubt which deserves some entertainment.
There is no difficulty for them to give evidence before the court when they have taken whom the person who taken examined before. There is no difficulty for them. It is clear, it creates doubt, my lord, that it is false.
ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ನಲ್ಲಿ ಎರಡು ಕನ್ವಿಕ್ಷನ್ ಸಫರ್ ಆದ್ರ ಮೇಲೆ ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ತಾವು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಅದನ್ನ ಇಷ್ಟು ಬಾಲಿಶವಾಗಿ ಮಾಡ್ಲಿದ್ರೆ ಸಾಧ್ಯವೇ? ನನಗೆ ಕಷ್ಟ ಇಲ್ಲ. ಇಷ್ಟು ವಕೀಲರುಗಳನ್ನ ನಾನು ಅವರ ಆಳಕ್ಕೆ ಹೋಗಿ ತೋಡಿ ಅವ್ರ ಬಾಯಿಂದ ಹೊಡಿಸೋದು ನನಗೆ ಅವಶ್ಯಕತೆ ಏನೇ ಇಲ್ಲ. ಆದ್ರೂ ನಾನು ಆ ಪ್ರಯತ್ನ ಮಾಡ್ತೇನೆ. ಯಾಕೆಂದ್ರೆ ನನಗಿಲ್ಲಿರೋದು ಯಾರು ನಿಂತಿದ್ದಾರೆ ಎದುರಿಗೆ ಅವರು ಮುಖ್ಯ ಅಲ್ಲ. ಏನು ಕೇಸ್ ಇದೆ, ಅಲ್ಲಿ ಯಾರು ಅಕ್ಯೂಸ್ಡ್ ಇರ್ತಾನೆ, ವೆದರ್ ಈಸ್ ಇನ್ನೋಸೆಂಟ್, ದಟ್ ಈಸ್ ಇಂಪಾರ್ಟೆಂಟ್. In that regard, only on the fond hope that if an accused were to be an innocent, he should not be punished. I am digging several aspects in your library and making you to make submission. ಅಷ್ಟೇ. ಪ್ರೊಸೀಡ್. ನಿಮಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲದ್ರೆ ನಾನು ಯಾತಕ್ಕೆ ಅಷ್ಟು ಪ್ರಶ್ನೆ ಮೇಲೆ ಹಾಕಿ. ಪ್ರೊಸೀಡ್. Yes, your point is that the person who extracted the fingerprint has not been examined. But I caution you one thing. A mere submission made in the argument on certain point which is not corroborated by explaining as to what is the basis for that submission, then the court which raised the judgment, starting from trial court up to the Supreme Court, has got two options. One, ignoring those submissions which have not been supported with any law or precedent, or recording those submissions, reflecting the same in the judgment, and adding its observation stating that except making a mere oral statement to that effect, learned counsel, despite the court repeatedly asking, did not take any pain of substantiating his statement with the support of either law or judicial precedent. These two options are there. I give you a liberty to choose either of these.
Make submission.
The submission be recorded.
No, next week I will make submission. I will research on this point. Your lordship's question I will answer kindly for me.
ನನ್ನ ಕಷ್ಟ ನೋಡಿ ಪ್ರತಿ ವಾರವೂ ನಾನು ಒಂದೊಂದು ಕ್ಲಾಸ್ ತಗೊಳ್ಬೇಕು. What is evidence? What is appreciation of evidence? How a fact is proved? Art of writing judgment, art of interpreting the argument of the learned counsel. ಇವೆಲ್ಲವನ್ನು ನಾನು ಪ್ರತಿ ದಿವಸ ತಿರುಗಿಸ್ತಿರ್ಬೇಕು. You are not prevented from taking all those defenses, but mere telling that this is not sufficient.
What I have to submit.
Yes, that's what I. ನೀವು ನೋಡ್ಕೊಂಡು ಬರಬೇಕು. ಲಾಸ್ಟ್ ಟೈಮ್ ನಿಮಗೂ ಕೊಟ್ಟಿದ್ದೇನೆ ಈ ಮ್ಯಾಟರ್ ನಲ್ಲಿ. You are not there. Your colleague was appearing in this matter. Your colleague was directed as to what he was required to look into and make submission. Ascertain the same from him. If he is not appearing, you are continuing and come prepared in that regard.
For obtaining fingerprints, for obtaining fingerprints.
ನಾನು ಹೇಳಲ್ಲ. Why should I once again reissue the question paper? Question paper has been given to you. You secure that question paper from your colleague. Learned counsels from both sides present. Learned counsel for the petitioner submitting that he wants to do some more research in the matter regarding the extraction of fingerprint and its proof in the court of law. Praise for some more accommodation in the matter. As prayed for, once again, the week's accommodation is granted. List this matter on 9/6/2022 on the top of the list.
Yes. Arguments number 46 are Nagendra Nayak, SCGP correspondent.
Yes, Mr. SCGP, your argument.
It is ready in this matter. It may be taken at 2:30, my lords. We are ready, my lords. We will go on with the matter. 2:30.
ಕೇಸ್ ಕರೆದಾಗ ಇಬ್ರು ಇರ್ಬೇಕು. ಯಾರು ಮ್ಯಾಟರ್ ಮಾಡ್ತಾರೋ ಅವರು ಇರ್ಬೇಕು. ಈಗ ನಿಮ್ಗೆ 2:30 ನಾನ್ ಕೊಡಬಲ್ಲೆ. I will be sitting here up to 4:45.
Yes.
But can the learned counsel on the other side spare his precious time? Who has waited till since morning till now? Yes, make that request. Madhyana antri.
ಅಲ್ಲ ಅದು ತೊಂದರೆ ಇಲ್ಲ. May I make one request?
Please.
Well, when I was discussing this issue with one of my colleagues, he informed me this honorable court has held that conductor is responsible in this similar situation, not the driver. Since you have not met the conductor as a party, driver is acquitted ಅಂತ ಯಾವ್ದು judgment ಇದೆ. I will information ನಿಮ್ಗೆ ಕೊಡ್ತೀನಿ. Otherwise you try ಅಂತ ಹೇಳಿದ್ರು.
ಇದರಲ್ಲಿ ಅವ್ರು 3 ಜನರು on the top of the bus ಹೋಗ್ತಾ ಇದ್ರು ಅಂತ ಯಾರ್ಯಾರು ಹೇಳಿದ್ದಾರೆ?
PW1 ಹೇಳಿದ್ದಾರೆ.
ಆ ಕಂಡಕ್ಟರ್ನು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು, PW1 ಹೇಳಿದ್ದಾರೆ. PW1 ಹೇಳಿ. PW1 ನಲ್ಲಿ, may I read that portion? That's
3 persons among the people sitting on the top died.
Yes. PW1 and PW12.
The conductor was examined.
Well, conductor, he was examined. I'll give PW number. PW5.
We have not suggested to PW5 that
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
There were travelers of the bus sitting on the top.
ಮಾಡಿಲ್ಲ.
But both the witnesses whom you are relying upon, PW1 and 12, who according to you have stated that some of the passengers
Top of it.
sitting on the top were treated as hostile.
Yes, they were treated as
hostile. Have you elicited anything, at least from the investigating officer, that it was only those 3 persons,
no, there is no
the alleged passenger sitting on the top who died?
No, in fact, in investigating officer, PW28 was not. Third line cross-examination. They have not even asked anything.
Then how come your alleged judgment, if any, that for the passenger traveling on the top, it would be the conductor's responsibility, but not of the driver?
But my submission is this.
That is one point. Second, here it is rash and negligent driving. 279.
Yes.
The conductor's responsibility not to allow the passenger to travel on sitting on the top of the bus.
Yes.
Is it connected with the correctness of the driving or not?
Probably.
Correctness of the driving.
Malad,
What is the proximity between those two or the direct nexus?
Malad, accident is not disputed.
That is true.
Malad, one of the judgment says the negligence has to be, it is not mere negligence. The negligence has to be relatable to the death. Culpability has to be there.
So that is true. That does not require any judgment.
Yes.
That is principle.
That is the principle. Here, my submission is probably if they had traveled inside the bus, then this accident would not have happened. This death would not have happened. I am not saying he is not liable for the accident, but not for 304A. Causing death. Another yes.
IO has not stated about. IO has not stated that the 3 persons who died.
No, he said about only one. Yes.
Conductor also is not.
Not stated.
Conductor has not been asked in his cross-examination, at least in the form of a suggestion. Look here, conductor, on the said day there were several passengers traveling on the top of the bus. No such suggestion was made to the conductor. In such a situation, only because one of the persons says that there were passengers traveling on the top of the bus and 3 persons dead were among those persons who were traveling on the bus. Ultimately, he was treated as hostile. How that can be considered as a proof to hold that the deceased 3 were those persons who were said to have been traveling on the
bus. In investigating officer evidence, he says, ನಾನು ಅಪಘಾತವಾದ ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ಭೇಟಿ ನೀಡಿದಾಗ ಅಲ್ಲಿ ಬಸ್ಸು ರಸ್ತೆಯ ಬಲಕ್ಕೆ ಅಡ್ಡಲಾಗಿ ಉರುಳಿ ಬಿದ್ದಿತ್ತು. ಬಸ್ಸಿನ ಸಂಖ್ಯೆ 70 K1 70 58 81 ಸದರಿ ಬಸ್ನ ಕೆಳಗೆ 3 ಜನ ಸಿಕ್ಕಿ ಹಾಕಿಕೊಂಡಿದ್ದಾರೆ. ಅವರು ಪಾದಚಾರಿಗಳಲ್ಲ. ಇಟ್ ಇಸ್ ನಾಟ್ ದೇರ್ ಕೇಸ್. ಆಮೇಲೆ
ಪಾದಚಾರಿಗಳಲ್ಲ ಅಂತ ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ಪಾದಚಾರಿಗಳಲ್ಲ ಅಂತ ಹೇಳಿ ಸಜೆಷನ್ ಬಂದಿದೆಯಾ? ಎವಿಡೆನ್ಸ್ ಇದೆಯಾ? ಇಲ್ಲ. ಮತ್ತೆ ಪಾದಚಾರಿಗಳಲ್ಲ ಅನ್ನೋ ಕನ್ಕ್ಲೂಷನ್ಗೆ ಆಧಾರ
ಅಲ್ಲ. ಅವ್ರು ಹೇಳ್ತಿರೋದು ಬಸ್ಸಲ್ಲಿ ಟ್ರಾವೆಲ್ ಮಾಡ್ತಿದ್ದವ್ರು ಅಂತ.
ಬಸ್ಸಲ್ಲಿ ಟ್ರಾವೆಲ್ ಮಾಡ್ತಿದ್ದವರು ಅಂತ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಹೇಳಲಿಲ್ಲ. 3 ಜನ ಬಸ್ಸಿನ ಕೆಳಗೆ ಸಿಕ್ಕಿ ಬಿದ್ದಿದ್ರು ಅಷ್ಟೇ. ಬಸ್ಸಿನ ಒಳಗಿದ್ದ 3 ಮಂದಿ ಅಥವಾ ಬಸ್ಸಿನ ಮೇಲಿದ್ದ 3 ಮಂದಿ ಏನು ಹೇಳಲಿಲ್ಲ. ಅಂತದ್ದು ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ಗೆ ನೀವು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅನ್ನು ಡೀಟೇಲ್ ತರಲಿಲ್ಲ. ಮಾಡಬೇಕಿತ್ತು ಡೀಟೇಲ್ ತರಲಿಲ್ಲ. ಮುಖ್ಯವಾಗಿ ಕಂಡಕ್ಟರ್ಗೆ ತರಬೇಕು. ಕಂಡಕ್ಟರ್ಗೆ ತರಲಿಲ್ಲ. ಸತ್ತೋದವರು 3 ಜನ ಆ ಬಸ್ಸಿನ ಮೇಲೆ ಕೂತು ಟ್ರಾವೆಲ್ ಮಾಡ್ತಾ ಇದ್ರು ಅನ್ಲಿಕ್ಕೆ PW1 ಹೇಳಿದ್ದಾನೆ ಅನ್ನೋದು ಬಿಟ್ಟರೆ ಬೇರೆ ಯಾವುದೂ ಇಲ್ಲ. ನೋಡೋಣ ರೆಸ್ಪಾಂಡೆಂಟ್. Counsel from both sides present and SCGP press to take up the matter at 2:30 PM. Call at 2:30 PM. Yes.
Hearing matters number 47. Okay, Aminullah. Yeah, Martina, amicus curiae.
for the petitioner, my lords.
Yes.
Lords, the brief facts of the case, according to the complainant, my lords, is that on 12/5/2008 at 2 p.m., the petitioner, being the lorry driver, was driving at a high speed in a rash and negligent manner from east to west near Chikkahalli village, T. Narsipura Road. Was driving the lorry from east to west side, hit the deceased, one Mr. Mahesh, who happened to fall down, sustained head injuries. Thereafter, he was admitted to JSS hospital. There he was declared dead on the next day, on 13/5/2008, my lords. There's also a mention that the lorry driver was driving without a valid license. Now, he was charge sheeted, the accused was charge sheeted under section 279(304A) of IPC and section 3(1), read with 181 of
Two
IMB.
eyewitnesses are there.
Please, my lords.
Two eyewitnesses. They are the main witnesses.
They are the main witnesses. Please.
Claim that they have seen the incident.
Please, my
And
lords.
PW1 has further stated that he has shifted the injured to the hospital.
Please, my lord.
Yes.
Lords, here.
PW2 stated.
PW2 stated.
Yes.
Please.
PW1
One
Alia.
is
Satwadhan Alia,
Alia.
company.
Please,
Yes.
my lords. Yes. But he was charge sheeted and the trial court has convicted him of these offenses and the appellate court has confirmed the judgment of the trial court. Now, the main defense which I would like to bring to your lordship is 4 points, my lords. First and the foremost thing, there are inconsistencies with the witnesses' evidence, my lords. I'll substantiate a little further. The second point which I would like to convey to your lordship is, my lords, the eyewitnesses have specifically stated in the witness, especially PW4, that he heard the accident. Thereafter, he went there. So that brings to the crucial point with respect to the definition of eyewitness. I will substantiate.
ನಾನು ಶಬ್ದ ಕೇಳಿ 10 ನಿಮಿಷಗಳ ನಂತರ ಸ್ಥಳಕ್ಕೆ ಹೋದೆ ಅಂತ ಹೇಳಲಿಲ್ಲ.
ಹೇಳಿಲ್ಲ.
ಶಬ್ದ ಆಗ್ತಾ ಆಗ್ತಾನೆ ತಿರುಗಿ ಬೀಳ್ತಾರೆ. ಒಂದು ಸಣ್ಣ ಉದಾಹರಣೆ ನಿಮ್ಮನ್ನ ಕೇಳ್ತೇನೆ. ನಿಮ್ಮ ಅಡಿಗೆ ಮನೆಯಲ್ಲಿ ನೀವು ಅಡಿಗೆ ಮನೆಯಲ್ಲಿ ಸ್ಟವ್ ಎದುರು ಏನೋ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀರಿ, ಒಗ್ಗರಣೆ ಹಾಕ್ತಾನೋ ಏನೋ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀರಿ. ಹಿಂದ್ಗಡೆ ಡಬ್ಬಿ ಬಿದ್ದ ಶಬ್ದ ಕೇಳ್ತದೆ ನಿಮ್ಗೆ.
ಪ್ಲೀಸ್.
ಸ್ಟೋರ್ ರೂಮ್ ನಲ್ಲೋ ಅಥವಾ ಅಡಿಗೆ ಮನೆಯಲ್ಲ ಇನ್ನೊಂದು ಸೈಡ್ ನಲ್ಲಿ ಒಂದು ಡಬ್ಬಿ ಬೀಜ ಶಬ್ದ ಕೇಳ್ತದೆ. ಡಬ್ಬಿ ಬೀಜ ಶಬ್ದ ಕೇಳಿದ ಕೂಡಲೇ ನೀವು ತಿರುಗಿ ನೋಡ್ತೀವಿ.
ಪ್ಲೀಸ್.
ಬೆಕ್ಕು ಕಿಟಕಿಯಿಂದ ಹೊರಗಡೆ ಓಡಿ ಹೋಗಿ ನೀವು ಏನ್ ಕನ್ಕ್ಲೂಷನ್ಗೆ ಬರ್ತೀವಿ?
ಅಲ್ಲ, what I would like to say is, ಡಬ್ಬಿ ಬಿದ್ದದನ್ನ ನಾನು ನೋಡಿಲ್ವಲ್ಲ, ಸೊ ಬೆಕ್ಕೆ ಮಾಡಿ ಬಿದ್ದಾಯ್ತು, ಬೀಳ್ಬೇಕಾದ್ರೆ ನೋಡಿಲ್ಲ.
ಕರೆಕ್ಟು. ನಿಮ್ಮ ಪ್ರತಿಕ್ರಿಯೆ ಹೇಗಿರುತ್ತೆ ಆ ಸಂದರ್ಭದಲ್ಲಿ? ನೀವಾಗೊಂದು ಕೇಸಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿದ್ದೇನೆ, ಹಾಗಾಗಿ ನಾನು ರಿಯಾಕ್ಷನ್ ಅನ್ನ ಬೇರೆ ರೀತಿ ಫ್ರೇಮ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದನ್ನ ಬಿಡಿ.
Please, my lord, I am trying my best to protect this petitioner. How much soever I know, it's very evident, my lord, that if the lorry has hit and he has died because of the lorry. But I am doing my best as a petitioner. So what I would like to say is, since he has heard and not seen, basically eyewitness andre eno, eyewitness andre the ingredients, it should be present, my lords, that he was eyewitness only means he has seen an occurrence of the witness and then he substantiates and tells it. So I will just come to that. My third point is that, my lord, the lower court has failed to observe that there is no cogent evidence which is adduced by the prosecution to convict the accused, my lords. That also I will substantiate that he has to, the ingredients are important. Rash and negligent manner andaga ondishtu ingredients ide which has to be proved beyond reasonable doubt, and that's where I would like to substantiate a little further. Further, my lords, the fourth point being, PW1 and PW2 have PW2 and 4, the main eyewitnesses, have stated that they have seen the incident from a far off distance, which is 200 feet or 300 feet anta heltare, which is unbelievable for a person, a prudent man, to know that he is the driver and he has hit the, I mean, he's a lorry driver who ran away and all that. It is little unbelievable to witness.
Has not PW2 stated that after hitting Mahesh,
please, my lords,
the lorry moved a little bit further and stopped there? The driver was there for some time.
And then he ran.
After the people gathered there, he ran away from the place.
Please, my lords, but he has not mentioned that he went there and saw the driver also at the same time. He has told, from what he has seen from 100 feet or 200 feet, he has told. But he has also not told that he went there and then he saw the driver ran away. That is mine. Well, it's first and the foremost with respect to inconsistencies, what I would like to say is, again, the evidence of PW2, if I may be permitted to read. ಚಾಸ 5 ನನ್ನ ಸ್ನೇಹಿತ ಸುಮಾರು 1 ವರ್ಷ 7 ತಿಂಗಳ ಹಿಂದೆ ಬಂದು ಒಂದು ದಿನ ಮೇ 2 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನಾನು ಚಾಸ 5ರವರ ಮೋಟಾರ್ ಸೈಕಲಿನ ಹಿಂಭಾಗದಲ್ಲಿ ಕೂತುಕೊಂಡು ಮೈಸೂರು ಕಡೆಗೆ ಟಿ ನರಸೀಪುರ ಮೈಸೂರು ರಸ್ತೆ ಎಡಭಾಗದಲ್ಲಿ ಬರುತ್ತಿದ್ದಾಗ ನಮ್ಮ ಮುಂಭಾಗದಲ್ಲಿ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಮೈಸೂರು ಕಡೆಗೆ ರಸ್ತೆ ಎಡಭಾಗದಲ್ಲಿ ಮೋಟಾರ್ ಸೈಕಲ್ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಹೋಗುತ್ತಿದ್ದರು. ಆ ಸಮಯದಲ್ಲಿ ಮೈಸೂರು ಕಡೆಯಿಂದ ಒಂದು ಲಾರಿಯನ್ನು ಅದರ ಚಾಲಕ ವೇಗವಾಗಿ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬಂದು ನಮ್ಮ ಮುಂದೆ ಹೋಗುತ್ತಿದ್ದ ಸದರಿ ಮೋಟಾರ್ ಸೈಕಲಿಗೆ ಡಿಕ್ಕಿ ಮಾಡಿತು. ಪರಿಣಾಮವಾಗಿ ಮೋಟಾರ್ ಸೈಕಲಿನ ಸವಾರ ಕೆಳಗೆ ಬಿದ್ದು ಆತನ ಕೈ ಕಾಲುಗಳಿಗೆ ಪೆಟ್ಟಾಗಿರುತ್ತದೆ. ಲಾರಿಯನ್ನು ಅದರ ಚಾಲಕ ಸ್ವಲ್ಪ ದೂರವರೆಗೂ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಹೋಗಿ ನಿಲ್ಲಿಸಿದ. ಸ್ಥಳದಲ್ಲಿ ಲಾರಿ ಚಾಲಕ ಸ್ವಲ್ಪ ಹೊತ್ತು ಇದ್ದು ಜನ ಸೇರಿದ ನಂತರ ಆತ ಓಡಿ ಹೋಗುತ್ತಾನೆ. ಸದರಿ ಲಾರಿ ಚಾಲಕನನ್ನು ನಾನು ನೋಡಿದ್ದು ಆತ ನ್ಯಾಯಾಲಯದ ಮುಂದಿರುವ ಆರೋಪಿಯಾಗಿರುತ್ತಾನೆ. ಗಾಯಾಳುವನ್ನು JSS ಆಸ್ಪತ್ರೆಗೆ ಸೇರಿಸುತ್ತದೆ. ನಂತರ ಅದೇ ದಿನ ಸಂಜೆ 4:15 ಗಂಟೆಗೆ ಸಮಯದಲ್ಲಿ ಪೊಲೀಸರ ಜೊತೆ ಅಪಘಾತವಾದ ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ನಾನು
read the cross examination.
ಈ ಅಪಘಾತಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಪೊಲೀಸರಿಗೆ ಹೇಳಿ ನೀಡಿದ್ದೇನೆ. ನಾವು ರಸ್ತೆಯ ಎಡಭಾಗದಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದೆವು. ನಮ್ಮ ಮುಂದೆ ಇನ್ನೊಂದು ವಾಹನ ಹೋಗುತ್ತಿದ್ದಾಗ ಅಲ್ಲಿ ಲಾರಿ ಬಂದು ಡಿಕ್ಕಿ ಮಾಡಿತು ಎಂದು ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಲು ತೊಂದರೆ ಇರಲಿಲ್ಲ. ಮೃತ ಮಹೇಶ ನನ್ನ ಪರಿಚಯಸ್ಥ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಗಾಯಾಳುವಿನ ಹೆಸರು ನನಗೆ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಗೊತ್ತಾಯಿತು. ಟಿ ನರಸೀಪುರ ರಸ್ತೆಯಲ್ಲಿ ತುಂಬಾ ವಾಹನಗಳು ಚಲಿಸುತ್ತವೆ ಎಂದರೆ ಅಪಘಾತವಾದ ಸಮಯದಲ್ಲಿ ಲಾರಿ ಮತ್ತು ನಮ್ಮ ಮೋಟಾರ್ ಸೈಕಲ್ ಬಿಟ್ಟರೆ ಬೇರೆ ವಾಹನಗಳು ಬಂದಿರುವುದಿಲ್ಲ. ನನ್ನ ಮೋಟಾರ್ ಸೈಕಲ್ ಮತ್ತು ಅಪಘಾತಕ್ಕೀಡಾದ ಮೋಟಾರ್ ಸೈಕಲ್ ನಡುವೆ ಸುಮಾರು 100 ಅಡಿ ಅಂತರ ಇತ್ತು. ನಾನು ಲಾರಿಯನ್ನು ಮೊದಲ ಸಾರಿ ನೋಡಿದಾಗ ಅದು ಸುಮಾರು 100 ಅಡಿ ದೂರದಲ್ಲಿ ಬಂದಿತ್ತು. ಸದರಿ ವಾಹನಗಳು ಬರುತ್ತಿದ್ದ ವೇಗವನ್ನು ನನಗೆ ನಿಖರವಾಗಿ ಹೇಳಲು ಸಾಧ್ಯವಿಲ್ಲ. ನಾನು ಅಪಘಾತವನ್ನು ನೋಡಿದ್ದೇನೆ ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ನಿಶಾನೆ P2ಕ್ಕೆ ನಾನು ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಸಹಿ ಮಾಡಿದ್ದೇನೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಮಹೇಶ್ ನನ್ನ ಊರಿನವನಾದ ಕಾರಣ ಚಾಸ 5ರವರ ಚಿತಾವಣೆಯಲ್ಲಿ ಮೇರೆಗೆ ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಮಹೇಶ್ ನನ್ನ ಊರಿನವನು ಎಂದು ನನ್ನ ಹೇಳಿಕೆಯಲ್ಲಿ ಹೇಳಿದ್ದೇನೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಮೃತ ಕುಟುಂಬವರಿಗೆ ಸಹಾಯವಾಗಲಿ ಎಂದು ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಹೇಳುವುದು ಸರಿಯಲ್ಲ. Let's hear, this is his version of it.
His evidence to the effect.
Evidence.
After the accident, his evidence in examination chief that after the accident, the lorry came to a stop. The driver was there for some time. After the people gathered, the driver ran away from the place. I have seen the driver. I identify that the present accused was the driver who was driving the lorry on the said day. All these statements, whether has been denied in his cross-examination.
Not cross-examined properly at all.
Next point.
And then, Manoj, I'll go to the PW4 evidence. Manoj.
Yes.
Here, I would like to read the. Manoj, before that, I would want to read the affidavit also, wherein one I want to bring to your lordship's notice here, Manoj. 6th line in the statement. ಆ ಸಮಯದಲ್ಲಿ ನಾನು ಮತ್ತು ಚಾಸ 4 ಸೇರಿ ಮೋಟಾರ್ ಸೈಕಲ್ ನಲ್ಲಿ 2 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನಂಜನಗೂಡಿನ ಮೈಸೂರು ಕಡೆಗೆ ಬರುತ್ತಿದ್ದಾಗ ನಮ್ಮ ಮುಂಭಾಗದಲ್ಲಿ ಅಂದರೆ 200-300 ಅಡಿ ಅಂತರದ ದೂರದಲ್ಲಿ ಮಹೇಶ್ ಅವರ ಸ್ಪ್ಲೆಂಡರ್ ಮೋಟಾರ್ ಸೈಕಲ್ ನಲ್ಲಿ ರಸ್ತೆ ಎಡಭಾಗದಲ್ಲಿ ಹೋಗುತ್ತಿತ್ತು. ಆ ಸಮಯದಲ್ಲಿ ಮೈಸೂರು ಕಡೆಯಿಂದ ಟಿ ನರಸೀಪುರದ ಕಡೆ ಒಂದು ಲಾರಿಯನ್ನು ಅದರ ಚಾಲಕ ವೇಗವಾಗಿ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬಂದು ಮಹೇಶ್ ಅವರ ಮೋಟಾರ್ ಸೈಕಲ್ಗೆ ಡಿಕ್ಕಿ ಮಾಡಿ ನಂತರ, ದಿಸ್ ಇಸ್ ವೇರ್ ಐ ವಾಂಟ್ ಟು ಎಂಫಸಿಸ್, ನಂತರ ಲಾರಿಯು ಬಲಗಡೆಗೆ ಇರುವ ಮರಕ್ಕೆ ಡಿಕ್ಕಿ ಹೊಡೆದಿದೆ. ಸೊ ಪರಿಣಾಮವಾಗಿ child skip. So what I was trying to emphasize here is, which prakara it has gone there and they are saying he has gone to the right and hit, but that is not the case. According to their own evidence, he was going on the right, on his lane only, my lords.
ಅವನು ದಾರಿಯಲ್ಲೇ ಇದ್ದ, ದಾರಿ ತಪ್ಪಿದ ಮಗ ಆಗಿರ್ಲಿಲ್ಲ ಅನ್ನೋದನ್ನ ತೋರಿಸ್ತೀರಿ.
300 ಅಡಿ ನಂತರ ದೂರದಲ್ಲಿ ಮಹೇಶ್ ಅವರು ಸ್ಪ್ಲೆಂಡರ್ ಮೋಟಾರ್ ಸೈಕಲ್ ನಲ್ಲಿ ರಸ್ತೆಯ ಎಡಭಾಗದಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದರು. ಆ ಸಮಯದಲ್ಲಿ
ಡಿಸೀಸ್ಡ್ ವಾಸ್ ರೈಡಿಂಗ್ ಆನ್ ದಿ ಲೆಫ್ಟ್ ಸೈಡ್ ಆಫ್ ದಿ ರೋಡ್.
ಪ್ಲೀಸ್
ಮುಂದೆ.
ಆ ಸಮಯದಲ್ಲಿ ಮೈಸೂರು ಕಡೆಯಿಂದ ಟಿ ನರಸೀಪುರ ಕಡೆಗೆ ಒಂದು ಲಾರಿಯನ್ನು ಅದರ ಚಾಲಕ ವೇಗವಾಗಿ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬಂದು ಮಹೇಶ್ ಅವರ
ಫ್ರಮ್ ದಿ ಆಪೋಸಿಟ್ ಡೈರೆಕ್ಷನ್
ಬಂದು ಮಹೇಶ್ ಅವರ ಮೋಟಾರ್ ಸೈಕಲ್ಗೆ ಡಿಕ್ಕಿ ಮಾಡಿ
ಸ್ಟಾಪ್ ಹಿಯರ್ ಬಂದು ಮಹೇಶ್ ಅವರ ಮೋಟಾರ್ ಸೈಕಲ್ಗೆ ಡಿಕ್ಕಿ ಮಾಡಿ. ಸೊ undisputedly, admittedly, that lorry was coming from the opposite
direction. Please,
this person witness has stated Mahesh was on his extreme left side on his motorcycle.
Extreme illa ಎಡಭಾಗ
on his left side.
It
ರಸ್ತೆ ಎಡಭಾಗದಲ್ಲಿ ಹೋಗ್ತಾ ಇರ್ಬೇಕಾದ್ರೆ ಎದುರುಗಡೆಯಿಂದ ಬರ್ತಾ ಇರ್ತಕ್ಕಂತ ವಾಹನ ಮಹೇಶ್ ಅವರು ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ಗೆ ಹೋಗಿ ಡಿಕ್ಕಿ ಹೊಡೆಯಿತು. ಅಂದರೆ ಆ ಲಾರಿ ಬಲಗಡೆಗೆ ಬರಲೇಬೇಕು ತಾನೆ. ಇವನು ರಸ್ತೆ ಎಡಭಾಗದಲ್ಲಿ ಇದ್ದಾನೆ, ಅದು ಮಿಡ್ ಲೈನ್ ದಾಟಿ ಬಲಬದಿಗೆ ಬರಲೇಬೇಕು.
That is not substantiated here, but it means it can be construed that
inference that can be drawn. ರಸ್ತೆ ಎಡಭಾಗದಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ದವರು ಎದುರುಗಡೆಯಿಂದ ಬಂದು ವಾಹನ ಬಂದು ಹೊಡಿತು ಅಂದ್ರೆ ಆ ವಾಹನ ಎದುರುಗಡೆಯಿಂದ ಬಂದು ವಾಹನ ಅದು ರಸ್ತೆಯ ಬಲಭಾಗಕ್ಕೆ ಬಂದು ಹೊಡಿತು.
ಹಂಗಿದ್ರೆ
ನೋಡಿ sketch.
Please my lords, I am aware of that. What I was trying to emphasize to your lordship is ನಂತರ when he is saying ನಂತರ ಲಾರಿ ಬಲಗಡೆಗೆ ಇರುವ ಮರಕ್ಕೆ ಹೋಗಿ, ಸೊ
ಬಲಕ್ಕೆ ಬಂದು ಇವನು ಡಿಕ್ಕಿ ಹೊಡೆದ್ರ ಮೇಲೆ ಬಲಗಡೆ ಇರೋ ಮರಕ್ಕೆ ಹೋಗಿ ಡಿಕ್ಕಿ ಹೊಡೀತು. ಇಲ್ಲದೆ ಹೋದ್ರೆ ನಂತರ ಲಾರಿ ಹೋಗಿ ಮರಕ್ಕೆ ಡಿಕ್ಕಿ ಹೊಡೆಯಿತು ಅಂತಿದ್ರೆ ಬುದ್ಧಿವಂತ ವಕೀಲರಿದ್ದವರು ಸ್ವಾಮಿ ಆ ಮರ ರಸ್ತೆ ಎಡಭಾಗದಲ್ಲೂ ಇರಬಹುದು ತಾನೆ, ಆ ಸಾಧ್ಯತೆನೂ ಇದೆ ಅಲ್ವೇ? ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ ಆಗ್ಲಿ ಸಾಕ್ಷಿ ಆಗ್ಲಿ ಆ ಮರವು ಕೂಡ ರಸ್ತೆಯ ಎಡಭಾಗದಲ್ಲಿ ಅಂದ್ರೆ ವಾಹನದ ಲಾರಿಯ ಬಲಭಾಗದಲ್ಲಿ ಇತ್ತು ಅಂತ ಹೇಳಲಿಲ್ಲ ಅಂತಿದ್ರು. ಅದಕ್ಕೆ ಆನ್ಸರ್ ಅವನು ಎವಿಡೆನ್ಸ್ ನಲ್ಲೇ ಬಂದಿದೆ.
Please my lords. And then his cross examination where he says ನಾನು ಮೊದಲನೇ ಬಾರಿಗೆ ಮಹೇಶನನ್ನು ನೋಡಿದಾಗ ಆತ ನನ್ನ ಮುಂಭಾಗದಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದರು. ಲಾರಿ ಡಿಕ್ಕಿ ಮಾಡಿದ ಶಬ್ದ ಕೇಳಿ ನಂತರ ನನಗೆ ಅಪಘಾತವಾಯಿತು ಎಂದು ತಿಳಿಯಿತು. ಲಾರಿ ಡಿಕ್ಕಿ ಮಾಡಿ ರಸ್ತೆಯ ಬಲಭಾಗದ ಮರಕ್ಕೆ ಡಿಕ್ಕಿ ಮಾಡಿತು ಎಂದು ಪ್ರಥಮವಾಗಿ ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿ. ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಕೆ ನೀಡಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಲಾರಿ ಮತ್ತು ಮೋಟಾರ್ ಸೈಕಲ್ ಯಾವ ವೇಗದಲ್ಲಿ ಬರುತ್ತಿದ್ದು ಎಂದು ನನಗೆ ಹೇಳಲಾಗವಲ್ಲ. ನಾನು ಆ ದಿನ ಅಪಘಾತದ ಸ್ಥಳದಲ್ಲಿ ಇರಲಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಮೃತ ಮಹೇಶನ ಕುಟುಂಬವರಿಗೆ ಸಹಾಯ ಮಾಡಲು ಉದ್ದೇಶ ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾವು ಹಿಯರ್ ಮೈ ಲಾರ್ಡ್ಸ್
ಹಂಪುಗಳು ಇರ್ತದೆ ಅಲ್ವೇ?
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್ಸ್.
ಸ್ಪೀಡ್ ಬ್ರೇಕರ್ ಇರ್ತದೆ.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್ಸ್.
They will break the speed. No, I will give a break.
Please.
2:30 first matter you will take.
Please, ma'am.
Next part is also final hearing. There is no chances for me to.
No, this hardly take another 7 to 8 minutes. She is concluding her argument in another couple of minutes. Prosecution may take 5 minutes. Last time the top of the list ಅಂತೇಳಿ ಹಾಕ್ಸಿತ್ತಲ್ರಿ. ನಿಮಗೆ ಏನಾದ್ರು ಅನಾನುಕೂಲತೆ ಇದೆಯಾ ಮಧ್ಯಾಹ್ನಕ್ಕೆ? ನಾಡಿದ್ದು ಹಾಕೊಳ್ಳೋಣವಿ. 8 ಕೂಡ 3 ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಇದೆ. ಮಾಡಿ. Yes. Learned counsel from both sides present. Learned counsel for the petitioner submits that since he has got one more matter in before another bench this afternoon, a short accommodation as prayed is granted. List this matter on 8/6/2022 as prayed on the top of the list. Yes. Yes.
ರಿಮೂವ್ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಮಾಡಕ್ಕಾಗಿಲ್ಲ ದಯವಿಟ್ಟು ಪ್ಲೀಸ್ ಮೈ ಡ್ಯೂಟಿ ಮೈ ಲಾರ್ಡ್ಸ್.
Other matters. Number 1. Did Krishnappa? Did you approach the register after 6 weeks?
No.
They say that you approached them after 6 weeks, that is after the expiry of the time for complaints of office objection.
My lord, the earlier council may have. I have filed the wakalat as I submitted in the morning. Before your lordships. Pardon?
I do not know that you are subsequent advocate and what advocate does. You are before me the advocate for petitioner. It is for you to ascertain what your predecessor has done. You cannot say that you do not know somebody else have done. But ultimately now you want to comply office objection.
Please.
Yeah.
Please.
At the request of the Learned Counsel for the petitioner, a week's time as period is granted to comply of subjection. List the matter immediately after compliance of subjection. Number 37.
Petitioner.
Brother Naik. Sorry. You have no objection for withdrawal. Learned counsels from both sides called again. Learned counsels from both sides in both the matters are physically present. Learned counsel for the petitioner in both the matter files separate memos seeking permission to withdraw the petition as not pressed. The counsel for the respondent submits their no objection to consider the memo as read. In view of the memo supporting submission from both sides, both these petitions stands dismissed as not pressed. In view of disposal of the main petition, the pending IA number 1/21 in both these matters, responsible for consideration. Yes.
Serial number 47, NK Aminullah, NK Skuri, A. Marchana.
Yes, please.
My lords, coming to the final leg of my argument, my lords, where the trial courts have failed to observe that there is no cogent evidence adduced by the prosecution to convict the accused. My lords, the material ingredients required have not been proved beyond reasonable doubt. So that's when it comes to negligence and rash and negligent driving. The negligence has 4 elements or ingredients to it, my lords. First is the duty. Second is there is a breach of duty. And then there must be a statutory, there must be an action causing it. And finally, the damages. Well, let's hear the duty as per what the petitioner had to do. He was right. He knew driving and he was driving. The breach of duty here has not been proved, where they have not mentioned ella evidence. They mentioned Vegavadi. How was he rash or negligent? Nowhere has it been mentioned. Firstly, Manoj. Secondly, there is a breach of duty which has caused this. Secondly, the action of the accident, Manoj. No doubt, it has caused certain damages. I agree. But the breach of duty part of it has not been substantiated or corroborated with any evidence other than they stating our evidence Vegavagi, one word bitre. Vega is nothing but just speed. It does not mean rash and negligent. And as your lordship is well aware of Cherubian Gregory versus State of Bihar, which clearly mentions the difference between negligence and rashness, where the state of mind, it doesn't foresee the consequence and negligence, whereas rash, it can foresee and still ignore it. So coming to that part of it, my lords, where here is my lords, section 304A talks about a situation where death of a person must be a direct result of the action of the accused. But this is where the principle of causa causans comes, my lords. That is the principle which talks about the immediate cause of any act, my lords. So here it is defined as the last link in the chain of action causing that event. And let's hear it also talks about the immediate cause of action and the remote cause of action. That is what I would like to submit to your lordship here. So to differentiate and to determine the immediate and the immediate cause of action and the remote cause of action, my lords, it is based on the reasonability of the prudent person. So it includes the act which a prudent person can see. Here, firstly, the evidence, the PW2, neither PW2 or PW4 has directly evidence and seen the accident occur. As your lordship previously mentioned, they make a mention of the motorcycle rider being on the left side. But what happened at the time of the accident? They have not mentioned that it is left to interpretation, my lords. They have not mentioned that the lorry went to the right hand. They say it is collided head on.
Yes, please proceed.
Based on these ingredients, my lords, I would like to say that there was no rash and negligent. No doubt an accident has occurred, but it does not mean that he intended to do it. My lords, there is one Supreme Court citation which is Balachandra Vaman Pate versus the state of Maharashtra, my lord, where a similar situation has occurred, where pedestrians, two sisters, were crossing the road, and a lorry driver happened to hit the sisters, and one of them succumbed to injuries, the other passed away. So where the Supreme Court has specifically mentioned that there was negligence in this, but there was no rashness, which was rashness was not elicited or it was not noted. So based on these circumstances, I pray that this Honorable Court I may be permitted to pass this citation.
Yes, Mr. CGP. Indian Congress. Yes.
May I read?
So according to this judgment,
Please, my lords.
in a similar circumstance, according to you, there was negligence, but rashness is not true.
It's not true. my
Not
lords. In my case,
Whether to attract 304A, both rashness and negligence are required.
or
Any one of them.
specifically, please, my lords, that is well noted. But in my case, negligence alone, it is not been proved. Of course, accident has occurred. Nobody is denying it.
ಹೌದು ಎಡಗಡೆ ಇರೋ ಲಾರಿ ಪೂರ್ತಿ ಬಲಗಡೆ ಹೇಗೆ ಬರ್ತದೆ?
My lord, that is
Banamati.
after the incident. My lords, to be very clear, in the evidence, or ಹೇಳೋದು ಡಿಕ್ಕಿ ಹೊಡೆದ ನಂತರ ಹೋಗಿದೆ. It could be the impact. They are not specifically saying this lorry has gone to the right side. That is my submission here. After the collision, it has moved to the right. It is left to interpretation, my lords, because they do not mention, I saw it, that the lorry has gone to the right, and if it was so, they would have mentioned is what the prudent mind says.
Yes, Mr. CGP.
Two eyewitnesses to the incident, my lords.
Yes.
PW 2 and 4.
Yes.
That's the evidence of both these witnesses, my lords, corroborates with each other.
Yes.
And there are no discrepancies in the evidence of these witnesses, my lords. Both the witnesses, my lords, deposes supporting the case of the prosecution.
Yes.
May I read my learned friend has already read the evidence of PW 2 and 4. My lords, I will only read the relevant sentences, my lords. I will not, yes, my lords, I will not trouble much of your lords.
Yes.
The evidence of PW 2. My lords, ಆ ಸಮಯದಲ್ಲಿ ಮೈಸೂರು ಕಡೆಯಿಂದ ಒಂದು ಲಾರಿಯನ್ನು ಅದರ ಚಾಲಕ ವೇಗವಾಗಿ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬಂದು ನಮ್ಮ ಮುಂದೆ ಹೋಗುತ್ತಿದ್ದ ಸದರಿ ಮೋಟಾರ್ ಸೈಕಲ್ ಡಿಕ್ಕಿ ಮಾಡಿತು. ಪರಿಣಾಮವಾಗಿ ಮೋಟಾರ್ ಸೈಕಲ್ ಸವಾರ ಕೆಳಗಡೆ ಬಿದ್ದು ಮತ್ತು ಆತನ ಕೈಕಾಲುಗಳಿಗೆ ಪೆಟ್ಟಾಗಿರುತ್ತದೆ. ಲಾರಿಯನ್ನು ಅದರ ಚಾಲಕ ಸ್ವಲ್ಪ ದೂರದವರೆಗೆ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಹೋಗಿ ನಿಲ್ಲಿಸಿದ ಸ್ಥಳದಲ್ಲಿ ಸದರಿ ಚಾಲಕ ಸ್ವಲ್ಪ ಹೊತ್ತು ಇದ್ದು ಜನ ಸೇರಿದ ನಂತರ ಆತ ಓಡಿ ಹೋಗಿರುತ್ತಾನೆ. ಸದರಿ ಲಾರಿಯ ಚಾಲಕನನ್ನು ನಾನು ನೋಡಿದ್ದು ಆತ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವ ಆಗಿರುತ್ತಾರೆ. ಗಾಯಾಳವನ್ನು ಜೇಸಿಸ್ he has also identified the witness, he also speaks about the rash and negligent driving, and he also supports the case of the prosecution. The PW4, another eyewitness to the incident, he also deposes in the same manner and supports the case of the prosecution. So the PW4, though these witnesses were cross-examined at length, nothing was elicited in the evidence of these two witnesses to disbelieve the case of the prosecution. Let's see, on the other hand, the complainant PW1, he also supports the case of the prosecution. And this evidence also corroborates with the evidence of the investigation officer who conducted the investigation and filed the charge sheet, that is PW6. So therefore, my lord, this evidence, my lord, so corroborates with the evidence of my lord, the doctor, my lord, they conducted the my lord, autopsy on the deceased. My lord, the doctor also says, my lord,
So by the time PW4, even according to him, saw the accident has already happened. Can, after seeing the post-accident scenario, can he claim himself to be an eyewitness to the incident?
ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಚಾಲನೆ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ರು, ನೋಡಿದ್ವಿ ಅನ್ನೋ ತರನೇ ಚಾಲನೆ ಮಾಡಿ.
Cross examination ನೋಡಿ, page number 2, second line from the top.
The evidence of PW2.
PW4.
PW4, my lord. ನಾನು ಮೊದಲ ಬಾರಿಗೆ ಮಹೇಶ್ನನ್ನು ನೋಡಿದಾಗ ಆತ ತನ್ನ ಮುಂಭಾಗದಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದರು. ಲಾರಿ ಡಿಕ್ಕಿ ಮಾಡಿದ ಶಬ್ದ ಕೇಳಿದ ನಂತರ ನನಗೆ ಆಘಾತವಾಯಿತು ಎಂದು ತಿಳಿಯಿತು. ಅಪಘಾತವಾಯಿತು ಎಂದು ತಿಳಿಯಿತು.
ಅಂದ್ರೆ ಇವರಿಗೆ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ ಅಂತ ಗೊತ್ತಾಗಿದ್ದೆ, ಲಾರಿ ಡಿಕ್ಕಿ ಆದ ಶಬ್ದ
ಕೇಳಿದ್ದೇನೆ.
ಆಮೇಲೆ ನೋಡಿದ್ದಾರೆ ಇವರು. Can he be an eyewitness?
Evidence, my lords, of PW2, my lords, have to consider. Let's when the accused, my lords, was examined at
for the petitioner. The SCGP for the respondents are physically present. Heard argument from both sides. Main matter. Orders reserved. Yes.
Much obliged.
Bill number 46. R. Narendra Naik.
Respondent.
R. Nagendra Naik. Repeat. No problem. Yes, no problem. You tell me. Yes. Where is the evidence? Say, how do you prove that it is directly due to the negligent act of the driver, the 3% succumbed?
Lord, there are three death of three innocent persons, Lord, and as many as Lord 20 injured persons. It's a serious offense, Lord, as alleged by the prosecution. As per Lord, the case of the prosecution, Lord, totally, Lord, prosecution have examined total 1 to 29 Lord witnesses, and Lord 1 to 37 Lord exhibits have. That Lord, the eyewitnesses, Lord, those who are the inmates of the Lord, the bus, Lord,
large number of eyewitnesses.
Large number of eyewitnesses there. Yes. Almost ಎಲ್ಲರೂ ಕೆಲವೊಂದು ಇಬ್ಬರು ಮಾತ್ರ ಸ್ವಲ್ಪ ಇದು ಮಾಡಿದ್ರು, ಆಲ್ಮೋಸ್ಟ್ ಎಲ್ಲರೂ ಕೂಡ ಸಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಆಮೇಲೆ ಮೋಟರ್ ವೆಹಿಕಲ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಅವ್ರು ಏನು ಮೆಕ್ಯಾನಿಕಲ್ ಇದು ಸ್ಟೇರಿಂಗ್ ಕಟ್ ಆಗಿತ್ತು ಅಂತ ಏನಂತಕ್ಕೆ they did not come with them on the prosecution to elicit Lord disbelieve the case of the prosecution. And moreover, Lord, the incident, even doctor also Lord has Lord the wound certificate also issued Lord as per Lord exhibit Lord P14 to P34. That has been Lord proved the case of the prosecution. Even Lord, on that day, Lord, he was on duty. Lord, that is concerned. Lord, letter has been issued by as per exhibit P35 is concerned. By looking into the evidence, even Lord, I would like to take Lord evidence on PW2. Lord, that is all Lord witnesses all support. Lord, I will read the Lord relevant portion. ಸುಮಾರು 5 ವರ್ಷಗಳಿಂದ ನಾನು ಮತ್ತು ನಮ್ಮ ಊರಿನ ಸಂಗಮಕ್ಕೆ ಹೋಗಲು ಬೆಳಿಗ್ಗೆ 10:45 ಗಂಟೆಯಲ್ಲಿ ಸರ್ಕಾರಿ ಬಸ್ಸು ಮತ್ತು ನಾನು ನನ್ನ ಹೆಂಡತಿ ಪುಟ್ಟಿರಮ್ಮ ಹಾಗೂ ಇನ್ನು ಇತರರು ಸರ್ಕಾರಿ ಬಸ್ ಅನ್ನು ಹತ್ತಿ ಹೊರಟೆವು. ಬಸ್ಸು ವೇಗವಾಗಿ ಹೋಗುತ್ತಿತ್ತು. ಹೆಗ್ಗನೂರಿನ ಮುಂದೆ 3 ಕಿಲೋಮೀಟರ್ ದೂರ ಹೋಗಿತ್ತು. ಕುಂಟೆ ಕಾಡಿನ ಹತ್ತಿರ ಬಸ್ಸು ವೇಗವಾಗಿ ಹೋಗಿ ಒಂದು ದಿಬ್ಬಕ್ಕೆ ಗುದ್ದಿ ಬಲಕ್ಕೆ ಉರುಳಿತು. ಅದರಿಂದ ನನ್ನ ತಲೆಗೆ ಏಟಾಗಿತ್ತು. ಸ್ಥಳದಲ್ಲಿ 3 ಜನ ತೀರಿಕೊಂಡರು. ಅವಳು ಎಲಗಳ್ಳಿಯವರು 2 ಹಾಗೂ ಕುಂತೂರಿನ 1 ಗಂಡಸರು ತೀರಿಕೊಂಡರು. ನನ್ನ ಹೆಂಡತಿ ಸುಂದರಮ್ಮನಿಗೆ ತೀವ್ರ ಸ್ವರೂಪದ ಏಟಾಗಿತ್ತು. ಇತರ ಪ್ರಯಾಣಿಕರು ಸಹ ಏಟಾಗಿತ್ತು. ನ್ಯಾಯಾಲಯ ಮುಂದೆ ಆರೋಪಿಯ ಈ ದಿನ ಅಪರಾಧ ಮಾಡಿದ ಬಸ್ಸಿನ ಚಾಲಕಿಗಳು, ಬಸ್ಸಿನ ನಂಬರ್ ಹಾಗೂ ಚಾಲಕ ಹೆಸರು ಗೊತ್ತಿಲ್ಲ. ಈ ಬಗ್ಗೆ ನಾನು ಹೇಳಿಕೊಟ್ಟಿದ್ದು ಸದರಿ ಹೇಳಿಕೆಯನ್ನು ಎಕ್ಸಿಬಿಟ್ ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. This is the Milord evidence, Milord stated by the even Milord, even other even witnesses, Milord, yeah, already Milord, my friend has been read in all evidence, Milord. Even all the evidence, Milord, they most of the witnesses have made it up, Milord, supported the case of prosecution. Moreover, Milord, both the court below, Milord, have concurrently, Milord, held that Milord be, and it is the prosecution has proved the case, Milord, beyond all reasonable doubt.
Read PW1 examination in chief.
PW1, Milord, though, Milord, I will read. ಸುಮಾರು 5 ವರ್ಷಗಳ ಹಿಂದೆ ನಾನು ನಮ್ಮ ಊರಿನಿಂದ ಸಂಗಮಕ್ಕೆ ಹೋಗಲು ಬೆಳಿಗ್ಗೆ 10:45 ಗಂಟೆಯಲ್ಲಿ ಸರ್ಕಾರಿ ಬಸ್ ಅನ್ನು ನಾನು, ನನ್ನ ಹೆಂಡತಿ ಕುಮಾರ ತೀರಮ್ಮ ಹಾಗೂ ತಾರೀಕು 24/2002 ಬೆಳಿಗ್ಗೆ 10 ಗಂಟೆಯಲ್ಲಿ ನಾನು ದೊಡ್ಡಾಳಲ್ಲಿ ಸರ್ಕಾರಿ ಬಸ್ ಅನ್ನು ಕರ್ತವ್ಯಕ್ಕೆ ಹೋಗಲಾಗ್ತಿದೆ. ನಾನು ಬಸ್ಸಿನ ಚಾಲಕನ ಹಿಂಬದಿ ಸೀಟ್ನಲ್ಲಿ ಕುಳಿತಿದ್ದೆ. ಬಸ್ಸಿನಲ್ಲಿ ತುಂಬಾ ಪ್ರಯಾಣಿಕರು ಇದ್ದರು. ಸಂಗಮಕ್ಕೆ ಹೋಗುವಾಗ ಇನ್ನು 3 ಕಿಲೋಮೀಟರ್ ಹಿಂದೆಯೇ ಅಪ್ಪನ್ನು ಹತ್ತಿ ರಸ್ತೆಯ ಎಡಭಾಗಕ್ಕೆ ಬಿದ್ದು ಬಿಟ್ಟಿತ್ತು. ಬಸ್ಸಿನ ಟಾಪ್ ಮೇಲೆ ಕುಳಿತ ಪ್ರಯಾಣಿಕರ ಪೈಕಿ 3 ಜನ ಕೆಳಗೆ ಸಿಕ್ಕಿ ತೀರಿಕೊಂಡರು. ಬಸ್ಸಿನ ಒಳಗಡೆ ಪ್ಲೀಸ್ ಮೇಡಮ್.
ಬಸ್ಸಿನ ಟಾಪ್ ಮೇಲೆ ಕುಳಿತಿದ್ದ 3 ಮಂದಿ, ಬಸ್ಸಿನ ಟಾಪ್ ಮೇಲೆ ಕುಳಿತಿದ್ದ ಪ್ರಯಾಣಿಕರ ಪೈಕಿ 3 ಮಂದಿ ಬಸ್ಸಿಗೆ ಸಿಲುಕಿ ಸತ್ತು ಹೋದರು.
ಹೌದು ಸರ್.
So for any person say who sustaining injury or dies by sustaining injury, whoever traveling on the top of the bus, can the driver be held negligent?
Milord, because he was present, Milord, he was the driver, Milord, actively, Milord, he is also involved, he also responsible for, Milord, by Milord, the loading them, Milord, top of the bus. The driver also, Milord, equally responsible for that.
How you are justifying it? That may be your opinion.
Please, Milord.
But how I should concur with your opinion? I may disagree. I may say that is not the lookout of the driver.
Yes.
He is driving the bus and say he takes care of the inmates of the bus.
Yes.
Before giving the signal to the driver to move the bus forward, the conductor ought to have been ensured that there are no passengers on the top of the bus.
Yes.
How did the conductor allow them to climb the bus and ask the driver to go? Without the signal of the conductor, the driver cannot move the bus.
Conductor also has been examined.
No, you are not answering my question as usual.
Yes, your lordship is right, Milord. It is Milord.
So can I take that the Lorent HCGP concedes in his argument that driver was not rash or negligent in his driving?
Driver is Milord, he is rash and negligent, Milord, while driving the Milord vehicle, Milord. Because of that reason, Milord,
So driver may be rash and negligent in his driving so far as the injury caused to various other people who were traveling inside the bus by sitting or standing inside the bus, the inmates of the bus. The 3 people who died, PW1 says they were traveling on the top of the bus, sitting on the top of the bus. So for their death, how can driver be held responsible? Had they been sitting inside, they wouldn't have dead, because none of the passengers sitting inside have been dead. None of the passengers, even according to you, 26% injured. None of them dead.
Could have been Milord verified, Milord. Character he would have been.
ಅದನ್ನ ನೀವು ಸಬ್ಸ್ಟಾನ್ಶಿಯೇಟ್ ಮಾಡಬೇಕು ವಕೀಲರೇ. ನೀವು ನಿಮ್ಮ ಅಭಿಪ್ರಾಯ ಹೇಳಿದ್ರೆ ಆಗಲ್ಲ. You have to do some homework. You have to find out what the law says. Did you not see in just the previous case in amicus curiae come up with so much of research work? What constitutes rash and negligence? Ingredients of rashness, 4 elements of rashness. Being an amicus curiae, if a council could able to do that, being a high court government pleader, are you not expected to do some research work in this matter? You should.
Please.
Otherwise, I won't leave you.
Please.
ನಿಮ್ಗೆ ಆತರ ನಿದ್ದೆ ಬರಲ್ಲ. ಕನಸಲ್ಲಿ ನಾನ್ ಬರ್ತೀನಿ ಬಹು ಅಂತ. ಓದ್ಕೊಂಬರ್ಬೇಕು ನನ್ನ ಕೋರ್ಟಲ್ಲಿ. Called again. Both sides present, clerk and HCGP prays for a time by a day, stating that they would like to do some research in this matter and make submission. List this matter on the topmost of the list on 2/6. ಇವತ್ತೆಷ್ಟು ತಾರೀಕು? 3/6/2020. Yes. ಯಾವುದೋ ಒಂದು ಕಾಂಪ್ರಮೈಸ್ ಇರಬೇಕು. Hearing on IA 230 matter. Serial number 55.
Pass over the matter.
Yakri.
Yes, the respondent counsel is on his way. The parties then the applications are also ready and prepared. Our sign ಮಾಡ್ಬಿಟ್ಟು sign ಮಾಡ್ಬಿಟ್ಟು notary ಮಾಡಿ ತರಬೇಕು another 5 minutes.
ಯಾಕೆ ನೀವೆಲ್ಲ ವಕೀಲರು ಯುದ್ಧ ಕಾಲ ಶಸ್ತ್ರಾಭ್ಯಾಸ ಮಾಡ್ತೀರಿ? ಪ್ರತಿಯೊಂದು ಸಂದರ್ಭದಲ್ಲಿ ಕೇಸ್ ಕರೆದ್ರ ಮೇಲೆ ಕೋರ್ಟಿಗೆ ಬಂದ್ರ ಮೇಲೆ ನಿಮ್ಮ ಕಾಫಿ ಗೀಫಿ ಮಾತು ಹೊರಟೆ ಆದ್ರ ಮೇಲೆ ಆಮೇಲೆ ಏನ್ ಕೇಸ್ ಇದೆ ಜೂನಿಯರ್ ಅಲ್ಲಿ ಇದಾನೆ ಹೋಗಪ್ಪ ನೋಟ್ರಿ ಹತ್ರ ಮಾಡಿಸ್ಕೊಂಬ.
In fact my lord ನೆನ್ನೆ
ನಿಮ್ಮ 3 ಜನ ಕಕ್ಷಿದಾರರು
ನೆನ್ನೆ
ಕಾಯ್ಬೇಕಲ್ವೇ?
ನೆನ್ನೆ ಸಂಜೆ including the DD and the applications were sent. Still today they want to ensure that what is typed is what I have sent. Maybe passed on.
Final hearing matters. Serial number 49. K. Chandrasekhara. Responding to the MP Chandrachud.
Supplement K ಅಂತ ಏನು
Who said settlement?
From both the side, my lord, on previous dates, my lord, it was submitted that my lord, there is a possibility of settlement. Thereafter, my lord, the Sambhu court adjourned the matter. And off the record, my lord, it was fairly admitted that my lord, 75,000 check amount is 50,000, my lord, for 75,000 it was
agreed.
And when now the petitioner my lord has deposited 62,500 rupees.
Fine itself is. Fine is 5,000. 1 lakh rupee compensation. 1,05,000 is the total liability.
Total
Yes.
Check amount is 50,000.
Check amount is 50,000.
Other side, it's out of 1,05,000, the petitioner has deposited 62,500 before the honorable trial court.
62,500.
62,500. And the petitioner may not agree to pay the balance amount, may not further agreeing the respondent area, that is company, to withdraw the amount deposited before the trial court. Other side, counsel may not, it's senior please may not, on the previous date, no, you withdraw the amount, you pay the entire amount of 75,000 before December.
No problem, say who withdraws it. The court can order for delivering that amount in favor of the complainant. So the question of who should withdraw doesn't arise. That cannot be a big issue. If they have agreed for 75,000 rupees, the remaining 12,500 rupees you may have to pay. And the grading cost on the check amount. Grading cost would be maybe around 7,500 rupees. Grading cost. Matter could be settled once for all. Can we have it day after tomorrow morning? There are counsel from both sides physically present and both of them jointly submit.
In the alternative minute, if other side minute is not agreed for such a proposal to withdraw the amount related minute, on merit minute, I am not contesting the case on merit. Only insofar as the sentence minute, honorable trial court minute is not, there is no reasoning passed by the honorable trial court minute to pass the double the sentence to double the check amount.
Then in such an event, if you are say on the point of sentence alone, that can be considered in the light of the settled principle as to what must be the sentencing policy. But still,
conviction.
Exactly, that is it. That blot would be there upon you forever and ever.
Let other side verify from this.
Better, better to persuade him to go ahead with the settlement, agree the terms of the settlement. 62,500 rupees, if it is deposited in the court, he must be very happy that so much of substantial amount has already been available. At any time he can lay his hand upon that. So he must be very happy.
Even before.
ನೋಡ್ರಿ 62,500 ಕೋರ್ಟ್ ನಲ್ಲಿ ಇಟ್ಟಿದೀವಿ ಅಂತಿದ್ದಾರೆ ಅವರು, ಅದನ್ನ ಅಸರ್ಟೈನ್ ಮಾಡ್ಕೊಳ್ಳಿ ಇಟ್ಟಿದ್ದಾರೆ ಅಂತ. ಅದು
ರೆಸಿಟ್ ಕೂಡ ಇದೆ.
ಸರಿ, ರಸೀದಿನೂ ಇದೆಯೇನು ಆಗಿದೆ ಅಂತ ಆದ್ರೆ ನೀವು 75,000 ಒಪ್ಪಿದ್ರೆ ಉಳಿದಿರೋ 12,500 ರೂಪಾಯಿ ಅವ್ರು ನಿಮ್ಗೆ ಕೊಡ್ತಾರೆ, ಗ್ರೇಡಿಂಗ್ ಕಾಸ್ಟ್ ಕಟ್ತಾರೆ, ಅವ್ರು ಬಿಡುಗಡೆ ಆಗ್ತದೆ, ನಿಮಗೆ ದುಡ್ಡು ಬರುತ್ತೆ. ಆ ಪ್ರಕಾರ ನೋಡಿ ಏನು ಅಂತ ನಾಡಿದ್ದು ಬೆಳಗ್ಗೆ ಇಬ್ರು ನಿಮ್ಮ ಕಕ್ಷಿದಾರಗಳನ್ನು ಹಾಜರಿಡಿ ಬನ್ನಿ.
2 days time.
ಯಾಕ್ರಿ 2 days ಟೈಮ್? ಈಗ ಹೊರಗಡೆ ಹೋಗ್ಕೊಳ್ಳೆ ಕಾರಿಡಾರ್ ಎಂದು ಒಂದು ಮೊಬೈಲ್ ಫೋನ್ ಮಾಡ್ತೀರಿ ನಿಮ್ಮ ಕಕ್ಷಿದಾರನಿಗೆ, ಹೌದು ಸ್ವಾಮಿ ಒಪ್ಪಿದ್ದಾರೆ, ಅದೇನೋ ಮುಗಿಸಿ ಬಿಡ್ರಿ ಅಂತಾನೆ, ಮುಗಿತಲ್ವೇ 30 ಸೆಕೆಂಡ್ ಒಳಗೆ ಸೆಟಲ್ಮೆಂಟ್ ಮುಗಿ. 2 days ಯಾಕೆ ಬೇಕು? ನೀವೇನ್ ಇನ್ವಾಯ್ಸ್ ರೈಸ್ ಮಾಡಿ ಬಿಲ್ ರೈಸ್ ಮಾಡಿ ಪ್ರೊಫೆಷನಲ್ ಫೀ ಅಂತ ಕೇಳಲ್ಲ, ಅದೇನಿದ್ರು ಓರಲ್ಲಿ ಇರ್ತದೆ, ಅದನ್ನು 30 ಸೆಕೆಂಡ್ ಫೋನ್ ಅಲ್ಲಿಯೇ ಹೇಳ್ಬೋದು.
ನಮ್ಮವನ್ ಏನ್ ಹೇಳ್ತಾ ಇದ್ದಾನೆ,
ಅದೆಲ್ಲ ಮುರ್ಕೊಂಡ್ ಕೊಡ್ರಿ ಅಂತಾನು ಮ್ಯಾಕ್ಸಿಮಮ್ ಅಲ್ವೇ?
ನಮ್ಮವನು ಡಿಪಾಸಿಟ್ ಆದ ಅಮೌಂಟ್ ತಗೊಳ್ಳೋದು ನಮಗೆ ತೊಂದ್ರೆ, ಡೈರೆಕ್ಟ್
ನಮ್ಗೆ ಈ ವಕೀಲ್ರೆ ಡಿಪಾಸಿಟ್ ಆದ ಅಮೌಂಟ್ ತಗೊಳ್ಳಿಕ್ಕೆ ತೊಂದರೆ, ಡಿಪಾಸಿಟ್ ಆದ ಅಮೌಂಟ್ ನಿಮ್ಮ ಕಕ್ಷಿದಾರನ ಫೇವರ್ ಆಗಿ ರಿಲೀಸ್ ಮಾಡ್ರಿ ಅಂತ ಕೋರ್ಟೇ ಆರ್ಡರ್ ಮಾಡುತ್ತಲ್ಲ. ಕೋರ್ಟೇ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಇನ್ನೇನಿದೆ? ನೀವೊಂದು ಆರ್ಒ ಹಾಕ್ಬೇಕು, ಅಮೌಂಟ್ ತಗೊಳ್ಬೇಕು, ಒಂದು ಐಡೆಂಟಿಫಿಕೇಶನ್ ಮಾಡಿ. ನೀವೇನಾದ್ರೂ ಅಲ್ಲಿ ಕೆಳಗಿನ ಕೋರ್ಟಿನಲ್ಲಿ ನ್ಯಾಯಾಲಯದ ಸಿಬ್ಬಂದಿಗಳನ್ನು ಬಹಳ ವಿಟಮಿನ್ ಪ್ರೋಟೀನ್ ಕೊಟ್ಟು ಬೆಳೆಸಿದ್ರೆ ಆ ವಿಟಮಿನ್ ಪ್ರೋಟೀನ್ ನೀವು ಪೂರೈಸಬೇಕಾಗ್ತದೆ. ಅದಕ್ಕೂ ನನಗೂ ಸಂಬಂಧ ಇದೆ.
ಈಗ ಅಕೌಂಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ಬಿಡುತ್ತೆ ಸ್ವಾಮಿ, ಅದು ಚೆಕ್ ಏನು ಕೊಡಲ್ಲ. ಬ್ಯಾಂಕ್ ಟ್ರಾನ್ಸ್ಫರ್, ಬ್ಯಾಂಕ್ ಅವ್ರ ಅಕೌಂಟ್ಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ಬಿಡುತ್ತೆ ಅವ್ರ ಅಕೌಂಟ್.
ಹೌದ್ರಿ, ಅದ್ರ ಟ್ರಾನ್ಸ್ಫರ್ ಎಂಟ್ರಿ ಮಾಡ್ಬೇಕಲ್ವೇ? ಅದ್ರ ಮೇಲೆ ಒಂದು ಎಂಟರ್ ಅನ್ನ ಬಟನ್ ಒತ್ತಬೇಕಲ್ವೇ? ಏನ್ ಮಾಡ್ತೀರಿ? ಕಂಪ್ಯೂಟರ್ಗಳು ಸರಿ ಕೆಲಸ ಮಾಡಲ್ಲ, ಸರ್ವರ್ ಡೌನು. The counsel from both sides present physically and submit that they have arrived at a settlement in the matter amicable to both parties, and they pray for a day's accommodation to the same. List this matter on 7/6/2022 on topmost of the list, either to report settlement or to proceed further in the matter. Nodi, 6 ದಿವಸ ಟೈಮ್ ಸಿಗ್ತದೆ. Serial number 50, Ravishankar PN, K. Chandrasekhara, respondent HCGP. Four 506 DP Act. Yes.
Under 498 DC Act, which was confirmed in the appellate court.
Yes.
The petitioner husband my lord before the Sambhav court in the revision. On the last date of hearing, my lord, it was submitted. What is there is a possibility of settlement since two children are my lord. One is with the father and another child is with the mother. Under the circumstances, my lord, since our counsel also my lord making effort to either go together or for separation. But in the family, before the family court, my lord, they were was granted.
Evidence. Yes.
Family court, my lord, under 13(1)(a), because a decree matter was decreed and MFA is pending for the Sambhav court. Now, my lord, parties are making effort for settlement.
Last time ಹೇಳಿದ್ವಿ.
Last time parties present ಇರಲಿಲ್ಲ.
ಆದ್ರೆ ಸೆಟಲ್ಮೆಂಟ್ ಅನ್ನೋದು ನೀವು ಹೇಳಿದ್ವಿ.
Both the parties are present today. Today also, my lord, the wife, my lord, PW1, wife of this petition is present. She is seeking a 2 weeks time, my lord.
How can you take their claim to your side ಹೇಳಿ ಮುಂದೆ.
If the others say.
ಅವ್ರದೊಂದು ಹೇಳಿದ್ರೆ ಆಗಿಲ್ರಿ ಮೆರಿಟ್ ಮೇಲೆ, ಅದಕ್ಕೆ ನಿಮ್ಮದು
Merit
ಏನಾದ್ರು ಸೆಟಲ್ಮೆಂಟ್ ಏನಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ನೀವು ಅದಕ್ಕೆ ನಾನ್ ಕಾಂಪೌಂಡಬಲ್ ಅಫೆನ್ಸ್ ನಲ್ಲಿ ಕಾಂಪೌಂಡ್ ಮಾಡ್ಕೊಳ್ಬೇಕಾದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಮಾಡಿ.
ಇದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್
ಹೌದು, ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ಬೇಕು ಮಾಡಿ. ಅದನ್ನ ನೀವು ಕಕ್ಷಿದಾರ ಅಂದಿಸ್ಕೊಂಡು ಸ್ವಾಮಿ ಸೆಟ್ಲ್ ಆಗಿ ಬಿಟ್ಟಿದೆ ಅಂದ್ರೆ ಹೇಗೆ ಈಗ ಆಗ್ತದೆ. ಆಮೇಲೆ ಹೈಕೋರ್ಟ್ ಕಾಂಪೌಂಡ್ ದಾಟ್ತಾನೆ ಆತ ಮತ್ತೆ ಶುರು ಮಾಡ್ತಾನೆ. ಅದೇನ್ ಮಾಡ್ತೀವಿ ಮಾಡ್ಕೊ ಹೋಗು ಅಂತ, ಯಾಕೆಂದ್ರೆ ಇಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಅಕ್ವಿಟ್ ಅಂತ ಆಗಿರುತ್ತಲ್ವೇ. ಆಮೇಲೆ ಅದೇನ್ ಮಾಡ್ತೀವಿ ಮಾಡ್ಕೊ ಹೋಗು ಅಂತಾನೆ. ಫಸ್ಟ್ ಹೋಗಿ ಅವ್ರ ಯೂನಿಯನ್ ಲೀಡರ್ ಹೇಳ್ತಾನೆ, ಸ್ವಾಮಿ ನಂದೆಲ್ಲ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಮುಗೀತು, ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಕೊಡ್ತಿದ್ದೀನಿ, ನಂಗೆ ಬರ್ಬೇಕಾಗಿರೋದು ಇನ್ಕ್ರಿಮೆಂಟ್, ಅರಿಯರ್ಸ್, ಪ್ರಮೋಷನ್ ಎಲ್ಲವೂ ಬರ್ಬೇಕು ಕೂಡ್ಲೆ. ಅಷ್ಟೇ ಆಗುತ್ತೆ. ಏನಯ್ಯ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಿ? ಎಷ್ಟು ಸಸ್ಯ ಬೆಳೆಸಿದ್ದೀರಿ ಕಡತದ ಮೇಲೆ? ಹಾರ್ಟಿಕಲ್ಚರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನು ಚೀಫ್ ಡೈರೆಕ್ಟರ್, ಚೀಫ್ ಸೆಕ್ರೆಟರಿನ? ಮತ್ತೊಂದು ಹೇಳ್ಬಹುದಲ್ವೇ, ನಮ್ಮ ಸಿಬ್ಬಂದಿಗಳು ಇರ್ತಾರೆ. ಏನಪ್ಪ ಕೆಲಸ ಮಾಡ್ತಿದ್ವಿ? ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದೀನಿ ಸರ್. ಹೊಸೋರ್ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಗಿದ್ದಾರೆ ನೋಡಿ. ಅವ್ರು ಮೋಟರ್ ಸೈಕಲ್ ಮೇಲೆ ಹಾಕೊಂಡು ಹೋಗ್ತಾರೆ. ಜುಡಿಷಿಯಲ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್, ಹೈಕೋರ್ಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಅಂತ. ಯಾವ ಪೊಲೀಸರು ನೋಡಬಾರದು. ಏನ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ ರಾಜಿ? ಬರ ಮತ ಈ ಕಡೆ ಬಾ, ನೀನ್ ಇವ್ರ ಪಾರ್ಟಿ ಅವ್ರ ಪಾರ್ಟಿ ಅಲ್ಲ. ಪಕ್ಷಾಂತರ ಮಾಡಬಾರ್ದು, ಕಾನೂನಿನ ವಿರುದ್ಧ. ಈಗ ಯಾವ್ಯಾವ ಕೇಸ್ಗಳು ನಿಮ್ಮಿಬ್ಬರ ಮಧ್ಯೆ ಇದೆ ಮುಂದೆ ಬರವ ತಾಯಿ? ಯಾರು ಹಾಕಿದ್ದು, ಏನ್ ಕೇಸು, ಯಾವ್ದ್ರ ಬಗ್ಗೆ? ಡೈವರ್ಸ್ ಆಗಿದೆಯಾ ಇಬ್ರಿಗೂ? ಡೈವರ್ಸಿಗೆ ಹಾಕಿದ್ಯಾರು? ಅವರು. ಡೈವರ್ಸ್ ಕೊಟ್ಟಾಗಿದೆ, ನೀವು ಅದ್ರ ಮೇಲೆ MFA ಹಾಕಿದಿರಿ ಡೈವರ್ಸ್ ಕೊಡಬಾರ್ದು ಅಂತ. ಈಗ ಅವ್ರ ಸರ್ವಿಸ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರೇ ಇದೆಯಾ, ಬೇರೆಯವ್ರ ಹೆಸರು ಏನಾದ್ರು ಸೇರಿಸಿದಾರ? ನೋಡಿದ್ರಿ? ನೋಡಿಲ್ಲ, ಅದಿನ್ನೂ ಗೊತ್ತಿಲ್ಲ. ಬೇರೆ ಹೆಸರು ಏನಾದ್ರು ಸೇರಿಸಿದ್ದೀರೇನಪ್ಪ ನಿಮ್ ಸರ್ವಿಸ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ? ಇಲ್ಲ.
ಸಾಕಾಗೋಗಿದೆ.
ನೀವು ಹಾಗೆ ಹೇಳ್ತೀರಿ, ಬಹಳಷ್ಟು ಉದಾಹರಣೆಗಳು ಆಪೋಸಿಟ್ ಇರ್ತದೆ. ಈಗ ನಿಮಗೆ ಡೈವರ್ಸ್ ಬೇಡ, ಅವ್ರ ಜೊತೆಗೆ ಇರ್ಬೇಕು. ಯಾರ ಮಕ್ಕಳು ಕರೀರಿ ಮುಂದೆ, ಬಾರಮ್ಮ ತಾಯಿ. ಆಗ್ಲಿ. ಈಗ ಆ ಮಗಳು ನಿಮ್ ಜೊತೆ ಇದ್ದಾಳ, ಅವ್ರ ಜೊತೆ ಇದ್ದಾಳ? ಅವ್ರ ಜೊತೆ ಇದ್ದಾಳ. ಎಷ್ಟು ವರ್ಷದಿಂದ? ನನಗೆ ಯಾವಾಗ ಗೊತ್ತಮ್ಮ ತಾಯಿ ಕೇಸ್ ಯಾವಾಗ ಹಾಕಿದ್ರಿ ಅಂತ? ಆಗ್ಲಿ. ಆ ಮಗು ಎಷ್ಟು ವರ್ಷ ಆಗಿತ್ತು ಅವ್ರ ಜೊತೆ ಇರ್ಬೇಕಾದ್ರೆ? 2.5 ವರ್ಷ ಅಂದ್ರೆ 12.5 ವರ್ಷ. ನೀವೇನ್ ಕೇಳಲಿಲ್ವಾ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನನ್ ಮಗಳನ್ನ ನನ್ಗೆ ಮುಖ ನೋಡ್ಲಿಕ್ಕೆ ಬಿಡ್ರಿ ಅಂತೆಲ್ಲ? ಈ ಮಗಳು ನಿಮ್ಮ ಹತ್ರ ಇದ್ದಾರೆ. One of the best principle, the policy adopted in many small groups or some communities in India is that partitioning the children also. Partition by means and bound not just say confines to the physical property, even the children also. Several of the instances you can see even today. Even today you can see. ದೊಡ್ಡ ಮಗ ಅವ್ರ ಹತ್ರ ಇರ್ಲಿ, ಎರಡನೇ ನನ್ನ ಹತ್ರ ಇರ್ಲಿ.
ಇಬ್ರು ಒಬ್ಬರೇ ಇದ್ರೆ ಕಷ್ಟ.
ನಮ್ಮ ಪುಣ್ಯ ಪಾಂಡವರು ವಿಭಾಗ ಕುರಿತು ಹೊಡೆದಾಡ್ಲಿಲ್ಲ. ದ್ರೌಪದಿ ಕಥೆ ಏನಾಗ್ತದೆ? ಈಗ MFA ಇನ್ನು ಬಾಕಿ ಇದೆಯಾ ಅಮ್ಮ? ಒಂದು MFA ಇದೆ. ಮತ್ಯಾವ್ದಿದೆ ಕೇಸ್ಗಳು ನಿಮ್ಮಿಬ್ಬರ ಮಧ್ಯ? ಆ ಎರಡನೇ ಮಗಳಿಗೆ ಎಷ್ಟು 12 ವರ್ಷನಾ? ನಿಮ್ ಕೂಡ ಇರೋಳಿಗೆ 13 ವರ್ಷ. ಇಬ್ರು ಓದ್ತಾ ಇದ್ದಾರಾ? ಇಬ್ರು ಓದ್ತಿದ್ದಾರೆ. MF ಇಲ್ಲದೆ ಮತ್ತೆ ಯಾವ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ ನಿಮ್ಮಿಬ್ರು ನಡುವೆ? ಮೇಂಟೆನೆನ್ಸ್ ನೀವು ಹಾಕಿದ್ದು, ಅದು ಎಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ? ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್. ನೀವೇನಾದ್ರೂ ಉದ್ಯೋಗದಲ್ಲಿ ಇದ್ದೀರಾ? ಪ್ರೈವೇಟು? ಏನು ಓದಿದ್ದೀರಿ? ಪ್ರೈವೇಟ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಒಂದು MFA, ಇನ್ನೊಂದು ಮೇಂಟೆನೆನ್ಸ್. ಮತ್ತೆ ಯಾವ ಕೇಸ್ ಬಾಕಿ ಇದೆ? GNWC. ಆ ಮಗಳು ಕಸ್ಟಡಿ ಕೇಳಿದ್ದ? ವಿಸಿಟೇಷನ್ ರೈಟ್.
one by wife and another by
GNWC ಕೇಸು ನೀವೇ ಹಾಕಿರೋದು?
ಇಬ್ರು ಹಾಕಿದ್ದಾರೆ. ಇವ್ರು ಅವರೊಂದು ಹಾಕಿದ್ದಾರೆ, ಈ ಮಗು ಬೇಕು ಅಂತ. ಇವರೊಂದು ಹಾಕಿದ್ದಾರೆ, ಆ ಮಗು ಬೇಕು.
ಎರಡು ಒಂದೇ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಪೆಂಡಿಂಗ್ ಒಟ್ಟಿಗೆ.
ನಂತರ ಒಂದು ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ನಂಬರ್ 336 of 2013 ಬಿಫೋರ್ ದ ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ seeking
ಒಂದು ನಿಮಿಷ. GNWC ಬಿಟ್ ಮತ್ತೆ ಯಾವ್ದಿದೆ ನೆಕ್ಸ್ಟ್?
criminal appeal seeking enhancement of sentence.
Filed by whom?
Filed by state. Filed by state against the very same.
Not by the victim. Criminal appeal. The conviction was for what?
Same, very 498 and very same inquin judgment my lord, seeking enhancement appeal before the sessions court.
Then that must be a clubbed matter with this, right?
Illa.
Agli.
It is before the sessions court. It is before the sessions court.
Sessions court.
State of file ಮಾಡೋಷ್ಟರಲ್ಲಿ ಈ appeal ಮುಗೋಗುತ್ತೆ. Present appeal was disposed of.
No, that is also for 498. That means for the same 498, two conviction judgments are there. One is before me now, right now. You say, you are telling that say one more matter is there before sessions court.
Before sessions court, preferred by the state seeking enhancement of sentence.
That is true. That means for 498A on there are two judgments.
Two judgments. No matter one judgment, who appeals before the sessions court. Judgment, common judgment before the one judgment by the trial court. Very same judgment matter was questioned by the accused before the sessions court, seeking acquit or judgment of acquittal. One appeal by the accused against the conviction. Another appeal by the state seeking enhancement of the sentence.
Then both of should have been heard together.
That is my lord. Before the state preparing the appeal, my lord, the appeal prepared by this petition was disposed of. Yes, still the appeal prepared by the state is still. I put records have been not found by the sample court and records are disappeared.
These are all, or are there some more? These are all. ನೀವೇನ್ ಓದ್ತಿದ್ದೀರಮ್ಮ? ಓದ್ತಾ ಇದ್ದೀರಾ? ಏನ್ ಓದ್ತಿದ್ದೀರಿ? ಗಟ್ಟಿ ಹೇಳ್ಬೇಕು. ಫಸ್ಟ್ PU ಓದ್ತಾ ಇದ್ದೀರಿ, ಹೋಗಿ ಜಾಯಿನ್ ಆಗ್ಬೇಕು. ಗುಡ್. ಯಾವ ಕಾಲೇಜಲ್ಲಿ ಅಡ್ಮಿಷನ್ ಸಿಕ್ಕಿದೆ? ಕುಮಾರನ್ಸ್. ಎಲ್ಲದಕ್ಕೆ ದೊಡ್ಡಕಲ್ ಸಂದ್ರನ? ಟಾಟಾ ಸಿಲ್ಕ್ ಫಾರ್ಮ್. PU ಕಾಲೇಜ್ ಇರೋದು ಪದ್ಮನಾಭ ನಗರದಲ್ಲಿ. ನೀವೇನ್ ಓದ್ತಿದ್ದೀರ? 8. ನಿಮಗಿಬ್ಬರಿಗೂ ಮಕ್ಕಳಿಗೆ ಇಬ್ರು ಒಟ್ಟಿಗಿರ್ಬೇಕು ಅಂತ ಆಸೆ ಇದೆಯಾ? ತಂಗಿ ಜೊತೆಗಿರ್ಬೇಕು, ಅಕ್ಕನ ಜೊತೆಗೆ ಇರ್ಬೇಕು. ಕುಂಟಬಿಲ್ಲೆ ಆಡಿದ್ದೀರಾ ಯಾವತ್ತಾದ್ರೂ ಇಬ್ರು ಒಟ್ಟಿಗೆ? ಆಡಿಲ್ಲ. ರಿಂಗಾಟ ಆಡಿಲ್ಲ. ಹೋಗಿ ಹುಡುಗರಿದ್ದಾಗ ಅಡಿಗೆ ಆಟ ಆಡಿಲ್ಲ. ಕಣ್ಣು ಮುಚ್ಚಾಲೆ ಆಡಿಲ್ಲ. ನೀವು ಮಕ್ಕಳಿಗೆ ಏನೆಲ್ಲ ಸುಖದಿಂದ ಸೋಕಾಳ್ ಘನಂದಾರಿ ತಂದೆ ಮತ್ತು ತಾಯಿ ಮಕ್ಕಳಿಗೆ ಏನೆಲ್ಲ ಅವರ ಬಾಲ್ಯ ಸುಖಗಳಿಂದ ವಂಚಿತರನ್ನಾಗಿ ಮಾಡಿದ್ದೀರಿ ಅಂತ ಯಾವತ್ತಾದ್ರೂ ಯೋಚನೆ ಮಾಡಿದ್ದೀರಾ? ಏನಯ್ಯ ಮಹಾನುಭಾವ, ನಾಳೆ ಮಕ್ಕಳಿದ್ದೋರು ಹೋಗಿ ಹೋಗಿ ಹೆಣ್ಮಕ್ಳು ಅವ್ರನ್ನೊಂದು ದಡ ಸೇರಿಸ್ಬೇಕು, ಅವ್ರಿಗೆ ಅವ್ರದ್ದೇ ಆದ ಒಂದು ಸಂಸಾರ ಅಂತ ಹೇಳಿ ಮಾಡಿಕೊಡ್ಬೇಕು. ನಾಳೆ ಮದುವೆ ಮಾಡಿ ನಾಳೆ ಅವ್ರಿಗೂ ಮಕ್ಕಳಾಗುತ್ತೆ. ಆ ಮಕ್ಕಳು ನಿಮ್ಮಿಬ್ರನ್ನ ಮಾದರಿಯಾಗಿ ಇಟ್ಕೊಂಡು ನಮ್ಮ ಅಪ್ಪ ಅಮ್ಮನ ಹಿಂಗೆ ಹೊಡೆದಾಡ್ತಿದ್ರು, ಹಿಂಗೆ ಬೈಗಳು ಮಾಡ್ತಾ ಇದ್ರು, ಹಿಂಗೆ ನಮ್ಮಪ್ಪ ಹಿಂಗ್ ಓಡಿಯೋದು ನಮ್ಮವ್ವ ಹಿಂಗ್ ಓಡಿ ಹೋದ್ಲು, ಅದನ್ನೇ ಅವ್ರ ಮಕ್ಕಳಿಗೆ ಕಲಿಸ್ಬೇಕೆ. ಅಷ್ಟೆಲ್ಲ ಹೋಗ್ಲಿ, ನಾಳೆ ಆ ಮಕ್ಕಳು ಅವ್ರದೇ ಕಾಲೇಜಿನಲ್ಲಿ ವೆಲ್ಡೆಕ್ಟರಿ ಫಂಕ್ಷನ್ ಅಲ್ಲಿಯೋ ಸ್ಕೂಲ್ ನಲ್ಲಿ ಪೇರೆಂಟ್ಸ್ ಮೀಟಿಂಗ್ ನಲ್ಲಿಯೋ ಇದ್ದಾಗ ಅಪ್ಪ ಅಮ್ಮನ್ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ ಹೇಳಿದಾಗ ಉಳಿದಾರದಲ್ಲಿ ಅಪ್ಪ ಅಮ್ಮ ಬಂದಾಗ ನೀವಿಬ್ರು ಬೇರೆ ಬೇರೆ ರೀತಿ ಬೇರೆ ಬೇರೆ ಬೂತ್ಗಳ ತರ ಬೇರೆ ಬೇರೆ ಕಡೆಗಿದ್ರೆ ಏನಾಗ್ಬೇಡ ಆ ಮಕ್ಕಳು ಮನ್ಸು. ನೀವು ಮಕ್ಕಳು ಪರ್ಮಿಷನ್ ತಗೊಂಡು ಹುಟ್ಟಿಸಿದ್ರೆ ಏನವರನ್ನ ಮಕ್ಕಳನ್ನ ಮಾಡೋದು ಮಾಡಿ ಈಗ ಯಾಕೆ ಆ ಮಕ್ಕಳಿಗೆ ಇಲ್ದ ಇರೋದು ಅನಾನುಕೂಲ ಉಂಟು ಮಾಡ್ತೀರಿ? ತಲೆ ಕೆಳಗೆ ಹಾಕೊಂಡು ನಿಂತ್ರೆ ಏನು ಬರಲ್ಲ. ಇವೆಲ್ಲ ಡ್ರಾಮಾಗಳನ್ನು ನಿಲ್ಲಿಸ್ಬೇಕು. ಜೀವನದಲ್ಲಿ ಹೇಗೆ ಚೆನ್ನಾಗಿರ್ಬೇಕು ಅದನ್ನ ಕಲಿಬೇಕು. ಹೋಗಿ ಹೋಗಿ ಸರ್ಕಾರಿ ನೌಕರಿಯಲ್ಲಿ ನಿಮ್ಮಂತವರೆಲ್ಲ ಇರ್ತಿರಲ್ರಯ್ಯ. ಆ ಮಕ್ಕಳು ಮನಸ್ಸು ಮಾಡಿದ್ರೆ ನಾಳೆ ಬೆಳಗಿರೋದು ನಿಮ್ ನೌಕರಿ ಹೋಗುತ್ತೆ ಗೊತ್ತೇನು? ದೊಡ್ಡ ಮಗಳೇ ಆಗ್ಲಿ ಸಣ್ಣ ಮಗಳೇ ಆಗ್ಲಿ. ನಿಮ್ ನೌಕರಿ ಇಲ್ಲದಂಗೆ ಮಾಡ್ಬೋದು. ಅಂತ ಮಕ್ಕಳಿಗೆ ಅವ್ರ ಬಾಲ್ಯದ ಯಾವುದೂ ಸುಖ ಕೊಡ್ಲಿಲ್ಲ ನೀವಿಬ್ರು ಘನಂದಾರಿ ಮನುಷ್ಯ. ಈಗ ಮಕ್ಕಳ ಹಿತದೃಷ್ಟಿಯಿಂದ ಇಬ್ರು ಒಟ್ಟಿಗಿರ್ಲಿಕ್ಕೆ ಒಪ್ಪಿಗೆ ಇದೆ ಇಬ್ರಿಗೂ? MFI ಯಾವಾಗಿದೆ ವಕೀಲ್ರೆ? ಎನಿ ಟೆಂಟೇಟಿವ್ ಡೇಟ್? 2016 ಮ್ಯಾಟರ್ ಆಗಿ ಆ MFA ಕೇಸ್ ಏನಿದೆ ಅದನ್ನು ಮುಂದಿನ ವಾರ ಬರೋ ಹಾಗೆ ನಿಮ್ ವಕೀಲರುಗಳಿಗೆ ಹೇಳಿ ಮುಂದಿನ ವಾರಕ್ಕೆ ಹಾಕೊಳ್ತಾರೆ. ಅದನ್ನ ನೀವು ಕೇಳಿದ ತಾರೀಕಿಗೆ ಹಾಕೊಳ್ತಾರೆ. ಅದರಲ್ಲಿ ರಾಜಿ ಆಗಿದೆ, ರಾಜಿನ ನಾವು ರಿಪೋರ್ಟ್ ಮಾಡ್ತೇವೆ ಅಂತ ಹೇಳಿ ಹಾಕೊಳ್ಳಿ. ಇಬ್ರು ಸೇರಿ ಒಂದು ರಾಜಿದನ್ನ ಅರ್ಜಿ ಹಾಕೊಳ್ಳಿ. ಯಾವುದೇ ಅದಕ್ಕೆ 5 ಪೈಸಾ ಕೋರ್ಟ್ ಫೀಸ್ ಇರಲ್ಲ. ನಾವಿಬ್ರು ಗಂಡ ಹೆಂಡತಿಯಾಗಿ ನಮ್ಮ ಬಾಳುವಿನ ಮುಂದುವರಿಸಲಿಕ್ಕೆ ನಮ್ಮ ಸ್ವಂತ ಮನೋ ಇಚ್ಛೆಯಿಂದ ನಾವು ಒಪ್ಪಿದ್ದೇವೆ. ನಮ್ಮ ಮಕ್ಕಳಿಗೂ ಉಜ್ವಲ ಭವಿಷ್ಯ ಕೊಡಬೇಕು ಅಂತ ನಮ್ಮ ಜವಾಬ್ದಾರಿನ ನಾವು ಅರ್ಥಕೊಂಡಿದ್ದೇವೆ. ಈಗ ದೇವರು ನಮಗೇನೋ ಚೂರು ಒಳ್ಳೆ ಬುದ್ಧಿ ಕೊಡ್ತಾ ಇದ್ದಾನೆ. ಇನ್ನು ಹೆಚ್ಚು ಪಾಪ ನಮ್ಮ ಮೇಲೆ ಬರಬಾರ್ದು, ನರಕಕ್ಕೆ ಹೋಗ್ಬಾರ್ದು ಅಂತ ಹೇಳಿ ನಾವು ಚೂರು ಒಳ್ಳೆಯವರಾಗಿ ನೋಡ್ತಿದ್ದೇವೆ ಅಂತ ಹೇಳಿ ಒಂದು 2 ಸಾಲ ಅರ್ಜಿ ಬರೆದು ಹಾಕ್ರಿ. ಆ ಡೈವೋರ್ಸ್ ಅನ್ನ ಹಿಂತೆಗಿರಿ, ನಾವಿಬ್ರು ಒಟ್ಟಿಗೆ ಬಾಳ್ತೇವೆ. ಆ ಕೇಸ್ ಮುಗೀತು. ಆ ಕೇಸ್ ಮುಗಿದ್ರ ಮೇಲೆ ಉಳಿದಿರೋ 3 ಕೇಸ್ಗಳು ತಾನಾಗಿನೇ ಹೋಗುತ್ತೆ. ಗಾರ್ಡಿಯನ್ ಅಂಡ್ ವಾಟ್ಸ್ GNWC ಇದು ಹೋಗುತ್ತೆ. ಮಕ್ಳಿಬ್ರು ನೀವಿಬ್ರು ಒಟ್ಟಿರ್ತೀರಿ, ಮಕ್ಳಿಬ್ರು ನಿಮ್ ಜೊತೆನೇ ಇರ್ತಾರೆ. ಆ ಕೇಸ್ ಹಾಕಿ ಒಟ್ಟಿಗೆ ಬಾಳೋದು ಆಗ ಟೈಮ್ನಲ್ಲಿ ಒಂದು ಎಲ್ಲಿ ವಾಸ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ಆ ಮನೆ ನೋಡಿ. ಆತ ಈಗ ಹೆಂಗ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ, ಮನೆ ಮಾಡ್ಕೊಂಡಿದಾರ ಇಲ್ವಾ, ಎಲ್ಲಿದ್ದಾರೆ, ಯಾರ ಮನೆಯಲ್ಲಿ ಇದ್ದಾರೆ, ಅವ್ರದ್ದೇ ಮನೆ ಇದೆಯಾ, ಇದ್ರೆ ಮನೆ ಹೆಂಗ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ, ಒಂದು ಸಂಸಾರ ನಡೆಸಲಿಕ್ಕೆ ಯೋಗ್ಯ ಇದೆಯಾ, ಅದನ್ನೆಲ್ಲ ನೋಡಿ 2-3 ದಿವಸದೊಳಗೆ ಅದನ್ನ ಅರೇಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆದ ಕೂಡಲೇ ಡೈವರ್ಸ್ ಪಿಟಿಷನ್ ಕ್ಯಾನ್ಸಲ್ ಆದ ಕೂಡಲೇ ಜೊತೆಗಿರಿ, ಮಕ್ಕಳನ್ನ ಜೊತೆಗೆ ಇಟ್ಕೊಳ್ಳಿ. GNWC ತೆಗೀರಿ. ಆಮೇಲೆ ಆ ಮೇಂಟೆನೆನ್ಸ್ ಎಂದು ತೆಗೀರಿ. ಮೇಂಟೆನೆನ್ಸ್ ಸಂಬಂಧದಲ್ಲಿ ನೀವೇನಾದ್ರೂ ಸಾಲ ಫಾಲ ಮಾಡಿದ್ರಿ ನಿಜವಾಗಿಯೂ ಅಂತೇನಾರಾದ್ರೆ ನಿಮ್ಮ ಯಜಮಾನರಿಗೆ ಸಾಲನ್ನು ತೀರಿಸ್ಲಿಕ್ಕೆ ಹೇಳಿ, ಸಾಲಗಳನ್ನ ತೀರಿಸ್ಲಿ, ದೂಸರ ಮಾತಿಂದೆ ತೀರಿಸ್ಲಿ. ನೀವು ಇಷ್ಟು ಜನ ಒಟ್ಟಾಗಿದ್ದಾದ್ರ ಮೇಲೆ ಮತ ಕರೆಸ್ತೀನಿ ನಾನು. ಕರೆಸಿದಾಗ ನನಗೆ ಮಕ್ಕಳು ಹೇಳ್ಬೇಕು, ನೀವಲ್ಲ. ಇಬ್ರು ಮಕ್ಕಳು ನಾನು ಕೇಳಿದ ಪ್ರಶ್ನೆಗೆಲ್ಲ ಉತ್ತರ ಕೊಡ್ಬೇಕು. ಆ ಮಕ್ಕಳ ಬಾಯಿಂದ ಕೇಳಿ ನೀವಿಬ್ರು ಹೊಂದಾಣ್ಕೊಂಡಿದ್ದೀರಿ ಅಂತ ಆದ್ರೆ ಈ ಕೇಸಿನ ರಾಜಿಗೆ ಒಪ್ಪದು. ಇಲ್ಲ ಹೋದ್ರೆ ಈ ಕೇಸಿನಲ್ಲಿ ಕಾನೂನು ಪ್ರಕಾರ ಹೆಂಗೆ ಮುಂದುವರಿಬೇಕೋ ಇವುಗಳ ಗುಣಗಳ ಮೇಲೆ ಆ ಪ್ರಕಾರ ಹೋಗ್ತೀವಿ. ಜೀವನದಲ್ಲಿ ಇಬ್ಬರಿಗೂ ಕಡೆ ಅವಕಾಶ ಭಗವಂತ ಕೊಟ್ಟಿದ್ದಾನೆ. ನಿಮ್ಮ ಪಾಪನ ಸ್ವಲ್ಪ ಮಟ್ಟಿಗಾದ್ರೂ ಕಡಿಮೆ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ, ಪಾಪ ಪೂರ್ತಿ ತೊಳೆದೋಗಲ್ಲ, ಬಹಳ ಸಂಗ್ರಹಿಸಿ ಬಿಟ್ಟಿದ್ದೀರಿ ಪಾಪ, ಅದ್ರ ಸ್ವಲ್ಪ ಮಟ್ಟಿಗೆ ಕಡಿಮೆ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ, ಮಕ್ಕಳಿಗೊಂದು ಒಳ್ಳೆ ಭವಿಷ್ಯ ಕೊಡ್ಲಿಕ್ಕೆ ಕಡೆ ಅವಕಾಶ ಇದೆ. ಇದ್ರಲ್ಲಿ ಏನಾದ್ರೂ ನೀವು ಎಡವಿದ್ರಿ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಇಬ್ಬರಿಗೂ ಜೀವನದಲ್ಲಿ ಯಾವತ್ತೂ ಕ್ಷಮೆ ಇಲ್ಲ, ಯಾವತ್ತೂ ಕ್ಷಮೆ ಇಲ್ಲ. ನಿಮ್ಮ ಜೀವನ ನೀವು ಹೇಗ್ ಬೇಕಾದ್ರೂ ರೂಪಿಸ್ಕೊಳ್ಬಹುದು, ನೀವು ಸ್ವತಂತ್ರರು. ನಿಮ್ಮ ಮಕ್ಕಳ ಜೀವನ ಹಾಳು ಮಾಡುವ ಯಾವುದೇ ಅಧಿಕಾರ ನಿಮಗಿಲ್ಲ. ಇಬ್ರು ಓದ್ತಾ ಇರ್ತಕ್ಕಂಥ ಹೆಣ್ಮಕ್ಳುಗಳು ಅವ್ರನ್ನ ನೋಡಿದ್ರೆ ಬಹಳ ಬ್ರಿಲಿಯಂಟ್ ಸ್ಟೂಡೆಂಟ್ ಅನ್ಸುತ್ತೆ. ಅವ್ರವ್ರ ಕಣ್ಣಿನಲ್ಲಿ ಆ ವಯಸ್ಸಿನ ಮಕ್ಕಳಿಗೆ ಏನು ಕಾಂತಿ ಇರಬೇಕು, ಏನು ಚಟುವಟಿಕೆ ಇರಬೇಕು, ಏನು ಕಾಣ್ತಾ ಇಲ್ಲ. ಚಿಂತೆ ಕಾಣುತ್ತೆ, ಯೋಚನೆ ಕಾಣುತ್ತೆ. ಇಂಥ ಗುದ್ದಾಡ ಅಪ್ಪ ಅಮ್ಮನ ಇಟ್ಕೊಂಡ್ರೆ ಯಾವ ಮಕ್ಕಳು ಚೆನ್ನಾಗಿರ್ತಾರೆ? ನಿಮಗ್ ನಾಚಿಕೆ ಆಗ್ಬೇಕು. ಈ ಕೇಸ್ ನನ್ ಕೈ ಬಿಟ್ಟು ಹೋಗಲ್ಲ. ಹಂಗಾಗಿ ನೋಡೋಣಂತೆ, ಈ ಜಡ್ಜ್ ಹೋಗಿ ಬೇರೆ ಜಡ್ಜ್ ಬಂದ್ರೆ ಏನೋ ಅಲ್ಲಿವರೆಗೆ ಮುಂದಾಕೋಣಂತೆ, ಇನ್ನೇನೋ ಮಾಡೋಣಂತೆ. ಇಲ್ಲ, ಇಲ್ಲಿಯೇ ಬರುತ್ತೆ, ಇಲ್ಲಿಯೇ ಬರುತ್ತೆ. ಇದಿಷ್ಟು ಮಾಡ್ಕೊಳಕ್ ಏನೂ ಕಷ್ಟ ಇಲ್ಲ. ಅಷ್ಟೋ ಕೇಸ್ ವಾಪಸ್ ತಕೊಂಡು ನೀವಿಬ್ರು ಜೊತೆಗಿರೋದನ್ನ 2 ದಿವಸದಲ್ಲಿ ಮಾಡಬಹುದು, 2 ದಿವಸದಲ್ಲಿ ಮಾಡಬಹುದು. ಈ ಶನಿವಾರದೊಳಗೆ, ಈ ಶನಿವಾರನ ಗಂಡ ಹೆಂಡತಿ ಮಕ್ಕಳು ಒಟ್ಟಾಗಿ ಕಳಿಬಹುದು, ಒಟ್ಟಿಗೆ ಯಾವ್ದಾದ್ರು ದೇವಸ್ಥಾನಕ್ಕೆ ಹೋಗಿ ಬರ್ಬೋದು. ನಿಮ್ ಕುಲದೇವ್ರು ಯಾವ ಊರಪ್ಪ? ಹಿರಿಯೂರು, ಯಡಿಯೂರು. ಯಡಿಯೂರು ಅಂದ್ರೆ ನೀವು ಈ ಭಾನುವಾರ ಯಡಿಯೂರಿಗೆ ಹೋಗಿ ಬರ್ಬೋದು. 4 ಮಂದಿ ಬೆಳಗ್ಗೆ ಬೇಗ ಎದ್ದು ಜಳಕ ಮಾಡಿ, ಜಳಕ ಅಂದ್ರೆ ಗೊತ್ತಾ? ಬೆಳಗ್ಗೆ ಬೇಗ ಎದ್ದು ಸ್ನಾನ ಮಾಡಿ ಬುತ್ತಿ ಕಟ್ಕೊಂಡು ಡೈರೆಕ್ಟ್ ಬಸ್ ಯಡಿಯೂರಿಗಿದೆ. ಕುಣಿಗಲ್ಗೆ ಹೋಗ್ಬೇಕಂತೇನಿಲ್ಲ, ಬಸ್ ಚಾರ್ಜ್ ಮಾಡ್ಬೇಕಂತಿಲ್ಲ. ಬೆಳಗ್ಗೆ 5:15 KSRTC ಬಸ್ ಡೈರೆಕ್ಟ್ ಇದೆ. ಯಡಿಯೂರು ದೇವಸ್ಥಾನ ಸ್ಟಾಪ್ ಕೊಟ್ಟು ಮತ್ತೆ ಮುಂದೆ ಹೋಗ್ತಾನೆ, ಬೈಪಾಸ್ ಇಂದ ಊರೊಳಗೆ ಇಳಿತಾನು. ಅಲ್ಲಿಗೆ ಹೋದ್ರೆ ನೀವು 9 ಗಂಟೆ ಒಳಗೆ ಅಲ್ಲಿ ಇರ್ತೀರಿ. ಹೋಗಿ ನಿಮ್ ಕುಲದೇವ್ರು ಮನೆ ದೇವರು ಯಾರಿದೆ ನೋಡ್ಕೊಂಡು, ಅಲ್ಲೇನಾದ್ರೂ ನಿಮ್ ಸಂಬಂಧಿಕರದ ಹಿರಿಯರದ್ದು ಮನೆಗಿನೇ ಇದೇನು ಇಲ್ಲ, ದೂರ ಇದೆ, ಸರಿ ದೇವಸ್ಥಾನಕ್ಕೆ ಹೋಗಿ ಬಂದು ಆಮೇಲೆ ಆ ದಿವಸನ ಚಂದ ಕಳೀರಿ. ಮುಂದಿನ ವಾರ ತಗೊಳ್ತೀನಿ ನಾನು ಈ ಕೇಸ್. ಏನ್ ಬೆಳವಣಿಗೆ ಆಗಿದೆ ಅನ್ನೋದನ್ನ ಹೇಳ್ಬೇಕು. ಏನಪ್ಪ?
ಕಂಪ್ಯಾಷನೇಟ್ ಗ್ರೌಂಡ್ ನಮಗೆ ಆಗಿದೆ. ನನ್ನ ತಂದೆ ತೀರ್ಕೊಂಡ್ಮೇಲೆ ನನಗೆ
ಸರಿ
ಗಾರ್ಡನರ್ ಆಗಿದ್ರು, ತೀರ್ಕೊಂಡ್ಮೇಲೆ ನನಗೆ ಆಯ್ತು. ಮದುವೆ ಟೈಮ್ ನಲ್ಲಿ ಇವರು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರು, ಇವ್ರ ತಂದೆಯವರು ನನ್ನ ತಾಯಿ ಫ್ಯಾಮಿಲಿ ಎಲ್ಲ ಮಾಡಿ ಮಾತಾಡಿ ನನಗೆ ಗೌರ್ಮೆಂಟ್ ಕೆಲಸ ಕೊಡ್ಸಿದ್ರಲ್ಲ, ಹಾಗಾಗಿ ನನ್ನ ತಾಯಿ ನೋಡ್ಕೋಬೇಕು ಅಂತ ನಾನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ದೆ. ಮದುವೆ ಮುಂಚೆ ಒಪ್ಕೊಂಡ್ರು.
ಯಾರ ತಾಯಿ ನೋಡ್ಕೊಳ್ಬೇಕು? ನಿಮ್ ತಾಯಿನ
ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ದೆ. ಇವರು ಮತ್ತೆ ಒಪ್ಕೊಂಡಿದ್ರು. ಮದುವೆ ಆಗಿ ಬಂದು 2 ದಿವಸಕ್ಕೆ ಸ್ವಾಮಿ ಕಾರಣಗಳು ಹೇಳ್ಕೊಂಡು ಬೇರೆ ಮನೆ ಮಾಡಿ ಒಟ್ಟು ಕುಟುಂಬದಲ್ಲಿ ಇರಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದರಿಂದ ಸಮಸ್ಯೆ ಪ್ರಾಬ್ಲಮ್.
ಈಗ ನಿಮ್ ತಾಯಿ ಎಲ್ಲಿದ್ದಾರೆ?
ನಮ್ಮ ಜೊತೆನೆ ಇದ್ದಾರೆ.
ನಿಮ್ ಜೊತೆ ಇದ್ದಾರೆ? ದೊಡ್ಡಬಳ್ಳಾಪುರದಲ್ಲಿ ಇದ್ದಾರೆ. ಎಷ್ಟು ವಯಸ್ಸು ಅವರಿಗೆ ಈಗ? 72. ನಿನ್ ಅಣ್ಣ ತಮ್ಮಂದು ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? ಏನ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ? ಯಾವ ಊರಲ್ಲಿ? ಬೆಂಗಳೂರಲ್ಲಿ. ಇನ್ನು ಅಣ್ಣ ತಮ್ಮಂದ್ರು ಬೇರೆ ಮನೆ ಮಾಡಿದ್ದಾರೆ. ಸರಿ, ಈ ವಾರದೊಳಗೆ ಏನು ನಾಳೆ ನಾಡಿದ್ರಲ್ಲಿ ಏನು ಮನೆ ಮಾಡ್ತೀರಿ? ಈಗ ನೀನಿರೋ ಮನೆ ಸಂಸಾರ ಇರ್ಲಿಕ್ಕೆ ಯೋಗ್ಯವಾಗಿದೆಯಾ? ಒಂದು ನಿಮಿಷ ಕೇಳ್ತೀನಿ. ಈಗ ಈಗಿರೋ ಮನೆ, ನಿನ್ನೆ ರಾತ್ರಿ ನೀವು ಮಲಗಿರೋ ಮನೆ, ಈಗಿರೋ ಮನೆ, ಅದು ಸಂಸಾರಸ್ಥರು ಇರಂಗಿದೆಯಾ? 100% ಇದೆ, ಪರವಾಗಿಲ್ಲ.
ವಿಡಿಯೋ ಬೇಕಿದ್ರೆ ಇದ್ರೆ ತಗೊಂಡ್ ಬಂದಿದ್ದಾರೆ. ಬಂದಿದ್ರು
ಸರಿ, ಈಗ ಆ ಮನೆಯಲ್ಲಿ ಈ ಕೇಸ್ಗಳನ್ನ ಡೈವರ್ಸ್ ಕೇಸ್ನ ವಾಪಸ್ ತಗೊಂಡು MFA ನ ಅಲೋ ಮಾಡಿ ಡೈವರ್ಸ್ ಅನ್ನ ಸೆಟಿಸೈಡ್ ಮಾಡಿ ಆದ್ಮೇಲೆ ಡೈವರ್ಸ್ ನ ವಜಾ ಮಾಡಿ ನೀವಿಬ್ರು ಗಂಡ ಹೆಂಡತಿ ಆಗಿ ಮುಂದುವರಿತೀರಿ ಅನ್ನೋ ಆರ್ಡರ್ ಆಗಿ ಮಾರನೇ ದಿವಸ ನಿಮ್ಮ ಮನೆಯಲ್ಲಿ 5 ಜನ ಇರ್ತಾರೆ. ನಿಮ್ ಹೆಂಡತಿ, ನಿಮ್ದೆರಡು ಮಕ್ಕಳು, ನಿಮ್ಮವ್ವ, 5 ಜನ ಇರ್ತಾರೆ. 5 ಜನ ಇರ್ರಿ. ಒಂದು ತಿಳ್ಕೊಳ್ರಮ್ಮ ಹೆಣ್ಮಕ್ಳುಗಳು, ಯಾವ ಕುಟುಂಬದಲ್ಲಿ ಹಿರಿಯರು ಇರ್ತಾರೋ ಅದು ನಂದನವನ. ಯಾವ ಮನೆಯಲ್ಲಿ ಹಿರಿಯರು ಅಜ್ಜಿ ಆಗ್ಲಿ, ತಾತ ಆಗ್ಲಿ, ದೊಡ್ಡಮ್ಮ ಆಗ್ಲಿ, ಚಿಕ್ಕಮ್ಮ ಆಗ್ಲಿ, ವಯಸ್ಸ ತಂದೆ ತಾಯಿಗಳಾಗ್ಲಿ ಇದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ದೇವರು ನಮ್ಮ ಮನೆಯಲ್ಲಿ ನೆನೆಸಿದಾನೆ ಅಂತ. ಅದರಷ್ಟು ಪುಣ್ಯ, ಪರಮ ಭಾಗ್ಯ ಬೇರೆ ಯಾವುದೂ ಇಲ್ಲ. ದುಡ್ಡು ಕೊಟ್ರೆ ಸಿಗಲ್ಲ ಅದು. ಯಾವ ಇಂಟರ್ನೆಟ್ ಅಲ್ಲಿ ಸಿಗಲ್ಲ ಅದು. ಎಲ್ಲಿಯೂ ಸಿಗಲ್ಲ. ಅಮೆಜಾನ್ ಅಲ್ಲೂ ಸಿಗಲ್ಲ, ಫ್ಲಿಪ್ಕಾರ್ಟ್ ಅಲ್ಲಿಯೂ ಸಿಗಲ್ಲ, ಸ್ವರ್ಗದಲ್ಲಿಯೂ ಸಿಗಲ್ಲ. ಪರಮಾತ್ಮ ಸ್ವರ್ಗ ಕೊಡಬಲ್ಲ, ಅಪ್ಪ ಅಮ್ಮನ್ ಕೊಡ್ಲಿಕ್ಕೆ ಅವನ ಕೈಲೂ ಸಾಧ್ಯ ಇಲ್ಲ. ಹಾಗಾಗಿ ಅವರಪ್ಪ ಅಮ್ಮನೇ ಆಗ್ಲಿ, ಇವ್ರಪ್ಪ ಅಮ್ಮನೇ ಆಗ್ಲಿ, ಯಾರು ಇದ್ದಾರೆ ನಿಮ್ ಜೊತೆಗೆ ಇರ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ನೀವು ಮಕ್ಕಳು ಒಪ್ರಿ. ಅವರಿಂದ ಬಹಳಷ್ಟು ವಿಷಯಗಳು ಕಲಿತ್ಕೊಳ್ಳೋದಿರುತ್ತೆ. ಅದು ಯಾವತ್ತೂ ಕುಟುಂಬಕ್ಕೆ ಒಳ್ಳೇದು. ಇರ್ತಾರಪ್ಪ, ಮನೆ ಮಾಡು, ಮುಂದಿನ ವಾರ ಡೈವರ್ಸ್ ಹೋಗ್ಬೇಕು, ನೀವಿಬ್ರು ಗಂಡ ಹೆಂಡತಿ ಅಂತಾನೆ ಮುಂದುವರಿಬೇಕು, ಮಕ್ಕಳಿಗೆ ಒಳ್ಳೆ ಭವಿಷ್ಯ ಬರ್ಬೇಕು. ಆಗ್ಬೋದೇನ್ರಿ ವಕೀಲ್ರೆ? ಒಪ್ಪಿದ್ದಾರಪ್ಪ. ಆಮೇಲೆ ಇದನ್ನ ಮಾಡು. ಏನ್ರಮ್ಮ ಈಗ ನಾನು ಅದನ್ನು ನಿಜ ಒಪ್ಪಿದ್ದೇನೆ ನಮ್ಮ. ನಾನು ಹೇಳುದು ಒಟ್ಟಿಗಿರ್ರಿ ಹಿಂದೆ. ನಾನೇನಾದ್ರೂ ನಿಮಗೆ ನಿಮ್ಮ ಅತ್ತೆಗೆ ಅಕ್ಕಮ್ಮ ಮಾಡಿದ್ರಿ ಅಂತ ಕೇಳಿದ್ನ ನಾನು. ಮತ್ ಆಯ್ತಲ್ವಾ? ಈಗ ಇಲ್ಲೇ ಇರೋದು ನಾವು ಯಾಕೆ ಮಾಡ್ತೀರಿ? ಗಾಯ ಮಾಯ್ತಾ ಇದೆ, ಕಜ್ಜಿ ಮಾಯ್ತಾ ಇದೆ, ಕೆರ್ಕೊಳ್ಬೇಡ್ರಿ, ದೊಡ್ಡದು ಮಾಡ್ಬೇಡ್ರಿ. ಇಬ್ರು, ನೀನು ಅಷ್ಟೇ. ನೀನ್ ಹಂಗಳಿಲ್ಲ, ನಮ್ಮ ಮೌನಿಗೆ ನೀನ್ ಹಂಗ್ ಬೈಲಿಲ್ಲ, ನಮ್ಮ ಮೌನಿಗೆ ಊಟ ಹಾಕ್ಲಿಲ್ಲ, ತಂಗ್ಳ ಹಾಕಿರಿ, ಬಿಟ್ಬಿಡ್ರಿ. ನಾನು ಯಾವತ್ತಾರ ಹೇಳಿದ್ದೀನೇನೋ ನಿಮ್ಮ ಮತ್ತೆ ಬಹಳ ಕಡಿಮೆ ಏನು ಮಿಟಕಾಡಿ, ನೀವು ಬಿಟ್ಬಿಡ್ರಿ. ಈಗ ನಿಮ್ಮ ಕುಟುಂಬದಲ್ಲಿ 5 ಜನರಿದ್ದೀರಿ. ದೇವ್ರಂಗೆ ಒಬ್ರು ತಾಯಿ ಇದ್ದಾರೆ, ಹಿರಿಯರು, 74 ವರ್ಷ ವಯಸ್ಸಿನವ್ರು. ದೇವ್ರು ದೊಡ್ಡವನು, ಅವ್ರು ನಿಮ್ ಜೊತೆಗೆ ಇಟ್ಟಿದ್ದಾನೆ. ಅವ್ರ ಆಶೀರ್ವಾದ, ಅವ್ರ ಸಹಕಾರ, ಅವ್ರದ್ದು ಮಾರ್ಗದರ್ಶನ, ಅವರ ಅನುಭವಗಳು ನಿಮಗೆ ಯಾವತ್ತೂ ಇರುತ್ತೆ. ಆ ಪುಣ್ಯ ಹೆಚ್ಚಿನ ಜನ ಮಾಡಿರಲ್ಲ. ಆ ಪುಣ್ಯ ನಿಮಗಿದೆ. ಮೊಮ್ಮಕ್ಕಳಿಗೆ ಆ ಪುಣ್ಯನ ದಾಟಿಸೋದನ್ನ ಮರಿಬೇಡಿ. ಇಲ್ಲಾರ ಮೊಮ್ಮಕ್ಕಳಿಗೆ ನೀವು ಅವ್ರ ಮೊಮ್ಮಕ್ಕಳನ್ನ, ನಿಮ್ಮ ಮಕ್ಕಳನ್ನ ನೀವು ಸರಿ ನೋಡ್ಲಿಲ್ಲ ಅನ್ನೋ ಪಾಪ ಇನ್ನೂ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಇವತ್ತೇ ಹೋಗ್ರಿ, ಆ ಕೇಸು ಇನ್ನೊಂದು ವಾರದೊಳಗೆ ಮುಗಿದವ್ರ ಹೆಂಡತಿಯಾಗಿ ವಾಪಸ್ ಬರ್ತಾರೆ ನಿಮ್ಮ ಮನೆಗೆ. ಏನೇನ್ ಸಾಮಾನ್ ಬೇಕು ಎಲ್ಲದೂ ತೆಗೆದಿಟ್ಕೊಂಡ್ರಿ. ಅವ್ರು ನೋಡಬಾರ್ದು ಏನಾದ್ರು ಮನೆಯಲ್ಲಿ ಇದ್ರೆ ಅದನ್ನ ಯಾರಿಗೋ ಕಾಣದಂಗೆ ದೂರ ಬಿಸಾಕಿ ಯಾವತ್ತೂ ನಿಮ್ಮ ಹತ್ರ ಸುಳಿಬಾರ್ದು. ಹಂಗೆ ವ್ಯವಸ್ಥೆ ಮಾಡಿ ಮನೆ ನೀಟಾಗಿ ಚೊಕ್ಕವಾಗಿ ಇಟ್ಕೊಳ್ಳಿ. ರಂಗೋಲಿ ಹಾಕಿಡಮ್ಮ, ನಿಮ್ಮ ಅವ್ವ ನಿಮ್ಮ ಮನೆಗೆ ಬರ್ತಾಳೆ. Learned advocate for the petitioner and learned SCGP for the respondent, along with the complainant in the case with her 2 children, with her 2 daughters, among whom elder daughter is said to be living with her father, are all physically present and they are identified by learned counsel from both sides. The submission made by the learned counsel for the petitioner on the previous occasion that the parties may settle the matter amicably was reiterated today. By the inquiry, the court also ascertained from the parties' reactions that though the complainant and her second daughter are ready and willing to reunion, join the accused herein, who is said to be the husband of the complainant and father of their first daughter. However, with some delay, the first daughter also submit that she too is very much willing to have a full-fledged union comprising both the parents and her sister. The accused, who was initially appears to be a little bit reluctant for the alleged reunion. However, in the course of the submission that was being made to the court by the other side, appears to have come to a final decision on his own volition, stating that he too is ready and willing to take back his wife by setting aside of the decree of divorce, which is in force between them. Parties from both sides pray for a week's accommodation to report the settlement, since 2 GNWC cases and 1 maintenance cases, 2 cases for GNWC, 2 cases under GNWC Act, and 1 case for maintenance, and 1 appeal which is said to have been filed seeking enhancement of sentence, 1 criminal appeal, ought to be settled between the parties, which may take a couple of days. In the light of the above, I am of the view that if both parties are decided to have a reunion and to establish a full-fledged family, along with the mother of the petitioner herein, it would be in their best interest. Hence, 10 days time as grade is granted. This the matter on. ಯಾವಾಗ ಬೇಕು ನಿಮ್ಮ ವಕೀಲರು ಯಾರಿದ್ದಾರಮ್ಮ ಕೆಳಗಡೆ ಕೋರ್ಟಲ್ GNWC ಎಲ್ಲ ಆ ವಕೀಲರನ್ನು ಕೂಡ ಈ ವಕೀಲರ ಸಂಪರ್ಕಕ್ಕೆ ನೀವು ತರಬೇಕು. ಈ ವಕೀಲರಿಗೆ ನಿಮ್ಮ ವಕೀಲರ ಫೋನ್ ನಂಬರ್ ಕೊಟ್ಟು ನಿಮ್ಮ ವಕೀಲರು ಏನಾದ್ರು ಒಪ್ಪಿದ್ರೆ ಇವರ ಹತ್ರ ಒಮ್ಮೆ ಭೇಟಿ ಮಾಡಿಸಿ ಅವಾಗ ಅವರು ಎಲ್ಲ ಕೇಸ್ಗಳನ್ನು ವಾಪಸ್ ತಗೊಂಡು ಈ ಕೇಸಿನಲ್ಲಿ ರಾಜಿ ಮಾಡ್ಕೊಳ್ತಾರೆ. ಆ ಕೇಸ್ಗಳನ್ನೆಲ್ಲ ವಾಪಸ್ ತಗೊಂಡು ಈ ಕೇಸ್ನಲ್ಲಿ ರಾಜಿ. In all those withdrawal of the matters, let them make a mention that they are going to, all those cases are being withdrawn with an only on the assurance that both of them would live together and lead a happy married life. With that understanding only, all these cases are being withdrawn. Another 1 sentence says
Yes, sir.
16th, no problem. List the matter on 16/6/2016 at 2:30 p.m. ಆಗ್ಬಹುದೇ ಮಧ್ಯಾಹ್ನ ಅಥವಾ ಬೆಳಗ್ಗೆನೆ ಬೇಕು? 2:30 p.m. ಪಾಠಗಳು ಸಿಗ್ನೇಚರ್ ತಗೊಳ್ಳಿ ಅಷ್ಟು ಜನರು. ಇದರಲ್ಲೆಲ್ಲ ಎಲ್ಲಿ ಪಾಠಗಳು ಪ್ರೆಸೆಂಟ್ ಇರ್ತಾರೆ ಸಿಗ್ನೇಚರ್ ತಗೊಳ್ಬೇಕು, ಹೇಳಿಸ್ಕೊಳ್ಬಾರ್ದು. ಇದು ಯಾವುದು? Yes, next.
Serial number 53. Yes. Somashekar Kashinath.
I appear for the petitioner. I request for time because I got angiography about a week back. I required two weeks time for rest. I got a heart attack. Therefore, I got angiography in Ramaya Hospital yesterday.
When? Yesterday?
Yesterday, I got consulted. 2 weeks.
So,
time.
when was the angiogram done?
Weeks back.
Week back.
Yes.
Let a counsel for the petitioner appearing through video conference prays for a week's accommodation, stating that
2 weeks time. Because I request 2 weeks time.
2 weeks time, stating that last week he has underwent angiogram treatment and he is advised to take rest. Next line. While reminding him that the criminal case is of the year 2007 as such, 15 years old petition. The time has 3 days. 15 years old time. As such, he is required to proceed further in the matter on the next date of hearing.
Yes.
The time as prayed is granted. Reach the matter on 17/6/2022. Yes.
Serial number 54.
Counsel for petition appearing through video conference and fact. Yes.
Serial number 54. Chandra Sarai B. Prasanna Rao.
Please, Your Honor.
Serial number 54. I'm Prasanna Rao, Respondent Counsel, NP Kanesh Gowda.
My lord, see, this matter, there's 2 weeks time, my lord. My senior is not well.
Senior is
Not well.
not well mean what?
My lord, my senior is NP Kalesh Gowda. He's suffering from kind of Alzheimer problem. I have informed to the client. My lord. Taking treatment.
You can proceed with the matter.
Please, Your Honor. Same day only. I filed my memo for posting, my lord. I requested this honorable court for posting on 6th, my lord. Because since the senior is suffering from some ailments, my lord, one date may be fixed, my lord. Please.
No, his senior's argument say he will continue on the next date of hearing.
Please.
And his alleged suffering senior would address his argument through video conference.
Please, please.
No problem.
Sorry to make submission, my lord. My senior is not in a position to make any submission, my lord. The reason is he's taking treatment. That's why I'm
You proceed with the matter.
That I informed to the client that because
You bring your client, probably the client may find out some other alternative.
please, madam, please. That's what I told him.
Let your client say, let your client find some other alternative.
Please, madam.
Sir, you should show urgency in the matter.
Please,
You yourself don't have urgency. It is yours 25 lakh rupees which is being withheld.
Madam.
Still you are not interested.
Yes, madam. He is a blind person, my lord. His contention before the trial court, he never entered to the bank, my lord. Sorry, madam. Which time I can.
Who are the complainant?
My lord, I am an accused, my lord. My lord, I am an accused. Before the trial court, my lord, my specific contention before the trial court is, my lord, I never entered to the bank to withdraw the amount of 25 lakhs. It is a check bearer check ಕೊಟ್ಟಿದ್ದಾರೆ. He is 70% blind ಇದ್ದಾಗ ಈಗ he is 100% blind, my lord. ಆ ಚೆಕ್ ಅನ್ನ ಇವರೇ ತಗೊಂಡು ಹೋಗ್ಬಿಟ್ಟು ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಅಮೌಂಟ್ ತಗೊಂಡ್ಬಂದ್ರು. ಸೊ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಸಮ್ ಥರ್ಡ್ ಪರ್ಸನ್ ಯೂಸ್ ಮಾಡ್ಕೊಂಡು ಆ ಚೆಕ್ ಅನ್ನ ಇವ್ರ ಹತ್ರ ಚೆಕ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಈ ಕೇಸಲ್ಲಿ ಇದು ಮಾಡಿದ್ದಾರೆ. ಇಟ್ ಈಸ್ ದ ಮೇನ್ ಕಂಟೆನ್ಷನ್. He has preferred an appeal before this honorable court also, my lord. The trial court subsequently convicted him.
You are the complainant.
Please, Your Honor.
You want to have the confirmation of the trial court judgment.
Please, Your Honor.
Where you get the more quantum as compensation.
Please, Your Honor. The lower court, my lord, honorable magistrate has granted 35 lakh, my lord. Honorable session court granted 25 lakhs, my lord. Hence, challenge this revision petition, my lord. And subsequently, they have filed one parallel petition, my lord. Challenge the same session court. Order of the session court, my honorable session court order, my lord. 2 weeks time.
The counsel for the petitioner and learned junior counsel for the respondent are physically present. The counsel for the respondent in criminal revision petition and fact number criminal revision petition 1151 of 2018 are physically present. Learned counsel for the respondent citing The alleged ill health of his senior pays for 2 weeks accommodation. Considering the reason, considering the fact that the present petition is of the year, considering the fact that considering the reason shown as a final opportunity, 2 weeks time as spread is granted. List this matter on 17/6.
Great.
Yes. Chaudhary. ಪಾಸ್ವರ್ಡ್ ಆಗಿದೆ, ಅದು ಬಿಟ್ಟು ಇನ್ಯಾವುದಿದೆ ಅದನ್ನ ಕೂಡಿಸಿ.
Number 55, Satyanarayana Chalke.
ಇನ್ನೊಂದು ಕ್ವೆಶ್ಚನ್ ಕೊಡಿ. ಎಷ್ಟು ಪೆಟಿಷನ್ ಇದೆ? 4.
There are four petitions.
$578. ಇಬ್ಬರು ಪಾರ್ಟಿಗಳ ಸಿಗ್ನೇಚರ್, ಅವ್ರ ವಕೀಲರ ಸಿಗ್ನೇಚರ್ ತಗೊಳ್ಳಿ. ಕನ್ಸಲ್ಟ್ ವಕಾಲತ್ತನ್ನು ತೋರಿಸಿ ಯಾವ್ದಾದ್ರು ಒಂದರಲ್ಲಿ. $581 ಕೊಡಿ. 578. Respondent signature period. Five 81. ಎಲ್ಲದರಲ್ಲಿ ಒಂದೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ. The memorandum of settlement is common in all these
Please, madam.
matters.
Please, madam.
Then
Lord,
you
totally.
could have filed only
I should
one
have.
compromise application with one memorandum of settlement, right?
Generally, my lord, as a matter of practice, my lord, in criminal petition, but each petition we are required to make the applications. That is how, my lord, when we used to practice earlier. But that is why, my lord, to be on the benefit, my lord, I have made that as a common application. And what the 147 applications that I have given, my lord, are pertaining to the case file.
147 application is also separate application in each of the matter.
Please, my lord.
Memorandum of settlement is also separate.
My lord, memorandum of of settlement, my lord, I have added all the cases. So that is common in all the cases.
Each of the memorandum of settlement,
My lord, in
you
the
have repeated the
please
pending case numbers, all the
of
pending
all,
cases.
yes, yes. Please. Matter of practice, my lord, that is how we have been doing. Together, my lord, the 4 cases, my lord, the checks are for 5,40,000.
Yes.
And my lord, together, my lord, the fine is 6 lakhs, my lord. Lord, for which, my lord, 3 lakhs, my lord, has been deposited. But 60,000 before the trial court, my lord, but in furtherance of the directions issued by the lower appellate court. And my lord, 2,40,000 have been deposited before this honorable court.
Who is Mala? You identify?
Yes.
You identify. ರಾಜಿ ಮಾಡ್ಕೊಂಡಿದ್ದೀರೇನ್ರಮ್ಮ? ಇಲ್ಲಿಗೆ 4 ಕೇಸ್ ಇದೆ ಈ ಕೋರ್ಟಿನಲ್ಲಿ ಇವತ್ತು ಬಂದಿರೋದು. ಆ 4 ಕೇಸಿನಲ್ಲಿಯೂ ಎದುರುಗಡೆಯವರು ಅರುಣ್ ವಿನ್ಸೆಂಟ್. Who is Arun Vincent? You identify him?
Please.
Yes. ಅವರು ನಿಮ್ ಜೊತೆ ರಾಜಿ ಮಾಡ್ಕೊಂಡಿದ್ದೇನೆ. ನಿಮಗೆ ಕನ್ನಡ ಅನುಕೂಲವ ಇಂಗ್ಲಿಷ್ ಅನುಕೂಲವ? ಇಂಗ್ಲಿಷ್ ಉತ್ತಮ. Yes. 4 petitions are pending before me now. In all these 4 petitions, he has filed an application. He has filed a compromise petition stating that those compromise petitions are also signed by you. It is mentioned in the compromise petition that both of you have settled the matter amicably as per the terms of the memorandum of settlement. By virtue of those settlement, he has sought for his acquittal in this matter. You have agreed for his request for acquittal. You have no objection to acquit him from the case. And what are all the deposits he has made in these 4 cases, whether in the trial court or the first appellate court or this court, you have agreed that the amount deposited by him in the court has to be refunded to him. Has to be refunded to him. Are you agreeable? You are agreeable. How much of amount you have received from him now?
Total 9 lakhs.
6 lakh DD you have already given.
Please, my
Yes,
lord.
3
3
lakh
lakh
DD you have not mentioned in the settlement
I-
that
I
has
have-
already been given.
I have mentioned, my lord.
Where?
Lord, Roman number 2.
Yes.
My lord, the last sentence.
Yes.
The demand draft is, however, handed over to the respondent. My lord, as the validity is of 3 months.
6 lakh have handed over when?
Lord, 6 lakhs now, my lord, she can present it right away, my lord. Lord, with
So
regard,
6 lakh you have not mentioned that has been handed over now.
I'm sorry, my lord, it is not been
No
mentioned.
problem.
It is
I'm not telling that it's a
Please, my lord.
lapse.
My lord, it is somehow missed out.
No,
Yes.
I'm not telling that.
Please, my lord.
I'm rather advising you
Please, my lord.
to give it, submit the same in the court.
Please, my lord.
So the court can record that you have handed over that DD to them.
I would, my lord. I would.
So far as the other 3 lakh is concerned, there is already
I have
mentioning
I have
the
mentioned.
settlement.
Yes. Please, my lord.
But so far as 6 lakh is concerned,
I should have
there is
mentioned.
no such mentioning.
I would mention.
The
I
court
would.
may mention that,
Please, my lord.
provided ಇಸ್ಕೊಳ್ರಿ ಅದು 6 ಲಕ್ಷ ಡಿ ಡಿ 6 ಲಕ್ಷದ ಮಾತ್ರ ಕೊಡಿ ಅಮ್ಮ, 3 ಲಕ್ಷ ಕೊಡಬೇಡಿ. ಜಸ್ಟ್ ಅಲ್ಲೇ ಇಟ್ಟಿರಿ, ಟೇಬಲ್ ಮೇಲೆ ಇಟ್ಟಿರಿ. Your client is yet to pay the grading cost.
I would, my lord. But anyway, Please, my lord. My lord, anyway, my lord, the amount is in deposit, my lord. My lord, after deducting the grading cost, my lord, the remaining amount may be directed to be paid.
I do not know how much amount is in deposit because
About
in
3
none
lakhs.
of your petition you have mentioned as to how much amount is in deposit.
My lord, it is 3 lakhs. My lord, I have mentioned, my lord, at 4. My lord, I have not mentioned individually in each cases. My lord, together, my lord, 3 lakhs is in deposit. 60,000, my lord, at Roman 4 of para 5, my lord, of the memorandum of settlement. Sum of 60,000 deposited before the learned magistrate and 2,40,000 deposited in this honorable court to be released in favor of the petitioner.
God, it is always better if you could able to
My lord,
specifically mention
please, my lord.
in which matter how much so that will avoid lot of time and
Please,
confusion. Order sheet
my lord, in my lord, in criminal revision petition 578, my lord, 15 lakhs were deposited before the trial court. 15,000, I'm sorry. 15,000 before the trial court. And 40,000 before this honorable court. In all, 55,000.
$78. Yes, Mr. Arun Vincent Raj Kumar. You have gone through the memorandum of settlement. You have gone through the joint affidavit. You are agreeable to the terms. Was there any pressure by anybody to enter into a settlement? Did anybody force you to enter into a settlement? You have understood the terms of the settlement. Do you believe that the terms of the settlement are favorable to you and in your best interest?
Yes, my lord.
Yes. Yes, take down. In all these 4 petitions, the present petitioner has challenged the confirmation of his conviction for the offence punishable under section 138 of Negotiable Instrument Act. The judgment of conviction and order on sentence passed by the trial court in all these 4 matters were confirmed by the session judges court in the appeal preferred by the present petitioner, who was the accused in the trial. The respondent herein is the complainant, was the complainant in the trial. No, both parties. No, both parties have come up with settlement in the matter in which regard in all these 4 petitions, they have filed separate applications under section 147 of the Negotiable Instrument Act, read with section 320(6) of the Code of Criminal Procedure, and bearing IS number dash 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 and dash respectively. Next line. Which first sentence. Learned counsel from both sides in all these four matters, along with their respective clients, as identified by them, are physically present in the court. By inquiry, ಬೇಡ ಅಷ್ಟೇ ತಗಲಿ ಆಮೇಲೆ ಮುಂದಿನ ಬರ್ರಿ. The summoned substance of summoned substance ಬೇಡ. All these four applications along with their annexures are identical in all the four matters except identical in their summoned substance. In all the applications, both the parties have filed joint affidavit also. Along with the application, in the memorandum of settlement, filed along with the applications in all the four matters, both the parties have carved out the terms of settlement entered into between them. The summary of which is that the present respondents in all these four matters, by accepting a total sum of rupees 9 lakh payable to her by the present petitioner bracket accused, has agreed for his acquittal from the alleged offences punishable under section 138 of NI Act, and also has agreed for refunding of the deposits said to have been made by the petitioner herein, both in this court as well in the trial. Both parties, the learned counsel from both sides, next line, have made their submission on the lines of the application filed under section 147 NI Act and the memorandum of settlement, and have prayed for accepting the application and permit the compromise as mentioned in the application. The inquiry made with the parties who are present physically also reveals that both the parties have, with their free consent and out of their own volition, without being influenced by undue influence, duress, coercion or misrepresentation, or by mistake, have entered into compromise in their best interest, entered into a compromise on the lines of the terms mentioned in the memorandum of settlement in their best interest. Hence, there is no embargo to deny them the permission to settle the matter. Accordingly, the petitioner, accordingly the present respondent as a complainant who has acknowledged the receipt of a sum of rupees 3 lakh in the form of a demand draft dated 31/5/2022, said to have been given to her by the accused bracket the petitioner herein, now acknowledges DD.
6 lakhs. ಇದು 3 lakhs.
ಆ ಡಿ ಅವ್ರ ಕೈ ಕೊಡಿ, ಲೇಡಿ ಕೈಗೆ. Acknowledges the receipt of another sum of rupees 6 lakhs from the accused bracket petitioner hearing the form of a demand draft bearing in the form of demand draft dated 31/5/2022 drawn in her favor, and acknowledges the receipt of a total sum of rupees 6 plus 3 lakh equals 9 lakh towards the full and final settlement of the agreed terms with respect to the present 4 petitions. In the light of the above, the present 4 petition, she has further agreed that the deposit made, if any, by the present petitioner in these petitions, either in the trial court or in the high court, be released in his favor. The learned counsel for the petitioner, next line. Upon instruction from his client, submits that the grading cost payable by virtue of the judgment in Damodar Prabhu versus so and so reported in so and so would be deducted, which comes to a total sum of rupees 81,000, be deducted from out of the amount deposited by the petitioner herein in this court, and balance of the amount be released to him. The petitioner, who is physically present, also reiterates what submission his learned counsel has made. In the light of the above, all these 4 petitions stands disposed of as settled between the parties amicably. Accordingly, all the IAs so and so stands allowed in part. The matter stands disposed of as settled between the parties amicably, subject to the payment of the grading cost as observed above. The accused stands acquitted of the offence punishable under section 138 of Negotiable Instruments Act. Registry to transmit a copy of this. LCR bandidiyendri? Bandide. Copy of this order to the concerned trial court and session courts respectively, along with their records by the registry without any delay. Signature ತಗೊಂಡಿದ್ರಿ ಎಲ್ರಿಗೂ? Yeah. ಇಡಿ ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡಿರೋದು. ಹಾ, ಬೇಡ ಅದಷ್ಟು. ಆಯ್ತ್ರಿ.
ಸರ್, ಈ 4 ಕೈಗೆ ಬೇಗ ಅರ್ಜೆಂಟ್ ಈಗ ನಂಬರ್ ಸರಿ 4 ಒಟ್ಟಲ್ಲಿ ಹೇಳಿ ಟೋಟಲ್ 9 ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿರೋದು ಇಮಿಡಿಯೇಟ್